Okay, it looks like we're live. Thank you all for coming this morning. And for the record, it's March 1st, 2017. We're in the Kenmore City Council meeting chambers. I'm Phil Albrecht, hearing examiner for the City of Kenmore. We have one big item on the agenda today, which is a site plan application and appeal of a final environmental impact statement for the St. Edwards Park Lodge project, file number CSP 160077. So this hearing is going to be basically divided into two parts, where we'll start off with testimony on the site plan application, and everyone from the public can testify on that. And I'll go through a list I have of people who sign up to speak, and if you didn't sign up to speak, that's fine. When I'm done with the list, I'll ask if anyone else in the audience wants to say something, and you'll have a chance at that point. Once we're done with the public comment on the site plan application, we'll then jump into the appeal of the environmental impact statement. A lot of you have probably heard of what an environmental impact statement is. Everyone calls it the EIS, and that is basically a document that assesses the environmental impacts of a project and also gives the City Council authority to condition the project on impacts that are identified in the final environmental impact statement. So it's an important document. Now, my job is essentially to collect your testimony and all the evidence that's presented to the record today, and then make a recommendation to the City Council, who makes the final decision. And it's very important that you understand that under state law, the council can't consider any new evidence. So if you have information that needs to be considered, make sure it gets into the record before I say the hearing is closed. Once I say the hearing is closed, no new evidence or information is permitted. So, don't miss out on that. I can't reopen the hearing under most circumstances once it's closed, because once I say the hearing is closed, people will leave the room, and if something new comes up, those people that left don't have an opportunity to respond to that new information. So again, once I say we're done with that. We do have a court reporter here who's going to be transcribing your comments, and your comments are also being recorded. The council will have access to both of that information. So everything you say will be there available for the council to consider. It's just that the City Council isn't here today to hear it in person. That's the main difference there. Now, site plan review usually is a pretty dry and I mean, there isn't a whole lot to it, because a typical site plan application simply means that you have to be consistent with all the city's development standards, and that's all that I, as a hearing examiner, can consider is, does it comply with the city's requirements for sidewalk improvements and landscaping, and are there going to be sufficient utilities, and are the water lines going to be in place, and that kind of thing. And so that's excuse me, I've been have a little bit of a lung problem, but that's my primary focus is, I have to basically apply the criteria in the city's code to make a recommendation to the City Council on whether the project should be approved or not. Now, since we do have a final environmental impact statement that's involved here as well, the City Council, when they review this, as I mentioned before, can essentially mitigate environmental impacts of the project. And so that opens the door to, basically any way this project could affect you. If that's something that can be considered an environmental impact statement, the City Council can address it in their exercise of what they call substantive SEPA authority. So I should be able to address most of the comments that you make today during the hearing, and then make recommendations to the council as to how to address that later on. The one thing that is outside of the scope of this site plan application is we're only dealing with this specific project today. Okay, when it comes to the decisions that were made by the State's Parks Commission on what to do with their land, the fact that they should have done something else other than a private use of the lodge facility is beyond the scope of the site plan hearing. All right, we're just dealing with what's proposed, whether or not it complies with city code, and whether or not all the environmental impacts are adequately addressed. That's the scope of this hearing. If you have issues with the decisions that the State's Parks Commission made, maybe that's something to address with the State's Parks Commission, but it's not something that I or the City Council ultimately can address. Now, in the SEPA portion of the hearing, there are some issues about alternative uses of the project, and that deals with the content of the final environmental impact statement, because there is an argument to be made that the State's Parks Commission can use that final environmental impact statement as well. But even though we may be discussing alternatives during the environmental impact statement of the hearing, that still doesn't mean that the City Council or myself have any authority to talk about what other things we can do with the property ultimately. That's not a decision for the city to make. We're just looking at the project here today. Now, and again, I apologize, it's kind of a little bit of a cold here, but I do have, one of the first things I need to do is get all the exhibits into the record. The exhibits are very important because, I think I'm there. As I mentioned before, all the information that I can consider and the council can consider is the evidence that's presented to the record today, and that is essentially your testimony and the documents that are admitted as exhibits. The staff report, which I think all of you have had access to, identified 20 exhibits for starters. And so I'm going to start off simply by asking, does anyone need to see any of the documents that are identified in the staff report or have any objections to the entry of the exhibits 1 through 20 listed in the staff report as part of the record? Okay, hearing no objections to that, then I'll admit exhibits 1 through 20 identified in the staff report. Now, ironically, the staff report list of exhibits doesn't identify the staff report as an exhibit itself. So in order to get that into the record, I'll mark that as exhibit 21. Does anyone have any objections to the staff report being admitted as exhibit 21? Hearing none, that's admitted. Okay, now onward to exhibit 22. This is kind of interesting. As a hearing examiner, I don't have the authority, well, I'm not supposed to, in essence, be talking to anybody outside of the hearing process. This ensures that all the information that's considered, as I said before, is just in the record, and you all know the information that I'm considering and that kind of thing. But the courts are willing to allow procedural communications when we're dealing with things like appeals and that sort of thing. The SEPA appellants in this case, the citizens who have been appealing the environmental impact statement, have put a lot of work into preparing their case, and there have been a lot of motions and things in advance of the hearing on what we can talk about in the SEPA appeal hearing today, and communications about what witnesses are going to be allowed to speak and that kind of thing. And so to that end, under Exhibit 22, I have a series of orders that addresses that motions that were made about who can talk, what issues can we discuss, and that kind of thing. It's A through F. Does anyone need to see those orders or have any objections to their entry in the records? Primarily procedural.
Mr. Examiner, I have a point of clarification.
Yeah.
Our understanding is that the Type 4 site plan hearing is going to be a separate hearing from the SEPA appeal hearing, that you have before you the Type 4 site plan application, and we're here today to have an open record public hearing on that. And then separate from that is the SEPA appeal hearing.
No, the SEPA rules require consolidation of the SEPA appeal with the hearing on the underlying action. The hearing is divided into two parts, but it's considered one hearing. So we're as I mentioned, I mean, the only persons who are allowed to participate in the SEPA portion are the parties to the SEPA appeal, but it is still considered one hearing under the rules, under the SEPA rules. Okay,
but you'll be making a decision on the SEPA appeal, and then on the site plan portion, you'll be making a recommendation to council.
That is, the code is not entirely clear on whether I'm making a recommendation or making the final decision. And Mr. Casaguma, does the city have a position on that? Because the code didn't really address it either way. So,
for the record, Rod Casaguma, City Attorney for the City of Kenmore. Appreciate that the code doesn't specify whether your decision on the SEPA appeal is a recommendation or a final decision, but under case law, as I understand it, and I would ask Ms. DeWeese if she has an opinion on this, your decision on the EIS appeal is the final SEPA decision for city purposes. That decision is a decision that will be considered by the City Council when deciding on the site plan review application.
Okay. Yeah. Since the code didn't directly say, I didn't want to presume that I was making it one way or another. But my final decision will identify, of course, whether it's a recommendation or a final decision. But my recollection is usually is a final decision. That's right. Mr. Casaguma, yeah, go ahead.
I do have a comment also concerning the exhibits for the record. I had anticipated that we would have two sets of exhibits, even though in many circumstances they will be duplicative. One set of exhibits is for the site plan application hearing, and the other set of exhibits is for the SEPA appeal. And I guess my request to the hearing examiner is, if, as you're reading through these exhibits or at the end of it, if you could help specify for us which of the exhibits are clearly part of the SEPA appeal and which other exhibits are, in your opinion, part of the site plan review application, because I was prepared on the city's behalf at the site plan hearing this morning to introduce an exhibit list that the city would like you to consider for the site plan hearing only, and also do the same thing for the EIS appeal.
Well, again, this is one hearing, so that it's all the evidence is kind of mixed together. That's kind of one of the oddities of the requirement for a consolidated hearing is you have one hearing, one record. But I do have separate lists for both. The reason why I'm adding the way I'm setting up the exhibit list is I actually have an exhibit list from the SEPA appellants from the city, for the city as a SEPA party and the applicant and state parks, and they each have their own different numbering system. And once we get to 10 o'clock, which is when I said that the SEPA hearing, the earliest the SEPA hearing would start, I'll address the specific SEPA exhibits. But I'm just adding the core documents here in terms of identifying my ex parte communications with the SEPA parties, and that's why I'm doing those at this time. So. Again, once I get to the SEPA documents, it'll be clear how it's all laid out.
Mr. Examiner,
Yeah.
This is Amit Ranade,
Yeah, sure.
for the record, also with Daniels Real Estate, the applicant. I wanted to answer a question that at least we don't agree that the code is unclear about what is your role here with respect to the SEPA appeal. The Municipal Code 19.30.070B says that your choices are to grant the appeal, deny the appeal, or grant the appeal with conditions, modifications, or restrictions. We just want to be clear that with the SEPA appeal, what you're not sort of empowered to do under the code is send it to the city council with some sort of recommendation. You can either grant it, deny it, or send it back to the city with some instructions on what you think
That's
is
what
inadequate.
it says, but there's also a consolidation provision that provides that once you've consolidated the appeal with the underlying permit action, that it has to be processed as the highest type of permit review process, which is type 4, which is a recommendation of the city council. So,
But that's with the site plan, right? I'm not talking. I agree with you on the site plan.
yeah,
You
but
make
I'm
a
saying if the
recommendation.
appeal is consolidated with the site plan, then the whole thing has to be treated as a type 4. That's how you could construe the consolidation
Okay,
part.
so that's how you're going to interpret it.
No, I'm not. I said I haven't made a decision on whether I'm making a
Okay.
recommendation or a final decision on the EIS. But I'm going to take a look at the case law, and as part of my final decision,
Okay.
I'll address that. So,
Okay.
Thank you.
yeah,
Thank you.
yeah. So
I just
take
wanted
those-
to make one more quick
Sure.
point of clarification. I'm Abby Deweese. I'm one of the attorneys for the
Uh-huh.
applicant. Like the city, we also had thought about putting together an exhibit list just for the site plan portion, just because there are so many fewer documents that are really relevant to the site plan portion, to try and consolidate the documents that were relevant to the site plan
Right.
portion and have
Well, that's
that
what we're
make
doing right
sense.
now. Okay, I'm putting in my SEPA orders and SEPA email communications as part of
Great.
my ex parte communications. But after that, we're just going to address the site plan documents when we get to the SEPA appeal. And I may jump in at 10 o'clock just to sort of take a break from the hearing to do that. We'll address the SEPA exhibits as well. But right now, other than my SEPA orders and just to simplify this, other than my SEPA orders and email communications, we're just dealing with the site plan exhibits right now, and we'll get all that consolidated. So again, Exhibit 22, as I mentioned, I had the 6 orders dealing with SEPA. Anyone need to see those? Anyone have any objections to their entry in the record? Okay, they're admitted. Exhibit 23. And again, and more clarification on this too. This is the core exhibit list, which was used both by the SEPA appeal and the site plan hearing. So that's also why this is all being put together. Exhibit 23 was the EIS appeal. I didn't see that admitted anywhere in the record. So we need to get that in. Exhibit 23. Any objections over that? That's the appeal document filed by the SEPA appellants. Okay, that's in the record as well. Exhibit 24 then is these are the procedural communications I had with the SEPA parties about when the SEPA hearing would be held, and how the procedures would be put together. Any objections over those emails being admitted into the record? Okay, so Exhibit 24 is the email communications between all the parties to the SEPA appeal. All right, now we got those out of the way. We have other site plan documents the parties want to get into the record.
Oh, excuse me. We do have some more
Yeah.
exhibits that we'd like to get into the record. And I believe all of these exhibits, except one, are already identified on our exhibit list for the appeal portion. So they're in the binder in front of you, the smaller binder that we gave you. And so the first one of those exhibits is an audio recording of the January 5th, 2017 State Parks Commission meeting. We received this audio commission from the State Parks through a public records request, and we'd just like this entered into the record because it shows kind of the range of public comment on the proposal, which is relevant to one of the site plan criteria that you need to consider today. So we'd like that entered.
Okay.
Would you like me to explain them one by one and you can rule on them, or how would you
Well,
like
yeah,
them?
let's do them one by one.
Okay,
So any
great.
objections to the audio recording of the January 5th, 2017 Parks Commission meeting? Okay, hearing none, that's admitted as Exhibit 25. All right.
The next applicant's exhibit is a transcript of the January 9th, 2017 Parks Commission meeting. This is the commission meeting where the Parks Commission actually voted on the lease approval with Daniels Real Estate. And we think this is relevant because it shows the Parks Commissioner's feelings on the lease and their statements. And as an agency with jurisdiction here, we think that's relevant to get in the record.
Okay, any objections over the transcript of the January 9th, 2017 Parks Commission meeting? Okay, hearing none, that's admitted as Exhibit 26. Down to Exhibit 27.
Great. The third exhibit we'd like to get in the record is the kind of combined meeting minutes and requested action for the January 5th and January 9th Parks Commission meetings. These exhibits are relevant because it kind of shows the background actions that the Parks Commission was deciding. It also contains some relevant information about the Land and Water Conservation Fund determination by the National Park Service. So we'd like to get that in the record.
Okay, any objections over Exhibit 27 as the Parks Commission special meeting agenda? All right, that's admitted as 27. Exhibit 28.
So we'd like to get into the record the National Register nomination for the Seminary Building and Park area. The building is on the National Register, and the National Register nomination explains a lot of really great background history that we think is relevant for your consideration and the council's consideration.
All right, any objections over the National Register nomination? Okay, that's admitted as Exhibit 28. Finally, note 29.
The last is the city's notice of availability of the EIS addendum. We know that the EIS addendum is already entered into the record as one of the exhibits that went along with the site plan recommendation, but we noticed that the notice itself had not been entered, so we'd like to enter that as well.
All right, any objections over the notice of availability of EIS addendum? All right, hearing none, that's admitted as Exhibit 29 then. Anything else from the applicant?
No.
Okay, and Mr. Casaguma, you said the city had some exhibits?
Yes, Mr. Hearing Examiner. You have to bear with me because I had separate lists for both hearings, but I'll start with several documents that are on the city's website that relate to the site plan application. And these are the Type 4 site plan information sheet that was submitted by the applicant.
Okay, any objections over the Type 4 information sheet coming as Exhibit 30? Okay. And how many exhibits do you have, Mr. Casaguma?
They are 13,
Ooh, okay.
many of which overlap, except for I think one overlap my other list. Now I could
Why don't you just
give them to
run
you.
through-
I can give them, hand it out to you and to the applicant at this time.
Yeah, and then I'll be able to get that in a more brief fashion so that we can get to public testimony. Sorry, we're almost done with the exhibit part, and we'll get to your testimony real soon here. Great, thanks, Mr. Casaguma. Oops. Okay. Okay, let's see here.
Mr. Hearing Examiner, so on the list that I have just delivered to you, we are asking you to admit into the record items 2 through 15. And I'm double checking that none of these were just offered by the applicant.
I don't believe they were run.
Okay. Well, I'm going to real briefly, so 2 through 15, which I'll say is exhibits 30 through 43. And I'll summarize them as follows, that 30 is the type 4 site plan information we already got in. 31 is architectural site plan. 32 is a preliminary civil plan. 33 is the title report. 34 is the lease boundary. 35 is the Washington State Parks Notice of Adoption. 36 is the drainage report. 37, the geotech report. 38, stream and wetland delineation report. 39, habitat assessment. 40, tree inventory. 41, SEPA lead agency agreement. 42, notice of rescheduled hearing date. And 43 is a lease of the park. Any objections over those documents, 30 through 43? All right, hearing none, then exhibits 30 through 43 are admitted as well. All right, any other exhibits need to get in up at front?
And
Okay.
I have one additional one.
Okay.
The St. Edward EIS appeal table. This is a document that was attached to the city's pre-hearing brief in the EIS appeal.
All right, any objections over that? Okay, hearing none, then exhibit 44 is admitted as well. So, question back there? Well, I think the rest of you in the audience, if you have something you want to get in when it's your turn to talk, we'll get it in at that point. So, yeah, I just wanted to get a bunch of them in wholesale up front so we can save some time overall. So, okay, any other exhibits from anybody, party sitting at the table there? All right, then. Now, all the testimony that we take during the hearing has to be taken under oath. So if there's any chance that you might want to say something today, I need you to stand up to be sworn in at this point. And just raise your right hand. Do you swear or affirm to tell the truth and nothing but the truth in this proceeding? I do. Okay, perfect. Now, when it is your opportunity, your chance to speak, you need to get in front of a microphone. And if you're not already sitting at one, we have one for you right there. And just come up, state how to spell your name so I'll get that right in what I write for the city council. Let me know if you've been sworn in or not, and then you can go ahead and make your comments. So with that, we'll move into the staff presentation on what this permit applications are all about. Then after that, the applicants get to make their comments. And then finally, we'll move into the public comments. So with that, I'll move on to the city of Kenmore.
Well, thank you, and good morning, Mr. Hearing Examiner. My name is Brian Hampson. I'm the Development Services Director and the City SEPA official. Today, with me from the city, we also have, go ahead and introduce yourself.
Zach Richardson, Civil Engineer.
Arlene Davis, Senior Planner.
And Rod Casaguma, the City Attorney. Daniels Real Estate filed a Type 4 site plan application on June 30th, 2016 to establish a hotel with an accessory uses for the St. Edward Seminary building project, which is located at the St. Edward State Park. The park is located on between Juanita Drive and Lake Washington, is in the state parks property and owned by State Parks and Recreation Commission. The application is subject to and was processed under Kenmore Municipal Code 18.28.020, 18.105.02A3, 18.105.030B, and 19.25.020A4. As you mentioned, Mr. Hearing Examiner, the process consists of a city manager or designee, which is me, recommendation to you, the hearing examiner, a hearing by you, the hearing examiner, following the receipt of the recommendation. Hearing examiner recommendation to the city council following the hearing and the city council decision based on the record before the hearing examiner. Today's proceeding is the hearing before the hearing examiner, which includes an opportunity for the public to comment on the application. If the application is approved, Daniels Real Estate will rehabilitate the existing deteriorated St. Edward Seminary building at the St. Edward State Park for use as a lodge-type hotel. with up to 100 guest rooms, meeting rooms, conference rooms, including 1,250 to 2,000 square foot portion of which could be used by a nonprofit organization or a public institution. Additionally, it could include administrative spaces, an exercise facility, a wellness spa, restaurant, and a cafe. The project will reuse the historic seminary building and preserve the historic and architectural integrity of the structure by not modifying the exterior of the building and maintaining the interior characteristic of the building as much as possible. On January 9, 2017, the Washington State Parks and Recreation Commission voted unanimously to execute a 62-year lease with Daniels Real Estate. Daniels Real Estate and the state of Washington, through the commission, have executed that lease. As part of the lease, Daniels Real Estate agreed to purchase a 9.7-acre private property that lies adjacent to the park along Lake Washington and transfer ownership of that property to the state parks in exchange for adapted reuse of the building as a lodge. The transferred property will add to the park's acreage and to the park's Lake Washington shoreline. The leased area is roughly 5.5 acres and is located in the central portion of the St. Edwards State Park. It is a pentagon-shaped and encompasses the existing seminary building, swimming pool building, gymnasium, volleyball court, and some surface parking. The seminary building is approximately 80,000 square feet in size. The gymnasium is approximately 14,000 square feet in size. The swimming pool building is approximately 10,000 square feet in size. The leased area is bordered on all sites by the parks property, with the ball field and ball field parking located immediately to the east of the seminary site. The Lake Washington shoreline is located approximately 1,500 feet west of the site, and access to the leased area is off of Juanita Drive via a private drive. The seminary site is mostly surrounded by forest, streams, and wetlands to the north and to the east. Areas surrounding the park property are predominantly residential. Daniels Real Estate does not propose any changes to the gymnasium or the pool building at this time. The proposed project would provide on-site parking for lodge guests and staff within a structured below-ground parking garage and surface parking located to the north of the gymnasium in an existing lot. Existing surface parking areas in the vicinity of the seminary building would be improved for park users, including a resurfaced and restriped surface parking area east of the seminary building and pool. An expanded surface parking area to the northeast of the gymnasium will be provided. No net loss of parking for the general public would occur, and no changes would occur to the site access. To explain the application request a little bit further, the site is zoned parks. The proposed hotel use is classified in the zoning code, but it's not designated as a permitted, conditionally permitted, or prohibited use in the parks zone use allowance table. Therefore, pursuant to the Kenmore Municipal Code, projects in the parks zone shall undergo a site plan review for purposes of establishing a classification or activity that is not otherwise established and permitted and prohibited or listed in the use allowance table. The application exceeded the categorical exemption of the SEPA State Environmental Policy Act and therefore is subject to SEPA review. The city and state parks entered into a SEPA lead agency agreement for the application and the proposed project. The city was designated the nominal lead agency, and as the nominal lead agency, the city's SEPA ordinance and process had been applied to the application. A SEPA determination of significance combined with the notice of application was issued with the request for a scoping comments on the environmental impact statement. The SEPA determination of significance was mailed to the SEPA agencies. The environmental impact statement scoping comment period ended on August 5th, 2016. Comments received were used to help define the draft environmental impact statement. A draft environmental impact statement was issued for review and comment to the public and SEPA agencies on October 14th, 2016. A final environmental impact statement was issued on December 16th, 2016. Comments received were addressed in Section 3 of the final environmental impact statement. On December 30th, 2016, a final environmental impact statement addendum was issued to respond to a comment on the draft environmental impact statement that was inadvertently omitted from the final impact statement. The city also extended the appeal period for an additional 14 days from the original deadline on January 6, 2017 to January 20th, 2017. And all persons on the city's environmental impact statement notice were sent notices of the extended appeal period. An environmental impact statement was prepared pursuant to RCW 43.21C.0302C to evaluate the environmental impacts of the proposed project. The environmental impact statement comprised of the draft environmental impact statement, the final environmental impact statement, and the addendum. These were all prepared in a manner using appropriate methodology and adequately analyzed the probable significant adverse environmental impacts of the project. Okay. With that, I'm going to turn it over to Eileen and Zach Richardsons to continue on.
Oh, we're moving on to the applicant presentation at this point?
No, this is
I
Eileen,
see.
our
Okay, got it.
planner.
All right.
Good morning. I'm going to discuss the milestones of the project so far, starting with the application and ending with the issuance or the end of the comment period for the final
Okay.
EIS.
And let me clarify for the record real quick, Mr. Hampson was sworn in. And Eileen, what was your last name again?
Davis.
Davis, I saw you were sworn in as well. And,
Yes.
and don't forget, speakers, the first time you speak, make sure you let me know if you've been sworn in or not, so we have that for the
Okay.
record. Okay, great.
And
Thanks. Go
please,
ahead.
if you're reading from something, everyone reads faster than they speak, so try to slow down a little bit so I can get every word.
Okay. So my name is Eileen Davis. I'm a senior planner. I am going to discuss the technical, like I said, the project milestones for the project thus far, the comprehensive plan compliance issues, and then I'll go through the technical aspects based on what the staff report. It's just a summary, really, of what's in the staff report with a little bit of clarification.
Please speak a little more into your mic. Thank you.
Better?
Yes.
Before she continues, Mr. Examiner, I may have some questions to ask her as she's progressing through her presentation. Would it be all right to ask her questions along the way?
Yes, that's perfectly
Thank
fine.
you.
Thank you.
So the milestones for the project thus far, land use application submitted on June 30th, 2016. Application determined complete on July 6, 2016. That's based on a submittal of a complete application form, required supporting information, and any additional information that was requested by the city. The EIS scope defined by the agency review and public comment period. There was a review agency, as Brian said, the whole DS scoping comments for the EIS. The EIS scoping information session notification issued on July 12th. An EIS scoping information session held on July 26, 2016. A notice of public hearing, a notice of availability and DEIS issued on October 14, 2016. A public meeting held on November 10, 2016. Public comment period for the DIS extended on 11/14/2016. Lost my place. End of the DEIS public comment period on 11/18/2016. Final EIS issued on 12/16/2016. Addendum issued, comment period extended, as Brian stated. FEIS appealed on 1/20, end of FEIS comment period 1/20/2017. The comprehensive plan requirements and how the project complies with the city's comprehensive plan. I would like to keep it brief, but I don't know if I'll be able to. Land use policy. I'm going to start at the beginning. Land use policy 1.1.1, encourage development within Kenmore that creates and supports a healthy and diverse community. Kenmore should contain employment opportunities and protect the natural environment and significant cultural resources. This project will further this policy by providing employment opportunities, preserving the historic seminary building, and protecting the natural environment by repurposing an existing structure. Objective Land Use 1.4, create a climate that fosters business creation and retention that positively contributes to the city's quality of life. The project will locate a new business in Kenmore and provide a restaurant and social opportunities for residents. The project will positively contribute to the quality of life in Kenmore in this way. Policy Land Use number 1.4.2, ensure zoning regulations accommodate a range of allowable business and commercial uses in appropriate locations at the neighborhood, community, and regional levels. The park zone provides a process to establish classified land uses not otherwise established as permitted in the park zone through site plan review. That's the Type 4 process that Mr. Hampson described. The project and the site plan review process meet this policy by ensuring a wide range of appropriate uses may be considered. Objective Land Use 2.5. Encourage development on properties with existing or planned public services and utilities. The project will be located within the existing seminary structure, which has existing services and utility connections that will be upgraded as necessary to meet codes, safety. Policy Land Use 2.5.1, encourage innovative quality development and redevelopment through a variety of regulatory incentive and program strategies. Possible approaches include possible development standards for infill or redevelopment sites. This project meets this policy because it is a quality redevelopment of the existing seminary building, which has significant deferred maintenance needs. Objective Land Use 3.2, promote the preservation of significant historic and archaeological uses, sites, and structures. The project meets this objective because it will preserve and adaptively reuse the naturally restored historic seminary building. Policy Land Use 3.2.2, encourage land uses and development that retain and enhance significant historic and archaeological resources and sustain historic community character. The project meets this policy because the historic fabric of the seminary will be retained to the extent possible. Additionally, the use of the seminary building will be enhanced because it will be open to the public for the first time in many years. Policy Land Use 12.1.3, encourage private reinvestment in residential and commercial areas by investigating mechanisms that support historic residential and commercial sites or neighborhoods. The project is an example of private reinvestment in a historic site consistent with this policy. There are also sub-elements that I probably don't need to go into. There's a natural environment sub-element policy, LU 13.3.2, require appropriate illumination levels and light shields and direction for lighting standards along streets and in public open spaces and parks. The project proposes careful lighting design that is appropriate for its location within the park consistent with this policy. Economic Development Sub-Element Policy LU 25.2, create a climate that fosters business creation and retention, positively contributing to the city's quality of life. The construction phase of this project will employ more local labor than a typical new building, since historic rehabilitation projects are much more labor intensive, thereby increasing local employment. The project also represents a new business that will be located in Kenmore consistent with this policy. I'm going to move on to the applicable code requirements for the proposal. The environmental and critical areas, the city reviewed the watershed reports prepared for this project and concluded the project is in compliance with the Kenmore Municipal Code. There are no listed species within or critical areas with 300 feet of the project area, therefore there would be no impacts. The geotechnical report was also reviewed by the city, and the city concluded that the project would have no impact on the nearest geological hazard, which is located about 500 feet off-site. The park zone and general development, Park zone and general development standards Kenmore Municipal Code 18.28 and Kenmore Municipal Code 1830. The site is zoned parks, as Mr. Hampson described earlier. The proposed lodge at St. Edward is classified as a hotel pursuant to the zoning code definition in 1820. And it could include, among other facilities, a central kitchen, dining room, and accessory shops and services catering to the general public. Meeting rooms, exercise facilities, and spas are considered allowed accessory uses to the primary hotel use. Depending on the organization involved, use of space in the building by a nonprofit organization would be considered an allowed accessory use to the hotel. An allowed accessory use to the established park use of the state park or a cultural facility are all permitted uses per 1828.020, Table A. The design requirements for the specific uses. Compliance with applicable design standards have been reviewed based on the scope of the alterations to the existing site and building. The application meets the applicable design standards based on Kenmore Municipal Code 1850.010 for the reuse of historic seminary building, Kenmore Municipal Code 1850.180. The application will encourage the adaptive reuse of an existing historic process resource that will continue to serve the community. Reuse of facilities standards for conversion of historic buildings 1850.220 in order to ensure that significant features of the property are protected pursuant to Chapter KMC 2.2. The city concluded that the application complies with the applicable standards and design requirements for specific uses based on the county's code requirements. Next up, we're going to discuss surface water and road standards. I'm going to turn that over to Zach.
Good evening. I'm Zach Richardson, civil engineer with the City of Kenmore. I have sworn in. And just for my qualifications, I am a licensed PE with over 10 years of experience and 6 years of doing development review for the City of Kenmore. So starting with surface water, the site plan approval has been recommended with a condition of approval to comply with KMC 1335 prior to issuance of the engineering permit, which would authorize site work to begin at the site. Kenmore, consistent with its MPDS permit with the Department of Ecology, requires that the project comply with the 2009 King County Surface Water Design Manual as amended in KMC 1335. The project will require flow control or detention to mitigate for additional impervious surfaces and water quality treatment to mitigate for runoff from polluted surfaces such as roads and parking lots. The final mitigation requirements will depend on the final configuration of impervious surfaces on the site and is why it's typically deferred till we get into a more detailed design. It's my opinion that the project will be able to comply with 1335 given adequate engineering design, and it has been conditioned to do so. Jumping into transportation, and in this section I'll reference a Heffron traffic report, which is actually exhibit number 14, I believe. The project is required to comply with KMC 1250 and KMC 1280 for transportation impacts and KMC 1840 for parking impacts. KMC 1250 adopts the 2016 City of Kenmore road standards. Under these standards, the project qualifies as an adaptive reuse site, which is exempt from frontage and access road improvements, provided that safe site access is shown. The Heffron report, which was submitted by the applicant, demonstrates that the signal at the intersection of Juanita Drive and Northeast 145th Street will continue to function at a level of service which meets the city standard, and that safe site access is provided. Accordingly, the project has demonstrated compliance with KMC 1250. The report also includes an independent fee assessment as permitted in KMC 1247 and has been conditioned to pay traffic impact fees based on the mobility units generated by the project. The mobility units available at this time exceed the bank of mobility units at the city exceeds those expected to be generated by the project, and therefore no further mitigation is required, and the project has satisfied KMC 1280. The Hefferon Traffic Report also includes a parking impact analysis as permitted in KMC 1840-030, Section B. The typical parking requirement per 1840-030 is 1 stall per bedroom for a hotel. Given 100 rooms, this project would typically generate a minimum parking requirement of only 100 stalls. The report, however, finds that the project would be best served by exceeding the code minimums and actually provides 153 stalls, which is anticipated to meet full capacity parking demands. The project has been conditioned to provide this number of parking stalls in addition to maintaining the total number of park stalls available for park users. This has also been built into their lease with state parks. The project has also been conditioned to provide bicycle parking consistent with KMC 1840-030 Section E, and to improve the existing pedestrian entrance trail to current ADA standards. With these conditions, the project will satisfy the requirements of KMC 1840 and all of the transportation requirements.
Thanks, Ed. Okay, so we're going to move on to utilities. Eileen Davis, Senior Planner. We're going to move on to utilities. We have an approval letter from North Shore Fire District, stating that there's adequate, hang on.
Is that in the record, or are you submitting that for the record? Or?
The part of the record, as part of the record, are the notice, the certificates of availability from North Shore Utility Water and North Shore for Water and Sewer. Trying to find those. At least I think that way. Yeah. The water availability, thank you, is Exhibit 15. The sewer availability is Exhibit 16. Let's see if I can find that.
If I could clarify the record, that's Exhibits 15 and 16, the core documents attached to the recommendation.
Mm-hmm. Got it. Thank you.
And just to clarify further, the fire department recommendation is also contained in Exhibit 17, the North Shore Utility District review
That's
letter.
the other one I was
There it
wondering
is.
about. Okay.
Thank you. I found it. So then we're going to have so to conclude everything, we're going to have a conformity discussion, how the project, just in summary, conforms with all the codes and requirements. So I think... So the proposed use is a hotel with other uses as accessories. The conformity with adopted city and state rules and regulations in effect on the date the complete application was filed. The park standards apply, expected to be met. Sorry.
Please slow down and speak up.
Yeah. Sorry, thank you, yes. Okay, so the proposed use is a temporary lodging and associated accessory uses. Temporary lodging use is defined in the Kenmore Municipal Code as a hotel, motel, bed and breakfast guest house or other facility providing temporary accommodations for travelers for compensation. And then the project will meet all applicable adopted city and state rules and regulations. The applicable rules and regulations generally include but are not limited to the following categories: the zoning code, the State Environmental Policy Act, the Surface Water Control, Surface Water Design Manual, Water and Sewer regulations, the road standards, traffic and parking regulations, fire protection and emergency access regulations. The project site is a portion of the St. Edward State Park, which is a Washington State Park within the jurisdiction of the Washington State Parks and Recreation Commission. The project will only move forward with the support, recommendation, and authorization of the Commission. The recommendations and comments of interested parties will be considered during the site plan review process. Compatibility with the character and appearance of the existing proposed development. The project is compatible with the character and appearance of the existing and proposed development in the vicinity. The project is proposed to be located in the Seminary, a historic building listed on the Washington Historic Register and the National Register of Historic Places. The project proposed temporary lodging use is generally consistent with the historic use of the building for overnight lodging of Catholic seminary students. The project will maintain its historic character and appearance of the seminary, while at the same time making necessary updates and alterations. The project site is located on 316-acre public park. The project will not locate any uses or intrude into the public open space, trails, or other park areas located outside the project site. Also located nearby the seminary is the 51-acre Bastyr University campus, which is surrounded by the St. Edward State Park. The project use is expected to be compatible with and complement Bastyr's use. There may be opportunities for collaboration between Bastyr's nutrition and culinary arts program and the project's restaurant. Although the project will share an access road with Bastyr, it is not expected that any traffic generated by the project will impact Bastyr's operations. Traffic impacts of the project will be studied in the environmental review process. Lastly, the City of Kenmore is proposing potential improvements to an expansion of the existing ballparks in the park. The project is expected to be compatible with the additional ball field use, as the uses will not share parking facilities, and the ball field use will be primarily limited to daylight hours. We've already discussed the conformity with the comprehensive plan, so with that, I'll turn back over to Brian for his conclusion.
Ms. Davis, I have a few questions for you. With respect to your last comments, I to understand that you were summarizing the aspects of this application that meet Kenmore Municipal Code 18-105-050. Is that what you were doing?
I was basically summarizing the staff report, but yes, to discuss how it's in compliance with the review process and the city's other codes, yes.
I think it'd be helpful for all of us if do you have a copy of the code at your table there?
Yep.
Could you please turn to 18-105-050A and read that section? I'm asking you to do this because those are the general overriding criteria, and I want the record to be clear that those criteria have been considered by the staff in making the recommendation, because that section is not referenced in the report.
I was going to ask you exactly the same question. I wasn't sure why that wasn't in the staff report. The criteria is the most important part of the analysis of the application. And so to clarify for the audience, the criteria that Mr. Kasaguma is addressing, those are the criteria I have to assess in terms of making a recommendation of the City Council. So if you can align your comments to be, address those criteria, that'd be most persuasive. You don't have to, but that certainly helps. So anyway, go ahead, Mr. Kasaguma.
So if you could just maybe not so fast that the court reporter can't take it down, but to read that section, because I think it helps put into context everything you've said before that.
Repeat the section you wanted to hear.
18-105-050A.
05008. The city manager may approve, deny, or approve with conditions an application for a site plan review. The decision shall be based on the following approval criteria: conformity with adopted city and state rules and regulations in effect on the date the complete application was filed, consideration of the recommendations or comments of interested parties and those agencies having pertinent expertise or jurisdiction consistent with the requirement of this title, compatibility with the character and appearance of existing or proposed development in the vicinity of the subject property, compatibility with plans for existing and proposed pedestrian and vehicular traffic in the vicinity of the subject property, and conformity with the city's comprehensive plan.
Thank you. And so am I to understand that what you said when you spoke is that, in your opinion, these 5 criteria have been met by the application?
Yes.
Thank you. I have a few questions concerning Section 5A of the revised recommendation, and this relates to the classification which is being approved by this application of hotel as well as accessory uses. Do you have that section open?
Of the staff report?
Of the staff report, right. Mm-hmm. And you touched on it briefly, and I wanted to ask you a few questions and have you elaborate a little bit. So it's my understanding that the applicant has applied for the hotel classified use. Is that correct?
Yes.
And is that the reason why the hotel use is being discussed here?
Yes.
Now, you didn't comment on this, but is there a definition of hotel in the Kenmore Municipal Code?
Yes.
Do you have that with you, and could you read that, please?
1375 defines a hotel as a building or portion thereof designed or used for transient rental for sleeping purposes. Hotel structures are at least 2 stories in height with lodging space above the first floor. Lodging space may also be located on the first floor. Individual rooms are typically accessed from a common hallway. A central kitchen and dining room and accessory shops and services catering to the general public may be provided. Not included in this definition are townhouses, apartments, bed and breakfasts, or motels.
And does this application meet the definition of hotel you just read?
Yes.
I'd like to turn your attention to Kenmore Municipal Code 1828030. Do you have that?
Yes.
Could you please read the title of that section and then tell us what it says?
1828030, Parks Zone Accessory Uses. Accessory uses, when consistent with definitions and criteria in Chapters 1810 and 1820 of the Kenmore Municipal Code, are allowed as determined by the city manager.
So are you familiar with Chapters 1810 and 1820 of the Code?
Moderately.
I'm sorry?
Just a moment. Yes.
And so are the uses that are in the application for this rehabilitated hotel consistent with those 2 chapters, 1810 and 1820?
Yes.
And therefore, is the staff recommending that the accessory uses that go with the hotel use should be determined by the city manager to be accessory uses under this section?
Yes.
Mr. Hearing Examiner, I'm going to ask Ms. Davis a question about one of the written comments that has been filed prior to the city's deadline at 5 o'clock yesterday.
Oh, okay.
I'm wondering if Mr. Hearing Examiner has a copy of those comments.
I'm glad you raised that because, yes, we did. I haven't admitted those into the record yet and should do that. Let me get out my exhibit list. Okay, so we have since, essentially, I think this is a collection of letters we've received since about February 21st, 2017. I got letters from Andrew and Sarah Zeller, a letter from Mary, or email from Mary Dre, a letter email from Jenny Scalo, letters from Jennifer Mortensen from the Washington Trust for Historic Preservation, a letter from Charles Powell, a letter from Phyllis Finley, and a letter from Rebecca Hurt. There are 7 letters altogether, which I'm going to designate as Exhibit 45 public comment letters. Does anyone need to see those or have any objections to their entry in the record? Okay, hearing none, then those 7 letters will be admitted as Exhibit 45. Yes, that would be Mr. Powell from Bastyr University.
I'm sorry. Ms. Davis, it's my understanding that one of the comment letters argues that the use for this application should be a convention center use and not a hotel use.
Correct.
Have you heard about that?
Yes.
Is there a definition of convention center use in the Kenmore Municipal Code? Excuse me, I should have said conference center.
Pardon me?
Is there a definition of conference center in the code?
Yes. 182560.
Could you please read that?
Conference center means an establishment developed primarily as a meeting facility, including only facilities for recreation, overnight lodging, and related activities provided for conference participants.
Have you had an opportunity to review the description of the seminary building in the environmental impact statement that shows the proposed rooms by levels?
Yes.
And for Mr. Hearing Examiner, could you describe for him and for us what pages you're looking at?
I'm looking at figures 2.5, 2.6, and 2.7.
What do they show generally?
They show the floor plans for the proposed seminary building. They show the basement floor, the first floor, second floor, third floor, fourth floor, proposed layout for the seminary building.
And generally, what is shown on the third and fourth floors?
The third floor shows primarily sleeping quarters, lodging.
Is that also true for the third?
That is also true for the fourth floor.
So what's the exhibit number of this again?
I'm looking at exhibits, or figures 2.8 and 2.9 in the final EIS.
Oh, the final EIS. Okay, thank you.
A correction for the record, that's the draft EIS, the very voluminous document with lots of attachments. I guess I'll get right to the point. Could you please describe for the hearing examiner the floors that have meeting rooms and describe the size of those meeting rooms and the location of those meeting rooms?
There are meeting rooms on the first floor of the proposed floor plan. That's figure 2.6 of the EIS. The meeting rooms in total look to be about 4,400 square feet in total. The largest meeting room is 1,357 square feet.
Okay, and that translates to an approximately what dimension?
That's not really provided. Maybe 30 feet by
I might be able to help out, Rod. It looks like about 20 feet. The largest room is about 20 feet by, I'd say, 50 feet.
Thank you.
Thank you,
That's
Mr. Hampson.
Brian Hampson for the record.
And given the fact that the largest meeting room on the diagram is about 20 by 50, roughly 20 by 50, in your opinion, is that room large enough to hold a large general session, like a opening session of a conference, a dinner of all the conference attendees, a large lunch of all attendees? Is that a typical size of what I would call a ballroom or a large meeting or session room for a conference?
No, not for a large conference. No.
Would it be fair to say that the size of those meeting rooms are for small groups of people who happen to be staying at the hotel or come from off the site and gather during the day to have small meetings?
In my opinion, yes.
Would you call that a conference?
I would call it a meeting.
I have nothing further. Thank you.
So with that, in conclusion, in accordance with my recommendation as designee of the city manager and as set forth in the revised recommended approval with conditions to the hearing examiner report dated February 8th, 2017, file number CSP 16-0077. I recommend approval of the application. I also recommend that the hearing examiner concur with the recommendation and also recommend approval of the application to the hearing, or excuse me, to the City Council, subject to the conditions of approval outlined in the revised recommended approval.
Okay, thanks, Mr. Hampson. All right, at this point, we're going to move on then to applicant and then property owner presentations, and then after that, we'll take a short break, and then finally, we'll get to public comments, and I'm anticipating we'll probably take the lunch break at about 12:30 to split the day in half, because we'll go until at least 5 o'clock today. So with that, move on then to Daniels Real Estate.
Thank you, Mr. Hearing Examiner. Before we get into our presentation, I'm wondering if you'll allow me to ask a few clarifying questions of the
Okay.
city folks.
All right, go ahead.
So I'll get into those. So the first question is with regard to nonconformities. And so Brian or Elaine, could you tell me who would be the best person between you two to answer that? Are you familiar with the nonconformity section of the code? It is, for your reference, 18.100.060 and .070.
And could you please speak into your mic?
Sure.
Particularly when you turn
Sorry.
away from me.
Sorry.
Dawn,
Is that
just for the
better?
record, just let us know who's speaking. To.
Oh, and this is Abby DeWeese with the applicant.
Thank you.
Can you give me those numbers again?
Sure. It's 18.100.060 and 18.100.070.
Eileen, if you would like me to help and
yeah, I
answer
was
this, I
just
could do
gonna
that.
ask
So this
if
is
you
Brian Hampson.
Great, Brian. I'll answer, or I'll ask you this question. So my understanding is that the city's code at 18.100.060 and .070 allows for existing nonconformities in buildings to continue and to expand under certain circumstances. Do you think that this section could be applicable to this project if there was an existing nonconformity in the building, say, as to height?
To height?
Yes.
Yes.
Okay. That's all I would like to clarify there. With regard to the traffic and parking, Zach, I have a question for you. You mentioned in your earlier testimony that there was enough mobility units to exceed what was in the city's bank of mobility units. When you say that there's enough to kind of fit within that, does that go to your concurrency determination?
Yeah, correct. The mobility units tie into the city's concurrency program. Basically, what the city has done is looked at the transportation network as a whole and figured out how development will impact that over time, and assessed a cost to what the development is going to be coming through. So up to a certain point, we can keep handling development with just traffic impact fees, and that's what we call our bank of mobility units available. The project won't generate enough to exceed what's available currently, so they're meeting the concurrency requirements just by paying the traffic impact fees. There's not actually a requirement to do physical improvements, and that's actually the way we get mobility units back into the system is through the city's capital projects. As we expand lanes, as we add sidewalks, it starts to add back mobility units. So the traffic impact fees are used to start addressing those mobility units and increasing those back into the system.
Thank you. That's much more clear to me. I have one more question for you regarding how the minimum parking requirements are calculated. We've heard today that the city considers the use primarily a hotel use with some accessory uses contained within that. Would it ever be appropriate, based on your understanding of how the city's code works, to calculate the minimum parking requirements based on the primary use for the building, but also the accessory uses to add on to that primary use minimum?
No, typically parking impacts are based on the primary use, and in fact, in the the ITE manual, which is the standard tool we use for engineering traffic and parking generations, the definition of a hotel is very similar to that of the cities, and it reads, hotels are places of lodging that provide sleeping accommodation and supporting facilities such as restaurants, cocktail lounges, meeting and banquet rooms, or convention facilities. And so, in fact, the hotel definition in the traffic and parking generation models includes all of the accessory uses.
Great, thank you for clarifying. And I actually have one more question for you. I understand the city has a number of neighborhood transportation programs based on the different neighborhoods around the city. Does the St. Edward State Park area neighborhood have such a neighborhood transportation program?
For the areas surrounding it, such as Arrowhead, yes. However, there's nothing for the internal to the site. It's a private property management concern to manage that. So there's no city program for working on 145th.
Great, thank you. Those are all my clarifying questions for the city. So as you heard earlier, Mr. Hearing Examiner, we're here today to build the record on the criteria in the code that you must consider in making your recommendation to the City Council. And just for the benefit of everyone sitting behind me, I'm going to say what those criteria are, and then we have a couple of witnesses to call up to talk about the project and talk about conformity with those criteria. So there's 5 criteria. They're contained in Section 18.105.050 in the city's code. The first criteria is conformity with city and state codes. I'm paraphrasing. The second criteria is the consideration of the recommendations and comments of interested parties and agencies with jurisdiction. The third criteria is compatibility with the character and appearance of the existing or proposed development. The fourth criteria is compatibility with plans for existing and proposed pedestrian and car traffic corridors. And the fifth criteria is conformity with the comprehensive plan. As you heard earlier, the city recommended approval of the site plan based on those criteria and has provided a very thorough analysis in their written recommendations. So we're just going to supplement some points that we think are really important. So without further ado, I'd like to call our first witness, Mr. Kevin Daniels of Daniels Real Estate.
Yes, right there. Sir, have you been sworn in? I haven't. Okay, great.
Good morning, Mr. Daniels. Will you please introduce yourself?
Good morning, everyone. My name is Kevin Daniels.
Kevin, I think you have to press up.
How's that?
That's better.
Okay. Now it's working? Oh, yeah. Sorry. My name is Kevin Daniels. I'm the founder, majority owner, and also the president of Daniels Real Estate.
Thanks. And does Daniels Real Estate have a special focus or specialty?
We have, over the years, we kind of focus on adaptive reuse of landmark structures and also community development projects that are associated with them.
Can you describe a couple of your projects for me?
Yeah. Here's some of the more familiar ones that people would probably have visited or have seen in the Seattle area, which is where we do all of our focus. So Starbucks Center, it's probably the largest historic building in the Pacific Northwest. Is over 2 million square feet. We bought it in 1990. It's adaptive reuse, converting a warehouse into what is now Starbucks corporate headquarters. Merrill Place in Pioneer Square, it's a full city block that we converted into the headquarters for Cray Computers, the supercomputers. So it went from Class B office space into Class A office space. My most favorite one is probably Union Station. We did that along with adding about 1.1 million square feet of office space behind it. The Cadillac Hotel building in Pioneer Square, which we worked with Historic Seattle on in the National Park Service to save, and now it's the National Park, the Klondike Gold Rush National Park in Seattle. Stadium Place, most people who've gone to a Seahawks game have seen it in the north parking lot. That's I believe, the largest transit-oriented development in the Pacific Northwest, about 1.2 million square feet, and it's just getting completed now. A project underway now is Gridiron. It is a contributing building in the Pioneer Square Historic District, which is the first historic district in America. It is going to bring necessary for-sale housing into the square, so I'm quite proud of that. First time in over 30 years. And we saved the building from demolition. The remodel of the Frye Art Museum was another one, which I think we've created a really jewel, one of the best private art museums in the United States. Currently, I'm working on the First United Methodist Church. You know, that was now it's been over 30-year battle to try to save that church downtown, and hopefully by the end of the summer, it'll reopen. Just to make sure I don't miss any of the more major ones, right now I'm working on the Pratt Fine Arts Center, which we're redoing their corporate campus and creating a more enlivening thing for the arts community. And then obviously what we want to do at the Lodge at St. Edward Park.
Great. So you definitely have a lot of experience with historic preservation projects. Do you have any personal interest in historic preservation?
Quite a bit. So I grew up in a small Union Pacific town in Idaho.
Please,
Sorry, too
I
fast?
want you to slow down and speak into the mic.
Okay. So I grew up in this small town in Idaho around trains. My family had moved west working for Union Pacific. But I really became hooked on preservation when we redid Union Station in Seattle. That was just a magnificent thing. And then we donated it on to Sound Transit, which is their headquarters now. Until recently, I was on the Board of Trustees for the National Trust for Historic Preservation. It was formed, I believe, in 1949 by Congress to protect the United States historic built environment. I termed out, so now I was just elected a trustee emeritus, which means I don't have the same responsibilities, but I still get to go to all the meetings, which are really fun. And I serve with a lot of great people across the country. And I'm also on the board of directors at the National Trust Community Investment Corporation and the National Main Street Center. Both are subsidiaries of the National Trust. And recently was the founder and co-chair of the Alliance for Pioneer Square, which has been working to rehabilitate and regenerate Pioneer Square.
Great. And does that just general interest in historic preservation bring you to wanting to do this project with the Lodge? How did you hear about the opportunity that might?
Well, I have a personal connection from 30-some years ago, and then the current connection. So 32 years ago, almost 33, I was married at St. John Vianney Chapel.
At what chapel?
St. John Vianney and St. Thomas Seminary, which is now known as Bastyr University. And I held our reception dinner in the Great Lawn in front of St. Edward's Park. So that was my first and only touch in St. Edward's Park until I was brought in by Bastyr like in mid-2014 to look at their expansion plans.
And those expansion plans were for the seminary but never materialized?
That is correct. We worked with them for, I would guess, nearly a year doing plans, and their idea was to use the facility as it used to be used for education and dorms, eating facilities like that. But for a variety of reasons, they decided not to proceed.
But you obviously saw the opportunity. Could you tell me about some of your goals for the Lodge project?
Sure. Once I was very disappointed when they made that decision, and the building kept gnawing at me. And so probably about 3 to 4 months later, the state parks RFP was still out there, and I looked to see if anybody had made any propositions or any proposals on what they would do with the building. And seeing none, we started, and I have a full team around me, we started looking at a variety of different options that we could find, and we felt that this one was the most appropriate use of that facility, and probably from an economic standpoint, it could justify the number of dollars it'll take to adaptively reuse that building.
Great, thank you. So this is the site plan hearing for the Lodge project. It's just one of many permits and entitlements you'll need. Do you intend to go and get all of those permits and entitlements as required by law?
Yes, just like we've done on every other project we've worked on.
Great, thank you. So now I want to turn to the lease that you signed with State Parks, just to touch on a couple of relevant provisions of that. And the lease is, for the record, to clarify, already entered as Exhibit 43. And if you'd like to have it in front of you, in the biggest black binder called Site Plan Hearing Exhibit Binder, it is under tab B, number 15. At the very back.
All right.
Great. So just to begin things off, did you sign a lease with State Parks, and does this appear to be the lease that you signed?
Yes, this is the lease that we signed.
Great. Can you just give me a high-level overview of what that lease allows you to do in the park?
It covers about 5.5 acres, and in that general area, it allows us to operate the proposed lodge facility in there. It includes 3 buildings: the seminary building, the pool building, and also the gymnasium. It allows us also to take a certain portion, a small portion, that's to, I guess it'd be the west of the pool building, to do an urban garden there. And also it allows us to put in a parking facility, a structured parking facility, to accommodate our visitors.
Great, thank you. As consideration for the lease, are you giving State Parks any property?
We're not giving it to them, no. No. There is a 9.9 acre parcel that's to the north in the corner. It's the carve out up there on behind me. And it is part of the compensation for this 62-year lease. It's an important part of the compensation feature. So it's not really a give, but it's one of the last privately held, undeveloped piece of land all along Lake Washington, and I think it has approximately 400 lineal feet of waterfront. It's priceless.
Great, thank you. And that is what is referred to as the McDonald property?
That is correct.
And if you weren't giving it to State Parks as part of this deal, what could happen with that piece of property?
So I can tell you what almost happened to it. The day that my associate, Trevina Wong, had contacted their attorney, the McDonald owner's attorney, they were going to sign a purchase and sale agreement with a developer to develop 12 residential units on it. We've since looked at it, and we can only figure out how to do 9 on it, but there's already easements that allow access to it. So it is, that's probably what would have happened, or may happen, if this doesn't go through.
Great, thank you. Turning back to some of the lease provisions, does the lease say anything about public access in and around the seminary building?
Yes. During our 2 years of public hearings around the state, one of the clear and firm comments by the public was that this shouldn't be, first, owned in public hands, and second, should be available for the public's use. So the lease is quite clear on that the public has access into all the public areas, including the food and main lobby area, food service, the restaurant, the cafes, the if whatever we happen to do, spa-related. And the only place that we will restrict, if you want to use that word, will be in the lodging facilities. Upstairs, we just can't have people walking through and other people feeling comfortable with that.
Thank you. And it's not your intention to put up fences around the leased area or anything like that to restrict public?
No, all of that was posted is incorrect.
Great. Does the lease require any other uses of the project site apart from what you propose? Uses not by you, but by another entity?
It does. One of the last changes that the Parks Commission insisted on before signing was to allow a public use inside the building. I think it's 1,250 square feet to 2,000 square feet, somewhere in that neighborhood, for a use that the state parks will decide on. I mean, I've heard environmental awareness or education facilities being tossed around inside the park system. They haven't made any decision on that yet.
And so you don't have any say over what goes in that space. You're just responsible for providing that space within the building.
That's absolutely correct.
Great. Do you have any current plans for the gymnasium or pool buildings?
We do not. The seminary buildings is a handful by its own self. And to be technically correct, the gymnasium is under lease now to 2021, I believe, and it's not included in the lease until that point. Once that lease with the current operator expires, that gymnasium becomes part of this lease. So it's only really the pool building that's included in the lease at this moment, and we have no plans in the future. We've heard lots of comments from the public on what they would like to see there, and there's a big variety, but as I mentioned, our hands are full right now.
Great. Does the lease grant you any other authority over parts of the park not within the lease area?
Well, other than having easements for access or utility easements to repair and maintain or put in whatever's necessary, we have absolutely no say whatsoever over any other part of the park.
And will you let your lodge guests know when they're kind of inside the lease area or outside the lease area and that they need to comply with park rules?
We're required to do that.
Great, thank you. So now I'm just going to kind of have a couple wrap-up questions regarding compatibility of your project with the rest of the park and the surrounding areas as you envision it. Do you think that the project will be compatible with the needs of the adjacent Bastyr campus?
I do think that. From many, well, first they brought me in originally, so that helped me get an understanding of what they wanted to do in terms of growing their program and the more educational aspects of it. And then just common sense. You just look at what we're trying to do, which is, combine environmental awareness, save a historic building, have food service, all of that stuff they're already doing in some manner. So I could see spa education, herbal medicine, the herbal farming, probably work study. They're right next door. They live next door, and everybody, when you're a college student, can use a few dollars. I'd say, we haven't arrived at any final decision with them or not, but they've been supportive, as evidenced in the public record.
That's great. And finally, do you envision the project being compatible with the surrounding public park use?
Absolutely. In my opinion, and I've said it, through the variety of a couple of years of public meetings and hearings and et cetera, that I think that our lodge will enhance the park as well as the park itself will be enhanced by our lodge. So both ways I think it goes. Because I think it's an ideal example of you take a historic building in a cultural landscape, and let's not forget that on the National Register is not just the building, is the cultural landscape. You're taking that, you're protecting it, and you're getting more people to be able to use it. And let's also not forget it is a state park. It's not a city. It's not a county park. It's a state park, and we heard when we went all around, especially when we were outside this area, around the state, that there's a huge interest in using state parks, and this particular park has such a great reputation that it'll now allow people to stay overnight. If they have to, they come in, they drop in, as well as providing all the jobs and economic benefits and a place to go on Saturday nights. So you don't have to go to Bothell, to McMenamins. You can just go up there. So I think all combined, whether you're hiking on the trails or what you may be doing, by having this the lodge there, it'll definitely enhance that experience.
Great, thank you. I have no further questions, Mr. Hearing Examiner. So.
Okay, thank you, Mr. Daniels. Do the other parties have any questions, Mr. Daniels? Okay, great.
Thank you.
Now I'd like to call Trevina Wang, who is the project manager with Daniels Real Estate. Good morning, Ms. Wang. Will you please introduce yourself and clarify for the examiner whether you've been sworn in?
Yes, I have been sworn in. My name is Trevina Wang. I am a vice president at Daniels Real Estate. Daniels Real Estate does many different types of projects and development, and my responsibility is for historic properties, and in this particular project, I am the project manager.
Great. Can you just tell us very briefly what other sorts of projects that you've worked on for Daniels and how long you've been with the company?
I have been with the company for 2.5 years, and it takes quite some time to do a development project. And the one that I have been working on, as Mr. Daniels had talked about, is the Gridiron project in Pioneer Square, and it's in the Pioneer Square Historic District. It's a condominium project and has 107 units condominium, and also the shell of it is a historic building, a contributing building to Pioneer Square Preservation District. What we were doing is we were building 7 levels of condos on top of a historic structure.
Great, thank you. So I'm going to dive right into the site plan application. I understand that you are, as the project manager, the person who submitted the site plan application. Is that right?
Correct.
Great. And can you just describe for me, from your perspective, the use and what is involved in the site plan application?
So we had a meeting with the City of Canmore, and along with our consultants, and the meeting's purpose was basically to talk about all the reports and requirements that are needed, that we need to submit for the site plan, including all the technical reports and all the documents. So after we have clarified the requirements, we basically had all the consultants work on it, and we submitted all of the required documentation to the City of Canmore.
And so was that the pre-application meeting you were referring to?
Yeah.
Okay.
Correct.
Great. And so can you describe for me the use that you had talked about in the actual site plan application?
Okay. Because of the current use or destination zoning for the park is parks, in order for us to operate the lodge, we needed to change the use of that 5.5 acres that we're leasing from State Parks to a lodging use. And my understanding is that the City of Canmore has a specific code for temporary lodging use, so we're applying under that particular code.
So you applied originally for temporary lodging use, but now you've heard from the city that hotel use is the most appropriate use designation.
Correct.
And do you agree with that?
Yes, we are happy to comply with what the City of Canmore's designation.
Great, thank you. So now I just want to dive into a couple of features of the site plan itself. I believe the site plan document is Exhibit 13 in the record. It was Exhibit 13 to the recommendation. And it's in the binder, biggest binder before you, that the one up top. The site plan hearing exhibit binder, yeah, the black one. Under subpart A, and then turn to Exhibit 13.
Okay, I'm looking at Exhibit 13.
Thank you. And can you just take a look at that and describe for me where the parking for the lodge is proposed and how that's going to work?
So under our proposed alternative one, the parking for the lodge is going to be, there's 2 different levels. One is the north of the gymnasium, the immediate triangular parking area, for which is going to be restriped and used for lodge parking. And then there's another area which is currently called the upper parking lot. It's in the middle of the 5.5 acres, surrounded by all 3 buildings, and that is going to be a structured, what we call a structured parking garage.
And does that mean it'll be like an underground parking garage?
I would say that it's a structured parking garage because it just depends on what level you are at.
So
the seminary sits up
multi-level
higher
parking
than the
garage.
Pardon me?
Just a multi-level parking garage?
It's a covered parking garage. Yes.
Okay, great. That's very clear. One thing that is referenced in the site plan recommendation, and I know from your familiarity with the project, you know what this is referring to, is that there's this idea that there will be no net loss of parking for the general public as part of this proposal. Can you explain what that really means in this context?
Okay. Yes, because we are currently the state park has 220 stalls of parking, and because we're taking up these two parking areas, we're required to provide the same number of parking stalls, so that the state park does not have less parking stall than it had started with. So with this, we are intending to adhere to what we have said in the lease, and in order to do that.
Great. So what it really refers to then, just to paraphrase what you said so I understand, is that there won't be any reduction in the amount of public parking spaces. There's going to be the same number of parking stalls before the project and after the project available to the general public in
Correct.
the park. Okay. Thank you so much. Are you required to charge for the parking that will be available for lodge guests?
Yes, absolutely, we are.
Is that a requirement of the lease?
Yes.
Okay, thank you. Is there any bike parking planned as part of the project?
I believe under the Kenmore Code, we need to provide 13 stalls of bike parking. So I believe those are in our site plan.
Great, thank you. Is there any loading spaces planned for, say, deliveries to the lodge?
Yes. There are 2 loading spaces that we have planned for the project.
Okay, and is it your understanding that that level of loading space complies with the Kenmore Code as well?
Yes.
Okay, thank you. I'm just going to run through some development standards, utilities, and things like that it's our understanding the project complies with, and I just want to confirm kind of your views on those as well. Throughout this site plan process, have you had discussions with the North Shore Fire Department regarding emergency safety precautions for the lodge and what those might look like?
Yes, they have participated in all of our discussions with the city.
And have they recommended anything specific?
Yes, they basically wanted us to make sure the access road, which is that one, that connects from Juanita Drive to the seminary property, is going to stay open. And there are certain conditions that we are supposed to adhere to make sure that it will be open.
Okay, thank you. And so when you say certain conditions, is that something like a monitoring plan?
Yeah, that was the monitoring plan was developed a number of years ago when Bastille was doing their redevelopment, and so we are intending to adhere to the same kind of plan, and maybe with newer type of technology. We don't know what that type would be yet, so we will be using the latest type that is feasible for the project.
Great, thank you.
Yeah.
So the last development standard I want to touch on is light and glare. I understand that there's a city code provision that requires any exterior lighting to kind of be shielded downward and have specific requirements. Do you envision the project complying with this?
Yes, absolutely.
Great, thank you. Because one of the site plan criteria talks about comments from the general public, I am going to ask you a couple of questions about comments that you've heard about the project based on your experience attending a bunch of public meetings. First is, did you attend the public meeting before the State Parks Commission on January 5th?
Yes, I did.
And did I provide you with an audio recording of that meeting?
Yes, you did.
And I believe, for the record, that audio recording is now entered as Exhibit 25. Was there a range of public comments expressed at that meeting?
Yes, that was a fairly long public meeting, and both the Board of Commissioners, actually I should say, all 7 of the Board of Commissioners were there, and they commented on the project, and also there's a very lengthy public comment period as well. I cannot tell you exactly how many comments there are, but I could recall close to 100, and most of them were very supportive of the project.
Okay, thank you. Did you also attend the January 9th public meeting before the State Parks Commission?
I did.
And did I provide you a copy of a transcript of that meeting?
Yes, you did.
Did you review that?
Yes, I did.
Did it generally comport with your recollection of what happened at that meeting?
Yes.
Great, thank you. For the record, that transcript is now entered as Exhibit 26. Can you give me a high level of what the Parks Commission did at that meeting and what their comments were?
All 7 of the Parks Commissioners spoke at that meeting, even though 2 of them called in by phone. They couldn't be in Olympia at that point. All spoke favorably about the project, and they were very, very supportive of the project. They thanked everybody for months and a couple of years of review, and basically just say thank you for everybody's efforts on making this project successful.
Great, thank you. Are you familiar with the requested action and meeting minutes of that meeting? I sent this to you earlier in the week.
Yes.
For your recollection.
I remember that.
That item is Exhibit 27 in the record. And if you wouldn't mind turning to it, in the black binder before you, that's the smaller one, not the one that you're holding on to right now. There you go. If you turn to tab 3, Appendix 4 within tab 3 is a document, and I'm wondering if you can identify that once you get there.
Appendix 4?
Appendix 4.
I'm looking at it.
Okay. Can you describe for me what that is?
That is a letter that was sent from the... Sorry, let me just... That was a letter that is basically sent to the State Park Assistant Director, informing them that NPS has informed the RCO, which is the Recreation and Conservation Office, that they have determined that our project is in concurrence with the use, that NPS it does not trigger a
Is it the word you're looking for, conversion?
Yes, it does not trigger conversion, correct.
Yeah. And so in your understanding, does this mean that the use that's proposed in the lease and the use that's reflected in the site plan has been reviewed and determined to be in compliance with the Land and Water Conservation Fund deed requirements of the original property sale?
Yes.
Okay, thank you. Is it your understanding that the site plan that you've proposed and as recommended by the city with a few conditions now complies with all of the requirements of the Kenmore City Code?
That's my understanding, yes.
Great. Thank you. Do you object to any of the conditions listed in the city's recommendation?
No.
Great, thank you. I have no further questions for Ms. Wang.
Okay, thanks, Ms. Wong.
Oh, actually, we'd just like to clarify, the way that we've set up our presentation is to call witnesses on the site plan portion, and we understand the SEPA hearing will be occurring later, so we'd just like to reserve the right to call back Ms. Wang for later.
Yes. Okay.
Thank you. So now I'd like to call up Ron Wright, the project's architect.
While he's getting settled, Mr. Examiner, this is Amit Ranade for the record. We don't need to reserve the right to call back all these witnesses for the appeal, do we?
For the record, all the SEPA appellants will be able to bring back any witnesses that presented at the site plan hearing.
Okay, thank you.
And sir, have you been sworn in?
Yes, I have.
Okay, great. Thank you.
Mr. Wright, will you please introduce yourself?
My name is Ron Wright. I am the principal of Ron Wright and Associates Architects.
And can you tell me a little bit about what Ron Wright and Associates Architects does?
Our office has been in existence for about 25 years, and we do a large mix of work both in the historic preservation area and also in special needs housing and restaurants and various special non-one-off projects, I'd call it. Different projects that take extra consideration and expertise.
Can you mention
Please
just...
speak into the mic. Can you get the mic a little closer to you?
Sure.
Thank you.
Can you mention just a few of your historic projects that you've worked on?
We completed work on the Starbucks World Headquarters building after the Nisqually earthquake, the Pioneer Square Pergola, which is a National Historic Monument when it was knocked over, and we just finished Washington Hall, which is a historic building in Seattle, and the combined mix is probably somewhere in the range of 30 historic buildings, probably about 10 or 15 of them are National Register buildings.
Great, thank you. Can you describe for me your connection to this project?
I am the consultant providing architectural design services for the project to date.
Great, thank you. And this is a building on the National Register. Is it your understanding that the design for the lodge will comply with the Secretary of Interior standards?
Absolutely, yes. And we have incorporated that understanding in all of our work, yes.
And can you describe for me kind of what the Secretary of Interior standards are?
The standards are a framework of guidelines that are put together to ensure that historic buildings are maintained in the proper manner according to how they were built, and that they will be restored in a manner that will allow them to continue in use for generations to come. And they're very prescriptive about following certain rules regarding restoration and maintenance and ensuring that the building will continue to be viable long into the future.
Great. So from your opinion as architect who works on historic buildings, does compliance with the Secretary of Interior standards help ensure that any adaptive reuse of the project or adaptive reuse of a building is really consistent with the kind of historic nature of that building?
Absolutely, yes. And there's plenty of examples of that across the entire country where adaptive reuse is encouraged in order to maintain the usage of a building that can no longer be used for what it was originally designed for, yet it is historic. And you want to maintain that historic character or fabric of the for the building.
Great, thank you. I have no further questions for Mr. Wright.
Okay, thank you, Mr. Wright.
That's it. I'd now like to call up Tim Brockway, the civil engineer for the project. Mr. Brockway, have you been sworn in this morning?
Yes, I have.
Could you please introduce yourself for the record?
I'm Tim Brockway, part of the Colgan Porter Lundeen Civil Engineering Group. I've been a project manager at various levels for about 23 years.
Great. And can you describe for me your involvement in the project or CPL's involvement in the project?
We participated in the upfront planning of the site plan application documentation to conform to city standards and help the Daniels Real Estate team understand what would be required.
Great. Thank you. I'm going to ask you just a couple of questions, first about water and sewer, and then about impervious surfaces and drainage, just to help us understand how the project will comply with those requirements. So first, regarding water and sewer, can you just describe briefly what connections are available and how the project will apply with the water and sewer needs and the codes?
Addressing water first, there's a water line that does feed the property and comes down to the development area. We'll have to probably do some extensions of that and some specific upgrades. We haven't officially laid out all that design, but the water availability certificate does indicate that per coordination with the fire district, the necessary fire flows can be made available with the system. On the sewer side, similarly, there's a joint sewer system, as I understand it, slightly downstream of where we will connect to it that also serves Bastille, and we'll be assessing the specifics of that with the sewer district to make sure that that complies with their requirements.
Okay, thank you. So as part of the site plan, there will be construction of a structured parking garage, we've heard, and some reconfiguration of existing parking lots. Is your understanding that this will increase the impervious surface at the site?
Yes.
Can you describe for me how much that impervious surface might increase?
For the overall facility, or the overall assemblage of the area, it's expected to go up to approximately 2.3%. I can't speak what that percentage increase is. That's 2.3%. Specific to the development area, we're actually proposing to reuse a lot of existing impervious surfaces. So in terms of the net add, it will actually not be as complete as what is shown on the document, because some of those areas already are tennis courts or that type of facility.
Great, thank you. And it's the kind of increase in reconfiguration of the impervious surface, in my understanding, that triggers the drainage requirements. Can you just describe how that all works for me?
Correct. Depending on the development, depending on the level of redevelopment, certain areas have to be treated as new even if they are existing. Certain areas are only treated as new if they are actually an addition. We'll be working with the city on the specific requirements and also the design. Certain areas may just be covered up that are currently impervious rather than actually torn up and rebuilt. So all of that kind of detailed design work is what we'll work with the city staff on to comply with city code and state code. Great.
And so when you say you'll work to comply with the codes, what do those codes kind of what is their intention? What are they set out to ensure?
They're intended to ensure that there's no degradation or impacts basically to the downstream or the immediate vicinity of the development within a certain area as identified. The specifics of that, again, are worked through on the development process in detail with city staff, but generally city code and state code are intended to not cause any harm by the proposed improvements.
And so you've heard from Zach Richardson earlier that the project will need to comply with the 2009 King County Stormwater Design Manual. Based on your experience and your familiarity with the project, is your opinion that it will be possible for the project to comply with that manual?
Yes, it is.
Would it also, if the project had to comply with the 2016 manual, would it also be possible for the project to comply with that?
Yes, it would.
Okay, thank you. I don't believe I have any further questions for you, Mr. Brockway.
Thank you.
Okay. Well, and this witness and Mr. Richardson, I should have mentioned too, both the expert witnesses, there's a right of cross-examination. If anyone had any questions of Mr. Richardson or this witness? Okay, sir. Thank you. Thank you.
Next, I'd like to call Jennifer Barnes, the traffic engineer for the project.
Good morning. I have been sworn in.
Thank you, Ms. Barnes. Can you please introduce yourself for the record?
My name is Jennifer Barnes. I'm a licensed civil engineer specializing in transportation. I've been working in transportation of some form or another for over 20 years, have been working in impact analysis to support environmental documents for about 14 years, and have been with my current firm, Heffron Transportation, for about 6.5 years.
Thank you. And can you please describe for me your involvement with the project?
I led the transportation and parking analysis for the project.
Great. Can you just give me a high-level overview of the traffic analysis portion of your transportation analysis? What did you do, and what were the results?
So we followed standard best practice methods that are established by the Institute of Transportation Engineers, which we refer to as ITE. Zach referred to ITE earlier. And that sets forth all of the procedures for traffic impact analysis and parking analysis and establishes rates for a variety of uses. We also used rates based on data that we collected, my firm, at the Cedar Brook Lodge in the city of SeaTac a few years ago, because that was a facility that is very similar, or at least at the time that the data was collected, in size and type as the proposed lodge, in that it was had about the same number of rooms, had meeting and banquet rooms, and also had restaurant and ancillary uses on site. We did the ITE, I should mention, the hotel category for ITE is very consistent with, as Zach mentioned, with the proposed project, and Zach had already mentioned what the hotel definition is for ITE. So for the traffic analysis, we looked cumulatively. We analyzed future conditions for the year that the project would be open and fully occupied, which is 2020, and looked at cumulative growth, some background growth that for conservative analysis that would be unrelated to the project. So we took into account background growth due to regional development, growth in Bastyr University's campus population, and also took into account the city's ball fields project and additional trips that would be that are expected to be generated by that project. And so all of those were combined for a conservative analysis of what the combined traffic conditions would be. We analyzed that without the proposed project, and then added the trips that we would anticipate would, or that we projected would be generated by the proposed project. For the project-generated trips, we assumed a very conservative condition of full hotel occupancy with a conference occurring. And our results were, as Zach mentioned, the city has a standard of level of service D for traffic operations. That is based on highway capacity manual methods, and level of service gets graded, kind of like a report card, A through F, where A is the best condition and F is total congestion. And the city has an adopted standard of level of service D, and our findings were that even with this combination of conservative conditions, that the traffic operations would be level of service C, which is well below the city standard.
Thank you. And is the city's designation of Juanita Way as an arterial contained in the city's comprehensive plan?
Yeah, that's an adopted standard by the city.
Thank you. And can you just explain to me, what does a level of service C kind of functionally mean?
It's based on the amount of delay that vehicles would experience at the intersection. We look at the peak hours because that's the busiest time of day, so we'll have the highest level of congestion. We looked at both the morning peak and the evening peak. And then there's different thresholds that define ranges of average delay that are defined for each level of service. And so level of service C is, I think the threshold is at 35 seconds average delay, and then D would be 35 to 55. So there's a lot of capacity still, even with the project and this cumulative conditions available while still meeting the city standard.
Okay. Thanks for clarifying that. And so just again, your analysis showed that with the project, even accounting for future growth in the background population and at Bastyr University, that the level of service would be C, and that would meet the city's requirement because the maximum level the city allows is D.
Correct.
Thank you. Can you also describe what the transportation analysis says with regard to parking?
So for the parking analysis, I should say for both the traffic and the parking analysis, we looked at rates that have been established by both ITE and the Cedar Brook. And in each case, they were actually of similar magnitude. The Cedar Brook data did corroborate what the ITE rates were, but they were a little bit different. And in each case when we were looking at rates from each of these two sources, We just chose the highest rate so that we would have the most conservative analysis overall. And for the parking analysis, the ITE rate for overnight parking was actually the higher rate. And the two kind of peak demand for parking periods that we would expect for this kind of use would be for the hotel, the overnight guest parking when everybody is back in their rooms and parked in the lot. So for a hotel with full occupancy and the overnight demand, we estimated a demand or projected demand that was well below the spaces that are being proposed. And so we identified no parking impacts related to overnight guest parking with a fully occupied hotel. We also looked at midday parking demand with a conference condition. For that, we used the Cedar Brook data because our counts were very detailed and we actually had enough data to break out conditions with and without a conference. And so we conservatively assumed a condition and applied the rates of a fully occupied hotel with all 100 rooms full, and then a conference on top of that that would be unrelated to the hotel so that everybody attending the conference would not be staying at the hotel. And we reached the conclusion that a mid-size conference of about 120 participants would be able to be accommodated with parking on the site in that condition. And there's a lot of different, infinite combinations of that can actually occur. So this scenario was chosen to be just a conservative estimate based on kind of what could likely occur. But we did conclude that, we did conclude that in most cases, the proposed parking would accommodate the peak midday demand, even with conference conditions. But we also identified that for a large event, there is potential that there could be more parking demand than the proposed supply. In that case, we identified two potential mitigation measures to address that. One would be for the hotel to use valet parking so that they could use the available space on site, like stacking the cars more tightly so that they'd be able to actually accommodate a higher capacity on site. And the second was potentially to work with Bastyr University during times when Bastyr has excess parking, to lease that parking for parking overspill. And we did acknowledge that in the case of off-site parking, the hotel would also probably need to shuttle its guests between the off-site parking and the site.
Okay, thank you. And is it your understanding that Daniels has committed to doing those mitigation measures?
Yes, that's my understanding.
Thank you. I don't have any further questions for you.
Thank you.
Okay, well, Mr. Reese, will Ms. Barnes be available for cross-examination during the SEPA portion?
She will, and will also provide more of her testimony that's relevant to the SEPA appeal issues at that point.
And since Ms. Barnes is an expert witness, there is a right of cross-examination now. If anybody wants to ask her some questions, the reason I asked about her availability for the SEPA portion is for the SEPA appellants, you'll have a chance to cross-examine her during the SEPA appeal to the extent that's relevant to the SEPA issues. So, okay, no questions of Ms. Barnes? Great, thanks, Ms. Barnes. Oh, okay, all right. Yeah, go ahead. Did you go up to the microphone there?
We've got power.
Thank you. Just here?
No,
No,
please
no,
go
right.
to the mic
Podium
and let
there.
me know. Give me
Yeah.
the spelling of your name.
Elizabeth Mooney, I don't have to give my address. Elizabeth.
Have you been sworn in, Ms. Mooney?
Pardon?
Have you
Yes,
been
I
sworn
did swear in.
All right, go ahead.
I'm definitely
Last name, please.
Mooney, Mooney. I'm certainly not an attorney, not qualified to understand all of the things that, the comporting and that. But having been to St. Edward Park and having worked with volunteers, I do have a couple quick questions. Have you ever been to the Beer Fest or whatever it's called? I think that other people who know St. Edward Park better than I do. In the summertime, there's some concerts. There's some beer fests. There's a Nordic Scandinavian fest. some of it is involved with bicyclers who come in and drink beer and depart. I don't know everything that's up there myself. How many of those particular festivals that bring in lots of traffic have you personally been to at St. Edward Park? Oh, wait. Do you have to object? Wait, do I get objected to? This isn't...
Yeah, when cross-examination, there can be objections. It's just to hear what Ms. Wellington...
Oh, sorry.
Yeah.
I didn't know I had to go against you.
I think, where are you going with your question, Ms. Mooney?
I just want to know, based on her going to Cedar Brook, which I've never been to, and based on Mr. Daniels having done wonderful projects in an urban setting, whether she's done any analysis in this type of setting where there's danger to children, there's danger to bicyclists, it's a traffic study, and I'm just wondering if she did any on-the-ground investigations when there was that kind of situation.
I'll allow the question overrule the objection. It addresses the traffic impacts of the proposal, which is relevant to site plan review. So,
I observed the site. I have not been to the Beer Fest personally in Kenmore. I'm aware that there are large events that sometimes happen at St. Edward Park. The purpose of our analysis is to determine if the traffic or the parking in particular that would be generated by this project, how well it could be accommodated by the proposed supply. And our conclusion was that in most cases, with moderately sized events, it can be accommodated on site. The parking, I am aware that there are events that cause the St. Edward Park parking to be full, but that's not related to this project because this project's responsibility is not to overspill into the St. Edward Park parking. And mitigation for off-site parking would have to be arranged by the hotel. So the hotel is not going to arrange, I would expect, is not going to arrange off-site parking at a time that they're at a place where there's no parking available. It would be the hotel's responsibility in the occasional event, if the occasional event happens that is large enough that it can't accommodate its own parking, then the mitigation that we identified is simply to find parking away from the site. And so if in the case that you're talking about, if Bastyr does not have, if Bastyr's parking is being used for something else, the hotel would not be able to make that arrangement, but they would have to make the arrangement with somebody for off-site parking.
I really appreciate the vigor with your analysis. My worry is that the common park user, like a mom with her little toddler, the person who brings their dog on a leash, and the children who come to play ball, or the spontaneous attendees that can come in throngs, that may be something that has not yet been analyzed, and that might be cause for significant danger in the future. So
Did you have any more questions, Ms. Mooney? Or you'll have an opportunity to comment during public comment. So,
is Cedar Brook in an urban setting or a state park?
Cedar Brook is in an urban setting, but I want to emphasize that the use of Cedar Brook wasn't to just assume Cedar Brook was going to be plopped into St. Edward Park. What the Cedar Brook data and data collection and analysis allowed us to do was to estimate trip rates based on occupied room for a facility that has lodging facilities, that has banquet and meeting rooms, has restaurant, has pool and fitness center on site. And so that's a very similar use. And so what we did was our observations allow us to establish a rate of trips with the conference occurring and without a conference occurring per occupied room. So the way we used that data was then to establish or to apply that rate when it was higher than the ITE rate, so it was more conservative, to the Cedar Brook Lodge as with its existing characteristics. And then we applied it because the rate is per occupied room. All of the rates were applied assuming a full occupancy. So all of our estimates are the high end of the range of reflecting a condition that is a fully occupied hotel with conference happening.
Did you include numbers for the Environmental Learning Center traveling yet? And I apologize if I didn't hear your answer before.
There wasn't an environmental learning center identified as part of the project. That's not part of the project. So that wasn't explicitly analyzed. The trip rates do capture the ancillary uses on a hotel as it's defined, with on-site restaurant, meeting and banquet rooms, and then the other supporting surfaces.
Thank you.
Thank you, Ms. Moody.
Thank you. I could use a break.
We're getting close. Another question?
I need one now.
Okay, I guess I was going to... I'm sorry, ma'am. I guess we need to take a break for the court reporter, so we'll take our 10-minute break now, and then we'll take your question when you come back. Thanks. So we're off for 10 minutes. All right, we're back on the record. It's about 11:20 or so, March 1st, 2017. We're still in the Lodge at St. Edward site plan application, CSP 160077. So we just took a 10-minute break. Ms. Barnes, the applicant's traffic expert, is still on the stand just to answer a couple questions. And apparently I think someone else had one more question, and so I'll let her ask her question, and then we'll move on. So come on up.
Hi, my name is Ann Anderson.
You've been sworn in, Ms. Anderson?
Yes, thank you.
All right.
Anderson with an O or an E?
Oh, thank you. Okay, my quick question is, because you are the go-to person for the hotel for parking and traffic, I'm here to ask you a question about kids' safety. And it looked like the expanded parking lot would be right adjacent with the castle playground. Is that true?
I can't speak to that, actually.
Oh, okay, so you are in charge of the hotel parking, and you don't know the layout of where the playground is.
Well, I can tell you
in relation to the parking lot.
That the project is subject to all of the design standards that the city and
okay, so my question is, I hope that you. I'm asking if you will consider to have a buffer between, because right now it's the eastern rolling grass field, and kids now play outdoor rec on it. And, you know, as a parent myself, you know, my stress level goes way up in a parking lot. And I also have students with special needs that run free in that grass lot.
We're just asking questions.
Okay, yeah. So I'm asking if you could consider having a buffer between the playground and the hotel parking lot, or like a gate, or like a section off walkway through the parking lot, so that kids can get from the entrance of the parking lot all the way safely to the playground.
I'll say as the traffic analyst and parking analyst.
Okay, so that should be under the analysis, right?
So that is a site design question, and I think that's important feedback for the designers of the site.
Okay, so we're not talking about that today.
That's not my
It hasn't been analyzed. Okay, thank you.
Mr. Hearing Examiner, can I help answer the question?
Sure.
This is Zach Richardson with the City of Kemla.
Thank you.
No, so the new parking is not down by that playground. Actually, all of the new expanded parking is up north of the gymnasium, and the new parking garage will be below where the existing parking is, and the project will also be rehabbing the public parking that is down next to that lower access road, but that will remain public parking, the parking right next to the play feature.
Okay, so you're the person to go to about the design. So a question for you would be, my colleague asked if would trees be removed on that northeastern side to expand the parking lot?
I actually can't speak to that at this point. I'm not entirely sure. I haven't reviewed the tree plan as part of that review. That's typically handled by the planning department.
Okay, but that's good. So the expanded parking lot, to confirm, will not be adjacent to the playground on
Correct.
the eastern side. Thank you.
All right, thanks, Ms. Anderson.
Thank you, Zach.
Okay. Ms. Bar- Oh, yeah, of course.
Is that better? Yes. You heard a question earlier about an environmental learning center. Mr. Daniels testified previously that there will be some space in the building that's reserved for state parks use to program however they want under the lease. So do you understand any specific environmental learning center use to be part of this project?
No.
Okay, thank you. And then with regard to the use of the Cedarbrook data, can you explain to me whether that was required to be considered, or kind of what is the requirements around that?
It wasn't required. We could have done all of our analysis just using the ITE data, but because we had this detailed data of a use that's very similar, we use that as in a supplementary way. And what it allowed me to do was actually provide more conservative analysis. Because as I mentioned earlier, the Cedarbrook rates that were derived by our observed data were kind of in the same ballpark as the rates that ITE provides in its trip and parking generation manual. But ITE was a little higher in some case, and Cedarbrook was a little higher in some case. And so for each point in the process where I needed to apply a rate, I applied the higher rate between the two so that we would have more conservative analysis. But had the Cedarbrook data not been available, we would have provided very similar analysis using the ITE rates. It's just that some of the elements of that would have been a little less conservative than what we provided.
Thank you. I have no further questions, Mr. Hearing Examiner.
Thank you, Ms. Barnes.
Any questions?
Anyone else from?
So we have a few additional witnesses who could have testified about critical areas, but as the city earlier pointed out, the project is outside all applicable critical areas, and there are expert reports to that effect in the record now. I think we'll just go ahead and do a quick synopsis if that's okay with you, Mr. Hearing Examiner. So I'm just going to speak very briefly to the criteria in the code that you must consider in making your recommendation to the City Council. As you heard previously, the first criteria is conformity with city and state rules and regulations. You've heard based on the testimony of both the city today and Daniel's witnesses that there's adequate water and sewer capacity, that there will be drainage improvements that will comply with the applicable King County Stormwater Design Manual, that the development will meet the development standards in the park zone that are applicable, that the increased traffic impacts of the project are expected to meet the city's expectations for level of service, concurrency, and impact fees. Along with that, the project is providing more than the minimum required parking. You also heard from the city that there's been a robust SEPA process and that they made a determination of adequacy. Obviously, that is the subject of the next portion of our hearing, but we wanted to point that out. So on a whole, taking that together, we do feel like we've met the site plan criteria 1 for conformity with city and state regulations. Criteria 2 is the consideration of comments of interested parties and agencies with jurisdiction. You'll hear more comments today, and I'm sure they're going to express a range of views, and you should absolutely give appropriate weight to those comments. We'd like to point out, just in the record, the comments of the State Parks Commission we think are particularly relevant as the property owner who agreed unanimously to approve this lease. So we think that's an important consideration there. Also, the support that the project has received from a number of historic preservation groups, both in the public comment that you admitted as Exhibit 45, but also attached to the DEIS are a number of public comments from those historic preservation groups, obviously commenting in favor of this rehabilitation proposal. Last, I'd just point out that Bastyr continues to be a supportive neighbor in this project, and we think that that should also be given weight. So in all, there is a range of public opinion about this project, and I'm sure you'll hear that today, but we'd like to just emphasize those comments. The third site plan criteria is consistency with the character and appearance of the existing development. As you heard from Ron Wright, the rehabilitation will comply with the spirit and intent and requirements of the Secretary of Interior's standards, and we believe those consistency with those standards will ensure that the lodge proposal is consistent with the level of existing development and the historic nature of the seminary building and cultural landscape surrounding it. The fourth criteria is compatibility with the existing and proposed vehicular traffic patterns. You've heard that the lodge proposal relies on the existing entrance access road to the park. It's not proposing to change any fundamental circulation patterns, and it will have increased ADA access into the park through work on a park trail. We think that that is absolutely consistent with this criteria, and that there are no other neighborhood pedestrian plans or anything like that that are applicable to this site that should be considered. Last is conformity with the comprehensive plan. Aline Davis in her testimony emphasized numerous comprehensive plan sections that this project is consistent with, and we absolutely agree with her analysis that it is consistent with the comprehensive plan. So we would hope that you'll take all of those things into consideration for your recommendation to the City Council, and we urge you to recommend approval of this project. Just one final note, we've noticed that the SEPA appellant has submitted all of their briefing as public comment on this. Obviously, we'll have a whole SEPA hearing to address those, so we haven't chosen to address those comments specifically here.
Okay, thanks, Mr. Weeks. Did Washington State Parks have any comments? Or?
We have no testimony in addition what was provided by the City of Kenmore and the applicant.
Okay, great, thank you. All right, now I did have one member of the public has an appointment she can't get out of and wanted to speak out of turn, and I said that would be fine. So, first of all, Ms. Baker, do you have the sign-in sheet? Yeah, and while you give that to me, Ms. Agard, why don't you go ahead and get started with the public comment portion of the hearing. As I mentioned before, all speakers go to this podium there, state your name, how to spell it, so we get that right, and then let me know if you've been sworn in, and then you can go ahead and make your comments. Have an approximate time limit of 5 minutes, and usually it's not hard to comply with that, so that shouldn't be a problem.
Mr. Hearing Examiner, I'd like to...
I will explain what I handed to him in just a few minutes, if you want to wait.
Let me, I'm just getting out my exhibit list. Are you addressing the exhibit, or?
I'd like to just ask the Hearing Examiner as a point of clarification for the city's rules regarding submission of written comments precluding testimony as well.
I'm not following your concern. I mean, documents will be admitted up until the close of the public comment portion of the hearing, and that can include written testimony.
My understanding of the city's rules were that if individuals chose to provide written comments, they would be precluded from also providing verbal testimony for the Type 4 site plan application, and that was the city's discretion to make that call.
Thank you.
I haven't seen that rule. I don't. Where is it? Could you?
Mr. Hearing Examiner, I can explain.
Yeah.
I would just note that when the meeting was advertised by the city twice, both in your original advertisement and your addendum, there was no statement at all regarding the need to provide public testimony by the 28th of February, or that this would preclude anything. So if this is your rule, you should have published it in your public notice.
Okay, Mr. Cascuma, if you could.
So I have provided...
The city would like clarification on this, too. Maybe to short-circuit this and allow this person to testify before the lunch break, could we have a clarification? Is this a written testimony of her, or is this a document that she would like considered by all of us?
Okay. This is a written testimony from Ms. Agard, correct, Ms. Agard? Your comments?
It is essentially an outline of the testimony. It is not verbatim what I would have submitted if I had submitted it in writing. It is also key sections of exhibits that are already in the record. Either they are addendum to the FEIS or the EIS. They are either part of your exhibits that are in the record. And I have simply copied the pertinent sections so that the hearing examiner can follow what I am saying.
Okay.
So what I'd like to point out on the city's behalf is I am looking at the hearing examiner rules. And in Section 3, titled Definitions, the hearing examiner has defined the word party. And according to
the word what?
3, Section 3 of the hearing examiner's rules, there is a definition of party. And that definition provides that a party is, for an open record hearing, the applicant, the city, or 3, a person who testifies at the hearing, or, it's a disjunctive, submits written testimony for consideration at the hearing. The city asked the question of Mr. Hearing Examiner last week whether the city should be interpreting and applying the or word, or that was something that the hearing examiner wanted to give us an opinion on. And as the hearing examiner will recall, the hearing examiner authorized the city to establish rules for the submittal of either written testimony or providing oral testimony this hearing. And Mr. Hampson, who wrote the notification to the public about that option and put it on the city's website last week, can testify as to what the instruction actually says. But it is our position that based on the rule and based on the notification that was given to the public about today's site plan hearing, that a person has the opportunity to do one or the other. We would certainly be open to, it'd be the opportunity of the person to submit an exhibit, a document that is in support of either oral or written testimony, but our position is that a person can't do both.
All right, yeah, because I was asked the question, how late into the game the citizens could submit comments to staff that were then forwarded to me, and I told my response to staff was, well, you can set the rules as to how late you get those comments. It's because I'll accept written comments up until the end of the public testimony portion of the hearing, and because I felt that it was appropriate for staff to identify. Obviously, if they don't think they can process 200 comments coming in at 8:30 for a 9 o'clock hearing, I think that's their call. And it's the responsibility of the public then to present whatever exhibits they have at the hearing itself. So that was what I was talking about. I still don't see how the rules are interpreted to say that they're only permitted to testify one way or the other by the definition of party. Or who submits. Yeah, that's just covering the rules so a person can be a party for more than one reason. Now, are you saying that public notice somehow stated that people could only participate one way or the other?
Yes, it does.
It did not.
Talking about the notice that was put on the website last week.
Pardon?
The notice that was put on the website last week. I believe she's referring to a notification of the first hearing on February 28th, I believe it was, or some
and
other
the revised notice that was sent to me. I don't check the city's website every hour to see what you may have added.
Well, we are just asking the hearing examiner for a ruling on this, because what we don't want to have happen is for people to submit both written testimony and oral testimony, and we all have to figure out whether they're the same, whether one is more than the other, and so forth.
All right. Yeah, this is, it's not the way I would have interpreted the rules, the way that this was notified. But people have now relied on that notice, so that, that presents a problem here. All right, Ms. Agard, I think, since that notice was sent out that way, just read your comments, and then I'll admit the exhibits as clarifying your comments, but it's basically the same thing. You're going to get it into the record, but it's going to be from what you read. I just don't have a written document. Because the public has been told one thing, I don't want to say another right now then. So what I'm saying is, if you read it, it's basically the same as if I had it in writing anyway. I'm going to get a transcript of it, and it's all going to be there. So
I think when I present my testimony, I have different emphasis and explanations, which I did not include in my writing. It was really intended as a summary as you followed along with what I said. It was never intended to be a formal written
Well, I think, like I said,
comment.
you just read this and then add anything you want afterwards verbally to emphasize other things you want to emphasize. But as I said, the public's been notified that this is going to be handled in a certain way, and I can't give conflicting rules to the public. Like I said, I wouldn't have ruled that way, but that's the way the notice was provided. So, like I say, do you have a copy of this?
I do. I have some notes on my copy that I was going to add to my comments. So.
Okay. All right. And,
so, how would you like to proceed?
Well, like I said, I mean, if you want this document in, I think you're just going to have to do it by reading it and then adding anything you want on top of that. And then in terms of these exhibits, they're already in the record, but I'll admit them as the exhibits that you're referring to in your testimony.
Okay.
Okay? Yeah. We're sorry about that, but so go ahead.
So I should not speak then?
No, I'm saying you should.
Oh, okay. Okay.
Well, you have an option. You can either
okay,
just submit this,
I will just,
or just read
I'm
this.
running short of time, so let's go ahead.
Just read your letter and then add anything you want to it, and then you're set. Yeah.
Okay, so for the reasons outlined as followed, I feel that the hearing examiner should determine that the St. Edward Park Lodge proposal by Daniels be denied on a determination that does not meet the criteria required for approval in Kenmore Municipal Code 18.105.050. And the first reason, as I've outlined, is its conformity with the city and state rules and regulations in effect on the date the completion application was filed. And I have outlined below and I'll emphasize why I feel this is not correct. RCW 79A050025, the statutory authority under which State Parks lease is granted, states that the associated property immediately adjacent to the areas is covered by the lease. As you look at the site plan over on the side and also included in my papers, you will see that there is a 0.5 acre piece of property noted as an organic farm, which is not immediately adjacent to any of the areas that are under the lease. It is a much larger area that is associated with a picnic area and a volleyball court, which is also recognized as culturally significant. And further, the addendum to the lease describes the current proposal in saying that it includes parking and circulation improvements, which includes expanding the existing parking and the pedestrian paths surrounded the seminary. I should say I have also included in the packet a color copy that was part of the lease showing lines of green and red, showing the area of the lease. And those lines include this organic farm or culinary garden, and also the new parking area, which is on the northeast side. So, first, I do not feel it is in conformity with the state laws because it has exceeded the area that is immediately adjacent to the buildings as outlined and as I quoted. Secondly, it says you should consider the recommendation or comments of interested parties in those agencies having pertinent expertise or jurisdiction. I do not believe that it meets that criteria. I've included just one page from Kayleen Cottingham's November 2016 statement, which you have as an exhibit, and she repeats the same language that's in RCW 79A, that the lease area includes the seminary, pool building, gymnasium, parking areas, and associated areas immediately adjacent to the structures. This does not include the 0.5-acre farm, and it would not include, it could include, I should have said, I said not, could include the new parking area for the 53 stalls, but it does not include improving pedestrian paths. The second agency which replied on November the 18th, 2016, was the Department of Archaeology and Historic Preservation, or what the acronym is called DAP. And the historic parks, I included two statements from there, and this again is the full exhibit, is in the record. Item 6 says, some questions remain to us about the automobile parking will be provided. We do recommend that the proposed parking structure be sited and constructed to minimize impacts to cultural and historical properties and be designed to be compatible with the district's historical character. So I'm going to digress here for a moment, and I'm going to point you to, this is the cover letter for the U.S. Department of Interior National Park Service 2008 study of the St. Edward's Seminary Cultural Landscape Inventory. This is an addendum and in the FEIS, so the full document is there. And I have excerpted from that document just one of the pages, which is this page entitled St. Edward's Seminary Cultural Landscape. It looks like this. And I want to point out here that the 53 stalls that are being proposed on the northeast side for that, if you look at this, there is a lavender color right up here in the corner. And I have also included a full-sized 11 by 17 color map called the Great Lawn and Contemplative Garden Niches. This is not in the current exhibit record, but I am now entering it, and I don't know where you are in your numbers.
So where does this document come from?
This comes from a compilation of the information in this cultural landscape inventory.
Oh, I see.
It's a compilation, but the document actually comes from myself and a group of citizens who were working on a sign for St. Edward, and we had a professional designer design this map, and the map that's attached, which duplicates the one here in the interior. Okay. And I want to point you to number 3, which is the Nun's Garden. So as I look at the parking that is being proposed, it is either right on top of or right in front of the Nun's Garden, number 3. This is part of the cultural landscape inventory, which is to be preserved and enhanced under the Department of Interior guidelines for historical preservation. It says that it's not recommended that altering buildings and their features or site features from the restoration period. So as you read that explanation of the Nun's Garden, you'll see this is an important part of the historical cultural site. It was created by the Sepulchre nuns as a contemplative retreat from the confines of the annex and their kitchen duties. It talks about the plant material, and so this parking spot is not compatible with the site features that are both there today, because this picture is taken from what it looks like today, or with the guidelines for historical preservation, or with the 2006 inventory. In addition, there is another point on this map where you see a red arrow here going in. Okay. And this map, it describes, again, the seminary cultural landscape, the spatial organization, the entry drive sequence, and it says the green arrows show intact views, while the red dashed arrow shows a view that should be closed. So when you look at the site plan and you look at the entrance to the structured garage that is being proposed, you see that it is directly in conflict with the cultural inventory recommendation. So please take note of that. Then also in the DAP letter from November 2016, this agency recommended that they should now more clearly define the mitigation, the impacts and affected resources more clearly. And now they are defined by the site plan, and we see that not only are they covering or completely obliterating the Nuns Garden, probably removing 10 of the large cedar trees that are beside it, which is contrary to the recommendation of the cultural inventory and clearly was cited by DAP. Then, and now also I would note that in the final EIS, in response to the DAP letter, the response simply says, response noted. So no mitigation is provided, no discussion, just response noted. Thirdly, compatibility with the character and appearance of existing or proposed development in vicinity of the project. As I've discussed previously, this underground parking and the entrance is not compatible with the cultural landscape. But I would also point out that on the west side of the gymnasium and coming down along the seminary, we now have the access road from the parking, which will be for the lodge, which is directly to the north. So you come down, there are additional parking spaces, and I've included a small map of this site plan. And then there's a point where it says valet parking or access. That road is horrid. Right now, as a visitor to the seminary, I can walk in and walk around and across the front of the gymnasium, access the trails and the Great Lawn. I am not passing a road that is servicing the seminary, the hotel parking. That road is totally out of character with the features from the restoration period, and it should not be allowed. Finally, compatibility with plans for existing and proposed pedestrian and vehicular traffic in the vicinity of the subject property. I would point out that now the new public parking on this northeast section on top of the Nuns Garden, now the people who are parked there have to cross over down by the gymnasium across this new landscape top of the structured parking, go over and again cross the road that is servicing the parking for the lodge, to get down to the main part of the park. And I do not feel that that is compatible with the current features and the use of the park. So for these reasons, I request that you, as a hearing examiner, determine that the St. Edward Park Lodge is not compatible with 18.105.050 and deny it.
Thank you, Ms. Agard. Let me just to clarify for the records what documents I have here. So where did this come from again?
Okay, it comes basically from myself and a friend I was the president of Friends of St. Edward State Park, and we had a for-culture grant to design signs for the park. We designed 3 of them. If you've been to the park, you will see those signs on the history of the seminary. We designed this one, but it was never installed.
Oh, this is a sign. Oh, okay.
Okay.
I see.
Yes,
Oh, okay.
it was
Okay.
designed.
I see. Okay.
It was designed. I had a professional photographer
Oh, got
taking
it.
the pictures, but it shows the park and these niches around the perimeter trail as they exist today.
Okay.
And it's taken from the cultural inventory.
From the cultural inventory.
That is from the cultural inventory.
And this document is a...
That is the
after
site
release?
plan that is on the city's website.
Okay. And then this is the cover of the cultural inventory.
That's the cover, correct?
And this is the, it says Appendix 3 to what was
Yes, that was part of the lease document.
Okay.
And that, again, shows what they are covering by the lease.
All right, and finally, we have the November 17, 2016 letter
Correct.
from
And
Colleen Cunningham.
I have
One at a
Kay-
time.
Kayleen Cottingham,
Cunningham.
and then I have a page from the DAP. Okay. But
I
you
don't
have the full
page
DAP.
of the DAP. Oh, I see, you're saying it's...
You
okay.
have the full documents in your exhibit.
All right.
Thank you.
Any objections to this collection of documents being admitted as 46? This would be Ms. Agard's collection of exhibits. Does it include her written testimony?
Mr. Can we just get copies during the break of
Yeah,
that?
sure. We can, and then see, okay. You can
And
raise any
and
concerns
thank
we
you
have.
for accommodating my time
Thank you,
schedule.
Ms. Agard. Yeah. I'll leave that right here. Take a look at that later. So it's admitted pending any objections, and I'll rule on those. So.
And Mr. Ulrichs, just one point of clarification on the structure of this. Previously, in kind of a draft agenda that the city had sent us, they had indicated a time for our rebuttal to public comments. Will that
definitely.
be on the
Before
agenda?
we go to SEPA, there'll be a staff rebuttal and then an applicant rebuttal, and then we'll move into the SEPA portion of the hearing.
Great, thank you.
Okay, sure. All right, let me go through the list now. George Scott, did you want to say anything? Mr. Scott? Is Mr. Scott here? Okay. How about Susan Gardner? Did she want to say anything? All right, and after Ms. Gardner, I have Elizabeth Mooney. Ms. Gardner, have you been sworn in?
I was sworn in.
Okay, great.
My name is Susan Gardner, Gardner. I am thrilled that the Washington State Parks agreed to lease the property to Daniels Real Estate Group. I'm thrilled that the city of Kenmore will finally have a reason for people to make this a destination. I'd like to talk about traffic and animals. So I live in the Arrowhead neighborhood. It is a development between the park and the golf course. Our only access to the outside world physically is on Juanita Drive. I want to say that the small impact that this proposal has will be nothing compared to the diversion of traffic to Juanita Drive that we're feeling from tolled roads. There is all the traffic created by Bastyr students. There is traffic created by the events that are held at the park. All of that is hugely more impactful than a 100-room hotel and its workers. We in Arrowhead have figured out how much time we need to allow to get out of our neighborhood in order to go anywhere, and that's just the way life is. So as far as, I just want to, as an aside, the beer festival is no longer held up there, so that those drunk people won't be running over kids. It's held at Marymoor now. And it is a Washington State Parks function, not a hotel function. Secondly, I'd like to talk about wildlife because there's always concerns about lights and a more or inhabited area may be disturbing the wildlife. In our neighborhood, we frequently see deer. They like to sit on our lawns. They like to nibble on our rose bushes. I have pictures of them on my deck. So the deer have figured out how to live and roam between the golf course and the park, and I don't feel that the hotel will make any difference to that. Also, we see things at night like owls. I've seen owls perched on my roof. I assume they're keeping down my rat population, which I appreciate. So I think, too, that the animals have learned to adapt. So both us humans in the Arrowhead neighborhood and the animals have adapted to the current culture in the area. Thank you.
Thanks, Ms. Carter. All right. Elizabeth Mooney. Ms. Mooney, did you want to say anything more? And after Ms. Mooney is, I think that's Mary Ratliff.
Macy Ratliff had
Macy.
to leave.
Okay.
But I know that one of the items that I have here to submit is a petition that she and I did put together, so I can submit that as evidence.
Okay. Did you have any copies of that, or just?
Yes,
Okay.
yes. Can I bring it up there afterwards?
Yeah, sure. That's
Okay. Great. So I'm trying to stick with the site plan criteria, and that's hard for me to maintain. I look at you because you have it right off the top of your but so in terms of consistency with the Kenmore Code and potential site improvements that would be consistent with me talking at a site plan hearing. That was what I think I'm trying to remember how to fit my comments into that. So, number one, what would be more consistent is if the city was not piggybacking a artificially lighted turf ball field into just to confuse us assessing the Daniels standalone seminary project. That has completely confused the process. And I do have an email that is from one of our council members, one of our citizens, that addresses trying to have the city council hold back their development agreements and zoning agreements until the ball field, the artificial lighted ball field, is approved, which for me is just unfair. The whole process sounds horrid, and that's all special interest Little League promoted. Now, the point of that is that it's really hard to discuss the site plan and make comments about the seminary building and its impacts without knowing that that is happening in the background. And even as recently as Monday, this is another exhibit, but I can explain if you need to, there was an agreement made and accepted by council whereby Parks, Daniels folks, and the city are in a confidentiality agreement, which seems on the face of it that the public will not have as much transparency. And ultimately, and I've even mentioned this to Mr. Daniels even as late as this morning, my purpose is that the site is not appropriate for his hotel unless he takes on essentially a where you protect the environment. So leave no trace as like his mission, or once he's gone, because 62 years from now, he might not be here. And so the project itself needs to have a leave no trace. So one of my letters, okay, so I'll start with just a list that comes from one of the women who's in the audience of just the animals to protect. I completely feel that the biological assessment is consistent with the site staying the same flavor of peacefulness and sanctity. So if the building is an old seminary building, keeping that and its cultural significance includes everything around it. And if Mr. Daniels is not protecting it, and that's not his job, then he needs to employ somebody like Susan Carlson. And Susan Carlson, or myself, I'm president of a nonprofit and local. Susan Carlson gave, and I have evidence of this, Susan Carlson gave a whole PowerPoint at a park commissioners meeting about having an environmental learning center there, which would require the people to have free traffic, free parking there. So the 2,000 square feet that has been allotted in the park's lease is, in my opinion, certainly insufficient to help Mr. Daniels Hotel protect that peacefulness, which is consistent with what we have right now, and it seems like everybody loves. And in fact, the whole heritage issue about the building, which he is promoting to protect, and thank you as architect, but that was brought about by one of our friends who is not here for the express purpose of protecting the deer, the bird habitat, the ospreys, the eagles, the garter snakes, the hummingbirds, the squirrels, the chipmunks. Oh, sorry. I'm so sorry.
Hummingbirds.
Deer, barred owls, bald eagles, pileated woodpeckers, herons, beaver, rabbits, garter snakes, hummingbirds, squirrels, chipmunks, frogs, salamanders, butterflies, bats, and this does go to the site plan. There are endangered Chinook salmon at the shoreline, and they need to hug that shoreline in order to live. And so everything that happens up at the site, and I listened about the water and the mitigation, and that's all great, even if Mr. Daniels does all that. But if it's not partnered with an environmental steward that has as their mission leave no trace and teach from this facility, the hotel, then it won't be sustainable. And whether that takes 5 or 10 or 20 years, there won't be any more of these animals, because if just right off the bat, the city's going to take the darkness. And that's what Macy was going to talk about. The darkness in that little ball field never was a artificial turf focused on Little League and active sports that go on past dark. And by the way, there was somebody who testified about the project for Mr. Daniels who stated that their assumption was that that ball field that the city is proposing is mostly during daylight hours. That is absolutely not accurate. The city is proposing artificial light to extend at least till 10 p.m., and that will kill any bird, any amphibian that requires a change in lighting, where there's darkness in the winter and more light in the summer. And if they don't have their circadian rhythms fixed up with their pineal glands, they die, they cannot breed, and that is not in keeping with the site plan criteria that have to do with the spirituality of that park. I met Mr. John Roman, is his name, last Sunday while Macy and I took around this petition, which we only started 2 weeks ago, to even the playing field of the Little Leaguers who started in 2015 to lobby for the artificial turf ball field to piggyback onto Mr. Daniels Hotel. Mr. John Roman, he was a seminarian student there, graduated in, I think he said, 1947. He said he played on the ball field, but it wasn't artificially lighted, and he's a peaceful, you know, his memory of that site is that it's a peaceful, spiritual place of learning. So if Mr. Daniels can keep that, it's not going to work with what the city has added onto it. So instead of having 1 + 1 = 3 as a positive thing, I think what the plan is here that we can't separate easily is that 1 + 1 = 3, but they have made me unsupportive of Mr. Daniels' project because the city, in a testimony in Lacey last month, maybe it was January, went all the way down there with Macy and other people, and our city said that Mr. Daniels is supportive of the city's artificially lighted Little League ball field. And then, contrary to that, park staff said Mr. Daniels is neutral on any project. And then, in asking over the phone whether Mr. Daniels' staff member thought that he was supportive, she said, and I've already told him this, but she said, well, he's supportive of anything that the city wants. And my point is that this is so confusing because the city has essentially a conflict of interest, and part of that, I think, has to do with this agenda item F that was okayed by City of Kenmore on February 27th, which is authorizing and executing Contract 17 C1658 Common Interest and Confidentiality Agreement between City, State Parks, and Daniel Real Estate, and ratify and confirm acts consistent with the agreement taken prior to approval. And that just seems like they're going to get to talk, and we're not going to get to know what's going on. So I think some of the pieces of paper, this is something that a woman named Judy pushed that is yeses to the ball field as it exists today, but no to what the city is trying to slam into the park right next to the hotel. I can provide you with that. These are copies that show what Susan Carlson proposed in a park commissioners meeting that have other examples like the Schoodic Institute and what is possible at St. Edward Park. Yes, there's lots. There's kokanee that could potentially come up the streams, but you're going to need to have more than 2,000 square feet in that seminary building to have an effective program. Ecotourism, as a possible alternative, instead of just promoting profit-making hotel, guests, if he were to promote ecotourism, leaving no trace, like is consistent with Harriet Bullitt's Leavenworth Sleeping Lady, maybe that would be an idea that would seem consistent with those site visit issues. Let's see. I've got one letter that I could just submit without having to say it, but in the habitat conservation element for the city, it says the principal condition for Kenmore is its natural environment. Consequently, the city recognizes that natural areas and open spaces are essential to the health, quality of life, and the vitality of our community. These areas not only affect city residents, they also have profound effects upon those who visit and work inside the city. These natural areas are often part of a broader system that affects our neighbors as well. One of the key values for the city is the notion of stewardship, which is an ethic that embodies responsible planning and management of resources, including those within natural systems, protection, conservation, enhancement of environmentally sensitive areas, including the city's 3 major habitat areas, is one of the city's 7 major goals. The 3 that they mention are Wallace Swamp Creek, where our city council member tried to put an artificially lighted turf field in 2007. The second that they mention is Squires Landing. The third is Swamp Creek. and Inglemore wetlands, and then they add, so it's not even included in the three things that the city is supposed to protect. The largest publicly owned natural area in Kenmore is contained in St. Edward Park, and contains 274 acres of nature park within the city and approximately 3,000 lineal feet of shoreline on Lake Washington. This just is another issue that has to do with the injustice here to try to protect the habitat around his seminary building. And that is that the city staff, the park staff worked out a deal with the city whereby the harm that will come to their proposed transformation of the little grassy ball field with wetland and streams, they'll mitigate by writing a grant to protect the shoreline, but only if the city gets their artificially lighted ball field. I told the city staff, Ann, as well as the park staff, Michael Hankinson, that our organization, PERC, People for Environmentally Responsible Kenmore, would be eager to help with writing and helping with a grant like that. And they said, well, no, that's only if the city gets their ball field, their artificially lighted ball field.
Grounds that that's hearsay and not based on firsthand personal knowledge of Ms. Mooney?
Oh, that's definitely based on firsthand.
It's overruled hearsay
Oh.
admissible on the list.
Oh, it's still
Are you almost
hearsay.
done, Ms. Mooney, by the way? Or just,
Yes, yes. I
let
will
you go
now
way
just.
over 5 minutes, but
I know.
I'm doing that because my plan was to allow people to submit written testimony if they couldn't do it in 5 minutes, but that's
So-
not
I know, I'm
allowed, so
sorry.
I'm being a little more
It's-
generous with the time.
So I will give you, this is a woman, Judy, who sent me this, who worked about the ball fields. It's 60-plus ball fields in a 5-mile radius of Kenmore City Center. They don't need an artificially lighted ball field. This is the email from Brent Smith and Doug Levy and to Stacy Danuski and mayor and city council members about, we urge you to take advantage of this opportunity to integrate the ball fields into development agreements and zoning agreements you will have to approve in order for Mr. Daniels to get the go-ahead. We know from Kevin Daniels that while he's not going to want to be the financier of a ball fields upgrade, he fully understands and even expects to see the city weave this in. That was a little disappointing to read. So here, I believe the worst thing is that Daniels and the city has been public about approving anything that the city wants, which includes an artificially lighted turf Little League field to replace a naturally dark, grassy bird habitat suited for more than just Little League noisy light adventures. Since Mr. Daniels refuses to take on the leadership of environmental protection and instead, despite my imploring him to work with me, only looks forward to the renovation of the seminary building and its inappropriately large, unsustainable impact on its natural surroundings, it is a bad plan at the moment. I should be optimistic. Adding on the city's ball field makes this whole site plan a death by 1,000 cuts. The EIS addressed cumulative impacts but ignored the environmental impacts of the seminary on nature, only addressing the cumulative impacts of the selfish seminary's parking upon the selfish city's artificial lighted turf field parking. It's abuse of nature. It's bullying if you're an amphibian. It is special interest. It is rich profit-making venture at a public park. I'm thinking optimistically, having talked to Mr. Daniels this morning. But anyway, I hate the fact that Daniels is aiding the city by doing a allegedly, I should ask, by doing a tit-for-tat development agreement zoning change and trade for the artificial ball field support. The evidence is sketchy at best. But the email from Doug Levy, discovered, I think, by another citizen, suggests it might be a factor. You know, can we change this? I want the bird habitat to remain, the wetland to be preserved, the stream to be protected, consistent with the flavor of the seminary building in its culturalness. For that to happen, the site must not allow so many cars to come in and out, and the mission of any entity at a newly refurbished seminary hotel conference center would have to be an environmentally friendly one, or else the natural habitats will dwindle at exponential speed thanks to noise, traffic, artificial light, more humans drinking, eating, reveling in a hotel conference center setting with alcohol as a main attraction. I'm not against alcohol per se, but I am against losing the natural atmosphere that supports wild animals who must have a habitat with natural darkness. I am against a passive-aggressive steward whose profit-making venture lets his profit trump protection of the environment and the bird's habitat. How can we solve this? Look to Susan Carlson and other folks like that. As an environmental community leader, I have reached out to Mr. Daniels, and up to now, he has never agreed to work with me to stop artificially lighted ball fields. He's focused, understandably, on a building. And as the building's manager, he must, in my opinion, make it his duty, if he is to host a hotel and refurbish a seminary, to protect to his highest degree possible the nature at the park that surrounds the building. If he were anything like Harriet Bullitt at the Sleeping Lady in Leavenworth, I would trust the system more than at present.
So you read that one. That one doesn't need to be admitted as a separate document. But you had other ones there, which I think you were saying addresses your belief there's a conflict of interest on behalf of the city. Now, as I mentioned before the hearing started, Ms. Mooney, when we talk about alternative uses of the site, that's beyond the scope of this hearing. So I don't see how that's relevant to the site plan criteria, really, when you're talking about other things that could be done with the property.
I've heard that the lease includes 2,000 feet of space, so I was wondering if it would be possible to increase the 2,000 square feet of the 90,000 square foot building to have it house more of a program that would be an environmental education program that's part of his hotel.
Okay, all right. So you're talking about adding to the space. Okay. All right. So do you have the documents in?
Thank you.
Oh, thank you. Do you have the documents you wanted to get in the record? Okay, great.
Mr. Examiner, this is Amit Ranade for Daniels. I just want to note for the record that the ball fields project is not at issue here. This project has nothing to do with the ball fields. We will offer testimony on Daniel's formal position on the ball field, but that's not what's at issue here, and so we object on relevance. I understand you're inclined to let folks talk, but I want that in the record.
Okay, I understand, and I think to the extent that Ms. Mooney was linking the ball fields to a conflict of interest on behalf of the city, I mean, she's entitled to her opinion on that, and it does address the credibility of the staff recommendation and the weight to be given to it. So, like I say, that's not any comment on the merits of that opinion. It's just on the relevance, and so I would admit that for that purpose.
Oh, Mr. Examiner.
Pardon?
I'd like to say that the city objects strongly to the introduction of any of those documents as exhibits, except for I understood there was a petition from people supporting or opposing the project. We would object to everything else, which is irrelevant, among other things, but there are a number of other reasons why those are not appropriate to be putting into this record for the site plan application.
All right, no, I understand, and like I said, I'm not commenting or making any conclusions as to the merits of the allegation of conflict of interest, but that's my understanding is that the ball fields are discussed for that purpose. So I'd overrule the objection and admit these documents. I think we need to let the parties take a look at these to see if they have any more specific concerns than what was already raised. So,
if we could just, whatever's submitted, maybe get copies over the lunch break and we can address it afterwards.
Okay, yeah. So Ms. Mooney, your documents are provisionally admitted. I mean, they will be admitted unless there's an objection raised later, and I rule in favor of the objection. That's to give an opportunity for the parties to review the documents. So I'll put that aside, and we'll get copies for you so you can take a look at it specifically. All right.
Mr. Examiner, I do have a couple of questions I'd like to ask Ms. Mooney about her educational background and professional experience.
Sure, yeah.
But if she is willing to confirm or stipulate that she does not have the education or relevant experience or background to prepare professionally, to prepare professional habitat or wildlife assessments that relate to the impact of projects or elements of the environment on animals, then I don't need to ask her questions about her background.
Okay. So did you understand that, Ms. Mooney?
Actually, no.
All right. Well, Mr. K, you can just
Do you have the
explain to her.
professional experience, educationally or otherwise, to prepare habitat assessments or wildlife assessments?
As a volunteer, I have...
My question.
Oh, okay. So you're asking me if I'm a professional habitat assessment.
Based on
well, I have
background in education.
I have a master's in fisheries from the University of Washington, and I have a BS in zoology from the University of Washington. I've been a volunteer by choice and an at-home mom fulfilling grant writing for a stream adoption project at Lockwood, which was successful. And as president of PERC, we received a $10,000 grant for an interactive map about Lake Washington. But I've chosen to be an at-home mom and serving the community. But yes, I could definitely help. Okay.
Have you ever prepared a habitat assessment or a wildlife assessment for a governmental agency for pay?
I have prepared I've been part of an ecosystem model at the Marine Mammal Lab back in 1982 that I was paid for that had to do with Bering Sea ecosystem modeling for fisheries and marine mammals. It led to a research paper about Pribilof Island lactation quantified food web kind of stuff. But then I had my baby, and then I became a volunteer.
A long time ago. Would you admit that's a long time ago?
Absolutely.
Have you prepared a habitat assessment or a wildlife assessment?
No.
For pay or for a governmental agency in the last 10 years?
No.
Okay. All the questions you have, Mr. Kesky? Okay. All right. And Ms. Mooney, the parties will be addressing your exhibits after the lunch break, so if you want to have any input on that, obviously come back after lunch. And
may I replace the one little, the petition has some scribbling on the bottom. Okay.
Just make sure we get your final exhibits to me before lunch starts, and then we can make copies for everybody. Thank you. All right. Let's see here. Next was, my understanding, Macy Ratliff is not here, just to confirm. Well, no Macy Ratliff. Okay, Ann Anderson, and after her is Carl Michael Mitchellman, and that's the last I have in the sign-in sheet. And like I said, if there's anyone else who wanted to speak, obviously, I'll certainly let you come up. And we will, I think after, well.
I'll keep it brief. Okay.
Yeah.
Hi, Ann Anderson.
And you've been sworn in, Ms. Anderson.
Yes, thank you. I just had a quick question. You had mentioned when we were talking about parking that there was a tree plan. And from working with the city of Kenmore, in my opinion, tree plans are often an afterthought. And there's no regulations in the city of Kenmore to save old growth trees. And, we all know that replacement trees are no replacement for old growth trees. That's what makes Kenmore and Washington State very special. So I would like to see the tree plan and not hear like, oh, I don't know where it is. I want to see it. Because it's all tied together. It's all one project. And we are in a state park. And and we got to do more than just care about trees. We need to see the plan.
I got to ask, I don't recall from staff, is there a tree plan on this one, or I don't recall what was done in that regard?
There's an arborist report.
Okay, and then I would like to share it, please, with the hearing examiner, please.
The tree inventory and arborist report is Exhibit 40 in the record.
Okay.
Okay, and then how many trees will be cut down? Can we look at that?
I'm not really an appropriate person to testify as to the contents of the...
That's my point.
I'll certainly be looking at it. So.
Okay, thank you. Thank you.
Ms. Anderson. All right, Mr. Mickelman or Michaelman. Was there anyone out after Mr. Michaelman who wanted to testify? Like I said, I've been through the list. So we'll take Mr. Michaelman's testimony. We'll go on break, and that'll give an opportunity for the other parties to take a look at Ms. Mooney's exhibits, and then we'll deal with any objections to that when we come back. And then we go to staff rebuttal, applicant rebuttal, and then from there we jump into the SEPA appeal. So, Mr. Michaelman, go ahead.
Hi, my name is Carl Michaelman, 18023 62nd Avenue Northeast here in Kenmore.
Have you been sworn in, sir?
Pardon?
Have you been sworn in?
Not that I know of.
Let's get you sworn in then.
Sure.
Just raise your right hand. Do you swear affirm, tell the truth, nothing but the truth in this proceeding?
I hope so, yes.
Great. Okay.
Okay, I just came because it was public comments. I am a resident as well as a local businessman here in Kenmore. And what's happening is I also chair the Kenmore Business Alliance, which is a bunch of businesses that are here in our community. And it's brought to you by the Greater Bothell Chamber of Commerce. And that we have endorsed the Daniel Group and the St. Edwards Park for this really nice building to be restored. The thing is that with the park system, they want people to come to the park. And what's happening is with the Daniels Group, it will definitely bring more people within the city or the community here, as well as will bring people from Washington State and all over the country that will make this a landmark. I've been going to a lot of the hearings on this, and even when the Archdiocese gave the park and was dealt with, they wanted all the people to enjoy the building. The thing is with that building is what's really important is the state does not have the money to pay for restoring it. They also don't have the money to tear it down. And what's really important is that Kevin Daniels has come to the table to make this happen. And it's really not going to change the outlook of what the Archdiocese wanted to do. They wanted these people to enjoy the building, to enjoy the park, and this is a win-win situation for the community as well as for the state of Washington. So I just wanted to give you a little bit of my opinion. Again, we endorse this from the Chamber of Commerce, and we also endorse this with the Kenmore Business Alliance. This will be a very prosperous and a good thing for all. Thank you.
Okay, thank you, sir. All right. So last call for any other members of the public? Okay, then I'll close the public hearing portion of, or the public testimony portion of the hearing. Ms. Mooney, please get your proposed exhibits to Ms. Baker sitting there to make copies for the parties. And we'll take a lunch break now, and when we come back, like I said, in let's say 12 or 1:35, we'll deal then with the city's rebuttal, applicant's rebuttal, and then it's on to the SEPA appeal. Okay, we're back on the record for the Lodge at St. Edwards site plan application, FEIS appeal. It's still March 1st, 2017. We're at 1:35 p.m. after the lunch break. And to start off, we just had a couple exhibits to deal with. One is, actually, I see someone marked at 45. 45 is the public comment letters that were submitted into the record this morning, the 7. So if it's... Yeah, so this one is actually 46 would be Ms. Agard's comments. Just any objections from the parties? I take it they've had a chance to look at what she put together at this point. And any objections? Hearing none, then Exhibit 46, which will be the compilation of Ms. Agard's documents, and I believe I went through them before the break, so we'll just say that's admitted. Exhibit 47, then, I take it that one is probably going to raise more eyebrows. This is from Ms. Mooney. Is Ms. Mooney here now? Or? Oh, she is. Okay, all right. So any objections from the party? I mean, I already noted the objections you've already raised on the basis of relevancy and whatever else you said back then. Any other objections on this one?
Yes, Mr. Examiner. The city would object to the acceptance of... It's an email from Brent Smith to Doug Levy, which responds to an email going the other way.
Okay.
But we have no objection to the diagram and the rest of this packet.
Okay. And what's the basis of the objection then on the email?
I'm sorry?
What was the basis of the objection on the email?
The basis is that's not relevant to the issues before the hearing examiner on whether or not the application meets the requirements of city code.
Oh, okay. Ms. Mooney, you can respond to that. I need you at the microphone there. I'm just trying to refresh my memory as to, that's the one you read the whole thing, right? Yeah. Okay.
So the objection was based on
Relevance.
its relevance.
Yeah, to the site plan criteria?
Do you mind listing the site plan criteria in, I'm sorry.
Sure. It's conformity with city regulations, compatibility with character and appearance of the surrounding area, compatible with
that one for sure. Just because I won't remember them all, the compatibility of nature is definitely a big one. That I would say that email shows that the city is waiting and has been waiting and has been advised to wait by a citizen who is a lobbyist, so it's crafted in a professional manner, well before people like Macy Ratliff, who cares about nature more than active, noisy, trafficky Little League. It violates that provision, or because it implies that our city council member, Ms. Danuski, was impressed by the numbers of people who had written in support of the Little League artificially lighted ball field. And that was well before people like me knew that was working in the background. And
so, when I remember you're saying, Ms. Booney, you're saying that this is kind of evidence as a conflict of interest, and that the city might be more willing to accept this proposal because they want to get the ball fields in place. Is that?
Yes, definitely. I know that I was not allowed to talk about the lead agency issue because you had dismissed that.
Yeah.
But yes, it's that the city sees economy, and one of our city council members thought it was a good idea, and I think it impacts directly, negatively, and significantly nature, and also the people who appreciate the existing sanctity and peacefulness. Even mental health gets involved there.
Okay. All right. Well, I'll respect your First Amendment right to express your opinions as they relate to the project, and like I said, this is no comment on the merits of your belief in a conflict of interest, but it's relevant. So to the partiality of staff support of the project and that kind of thing. So I'll admit it for that reason. All right.
Thank you.
Mr. Examiner, just for the record, I know you've already admitted, but I want it on the record that we also object to this email on hearsay grounds. It's attempting to paint a picture of Mr. Daniels that is not his words. So I just want that on the record.
Okay,
I know you're
understood.
admitting.
Yeah, and that's noted for the record and overruled, but yeah, I understand. All right. So now we can, I think, we're ready to move on then finally to the staff rebuttal, if any, for the comments that were made at the site plan hearing portion of this proceeding.
The city would like Brian Hanson to comment on or respond to a comment regarding a development agreement that had been discussed during this process. It should be very quick.
Yeah, it should. This is Brian Hampson, Development Services Director. The email from Doug Levy was prior to the applicant making an application on the site. The previous developer was thinking about doing a development agreement, and as such, a development agreement requires a public benefit as a trade-off. And the previous developer was talking about a possibility of putting in some ball fields as a development. And so I think the email chain that got circulated was prior to the actual application being known, the process being known, and applying for.
Okay. Is that it from the city then? That's all. Great. Okay.
That's all.
Final word on this part of the
Yeah,
hearing?
we do have just a couple rebuttal arguments. We think that some of the testimony that will be brought out this afternoon will also be relevant to rebutting these. So I'll just kind of note that as we go along. But for time and efficiency's sake, won't call people up right now. So there seems to have been an allegation that the project doesn't comply with state law because there's some inconsistency with the state parks regulations and the lease approval. To the extent that that is an allegation that's on the table, of course we object to that. We think that the state parks process was appropriate and proper, and that decision has been made and it wasn't appealed at all. And so I know that state parks can speak to this issue more, but we would just note that for the record. Again, you've heard from testimony this morning from Kevin Daniels and from Trevina Wang that the ball field proposal is not part of this proposal. And so to the extent that there are objections about the ball field proposal, those should really have no relevance here. We know that the hearing examiner is obviously allowing it for this conflict of interest issue, but they're separate proposals. They're on separate tracks. The only commonality they have is their location and adjacency to one another. To the extent that there is some objection about the size of the Environmental Learning Center, again, this is a proposal for a hotel and accessory uses. Kevin Daniels testified to the fact that there is some space in the building that is going to be reserved for parks programming. We don't know what parks will program in that space, and that's not part of our proposal. Next, there is some contention that there might be some impacts to salmon, as will be brought out in the EIS appeal. There are impacts disclosed in the EIS, and there are mitigation measures that are identified. One of those mitigation measures is compliance with the Stormwater Design Manual. And as Tim Brockway testified to, the intent of that Stormwater Design Manual is to make runoff conditions better. So we want to note that for the record. Finally, there is some contention that certain elements of the cultural landscape can't be removed, or doing so would be in violation of the Secretary of Interior's standards. The Secretary of Interior standards are flexible guidelines for adaptive reuse projects, and so we'll be having our project architect address that issue further during the site plan appeal hearing. Thank you.
Okay, great, thank you. All right, then, we're now moving. Oh, sorry, Ms. Ball. I'm not used to having both an applicant's attorney and a property owner's attorney. That's pretty unusual. Obviously, nothing wrong with it, but that's why I keep forgetting that you're.
Yes.
So go right ahead.
We'd like to keep you hopping here.
Yeah, that's good. Yeah.
I would like to call Jessica Logan as a rebuttal witness to the citizen comments.
Yeah.
It'll be very brief. Ms. Logan, were you sworn in earlier?
Yes, I was.
Could you please state your name and your title for the record?
My name is Jessica Logan. I'm the Environmental Program Manager and SEPA Responsible Official for Washington State Parks.
So I would just like to ask you a few clarifying questions. I know that there was some confusion in the public comment regarding the difference between the appeal of the SEPA issue and the Type 4 site plan, so there may be some overlap with your testimony later. The first thing I'd like to address is the lease that State Parks entered into with Daniels. That is Exhibit 43, Mr. Hearing Examiner. And both Ann Anderson and Ann Agard's testimony mentioned the removal of trees. In the lease, on page C-3, paragraph 3.c, it states that tree removal will be consistent with state park policies. Is that State Parks' position?
Yes, it is.
And then Elizabeth Mooney raised some concerns about the ball fields proposal. Is there currently any proposal for the ball fields in front of the Parks Commission?
No, there's not.
Elizabeth Mooney also raised some concerns about parking and the Nuns Garden. Mr. Hearing Examiner, core document number 19 is the DEIS, and in Appendix G on page 3, Figure 1-2, there is a map. It is very similar to the second map that is up on the big sheets. I would just like to ask Ms. Logan to go to the large map and to explain, describe for you the location of the parking, the location of the Nuns Garden, and whether there is any impact from the parking location and the location of the Nuns Garden. Would it be okay if she approached that exhibit?
Yes, of course.
Thank you. And then my final question for you has to do with Ann Agard's exhibit that was an excerpt from the National Park Service's August 2006 Cultural Landscape Inventory. Could you just describe what that is and what role it provides to the Parks Commission?
Sure. State Parks sought advice and recommendations from the National Park Service in the form of that report. That report was intended to inform us about our cultural resources in the park so that we would better understand what we were working with. The report also includes treatment recommendations that we can employ. There's no binding, there's nothing binding in that report.
Thank you, Ms. Logan. I have no further questions.
Okay, thanks you, Ms. Welling. Was that it for the state parks then? Okay, great, thank you. And again, I apologize for skipping over you that time. All right, now we'll move on to the SEPA appeal portion. Let's start off just by, hold on a second here. Yeah.
We're going to need to readjust a couple positions.
Oh, for
just
the
need
table?
2 minutes.
Oh, sure.
Yeah, can we just take like a 5-10 minute break because we've got to switch people up.
Oh, do you? Okay.
Yeah.
Okay.
Switching out.
All right, let's do a 5-minute break then, or switch around. And we wait 5 seconds, so we're good. Okay. All right, so back on the record on the St. Edwards SEPA appeal and site plan application, CSP 160077. It's March 1st now, about 1:55 or so. Just got back out of a break. So we're into the SEPA appeal portion of the hearing. Let me start off first. A quick disclosure. Ms. Rebecca Hurt came and talked to me during the first break and asked, how she could present her evidence, whether she needed to do it in a question and answer format or whether she could have her people just talk. And I said they could just talk. If you have a problem with that, you can object when she does it. But from what I recollect, some of the previous testimony was done that way as well. Also, just kind of with an apology to Mr. Casaguma, as you all know, I've been issuing orders on almost a daily basis the last week, and by the time I got to Mr. Casaguma's brief last night, I didn't realize it, but he had a bunch of requests for dismissal as well. And at that time, it was I don't think an order at 2 in the morning would have been much use to anybody. But I think all of your dismissal issues, Mr. Casaguma, were covered by everyone else already, I believe. But if anything comes up, that it pertains to an issue you sought dismissal on and it hasn't been addressed already, obviously feel free to object at that time, and then I can address it. I looked them over, and as I said, it looked like they pretty much the same as what everyone's pretty much objected to everything they can, it seems to me at this point. But
and I can clarify my intent.
Oh, okay, sure, yeah. All right. And Casaguma?
Yes, and if I could clarify, I did not intend for the words, the issue should be dismissed or the allegations should be dismissed to be a motion, formal motion before you. And the argument is that the arguments themselves, the assertions themselves, should be dismissed and rejected.
Okay, all right, good. And one thing I did clarify, I think it was in the last order I issued, was the applicant's arguments on another motion. It became clear to me that in their first motion they were not asserting that a bunch of dismissal issues should be dismissed because they cited the wrong provision of the Washington Administrative Code, but rather that they were dealing with threshold issues for FEIS adequacy. And I mean, I do agree with the applicant's position on that. We're not here to talk about past procedural issues. We're here to talk about the substance that's in the final environmental impact statement. So, and from all the documents submitted by the appellants, I don't think they were pursuing those threshold issues anyway, at least at the procedural level. So, but if that comes up, obviously objected. If they're raising those procedural issues again. Then finally, on the alternatives issue, which I think is one of the more complicated ones in this case, as you might recall from my order, I mentioned that that the FEIS, it's unclear from the record whether the FEIS was intended or legally could be used for the Washington State Parks Commission in its final decision making. And of course, that's pertinent to the issue of alternatives, that in the sense that, the FEIS may not have alternatives in it that would be of benefit to the council, but if they're of use to the Parks Commission in their decision making, then maybe it's valid to argue that they should be in there. One thing I hadn't realized when I wrote that order was that the lease had actually been approved, but it's still unclear to me what final decision making is left to the Parks Commission. I would imagine there's some contingencies in the decision-making process where if the site plan is significantly modified as a result of this review process or denied or something, that some final decision-making is still to be made. So anyway, if I get some clarification from that from the parties as we get through this appeal, that would be helpful as well. So I think that covers everything at this point. Any questions? Or I mean, I laid out the format of the appeal hearing in my order, and the appellants should know that you're first, so you can go ahead and make your presentation at this point.
Okay. Well, it's up. I am Rebecca Hurt, and it's nice putting names with faces since all these emails have gone out. We're here, and people, there's been a lot of writing about why we're here, not from us, but from others. And we're concerned about the project and how it fits with the management plan, as that is still in state, even though I'm not sure how much that's being honored. I have some questions. And then the outdoor recreation and how this will impact outdoor recreation, especially in the core of the park. And, of course, the historical parks are culture that's been established over the 40 years it has been a park. I have lived in the area for...
Mr. I don't want to interrupt you, but you have been sworn in, right? You're getting a testimony. You've been sworn in, correct?
No, I haven't.
Well, yeah. Before you start testifying, then, do you swear? Stand up and raise your right hand.
Okay.
Yeah, thank you. Both of you, then. Yeah. Do you swear and affirm to tell the truth, nothing but the truth in this proceeding?
I do.
Okay, great. Thank you.
Okay. Thanks for catching that. Anyway, I've lived in the area for almost 44 years. And I was around when the park was being discussed. I went to many public meetings, so I have a long history with St. Edward State Park and do know the park and the purpose for which it was purchased and all of the history of it. And although I did learn a couple of things that I missed when I was busy with young children. But and other things in my life. But I have used the park, and I am a park user. My children, of course, have used the park, and now my grandchildren and my husband. So we have our park pass and go often. So that's kind of gives you an idea that I do have some history with the park. I've been a member of the Friends group. I was one of the ones that helped start it. I helped keep the pool open for a couple of years because I'm elected hospital commissioner at Evergreen Health, and we use tax monies to support the pool to keep it open because of all the elderly people who came there to swim, and also some patients with MS and other crippling diseases, and that was a good place for them to come. The pool was warm. So anyway, we used it as a community benefit. Couldn't do that every year, but we did that for about 3 years and supported the pool, which really benefited the city of Kenmore and the whole region. So just wanting to give you a little history of my involvement with St. Edward State Park. And I'm still on the board of Friends of St. Edward State Park. So anyway, I would like to call Tracy Hendershot as our first witness. We had 5 listed. One has had to leave, and Elizabeth Mooney's already spoken, and she decided she wouldn't speak for this one.
Okay.
She deferred to Dr. Bain.
Okay, great.
I have been sworn in.
Pardon?
I have been sworn in.
You have been sworn in, okay. And I think the parties already know this from my pre-hearing order, but just so you know, again, all witnesses are subject to cross-examination, even non-experts. So
Yes.
just so you know, that's coming.
Okay. I'll try to be ready for that. So I thank you, Hearing Examiner Obrecht, for listening to me today. I appreciate that. Do I need to spell my name? Okay. Tracy, Tracy, Hendershot, Hendershott. Okay, great. I live near downtown Kirkland and approximately 7 miles from St. Edward State Park. I've walked on the trails of St. Edward State Park through the Home of Wildlife for 19 years. Can everyone hear me okay? So I've been told I get too close to the mic, so let me know.
The mic's picking you up.
So over 1,000 hikes, over 4,000 miles, over 800,000 vertical feet in total on the trails. I've taken photos of wildlife on occasion, and some of these photos are included in my pre-hearing brief comments. I've seen mountain beavers, barred owls, and many other species there. Some particularly sensitive species I've encountered at St. Edward State Park are bald eagles, great blue herons, and pileated woodpeckers. And I have photos with me today that people can view that I could submit if you want, but some of them are already in my brief. While I feel that many of my comments regarding the effects of wildlife from the construction and operation of the Daniels Lodge were responded to in an unsatisfactory way in the FEIS, I feel one concern in particular was not really addressed at all, and that was the negative effects on wildlife by night trail use. Currently, the park is closed at dusk, as is indicated by a photo of a sign that I have in my pre-hearing brief. At night, wildlife gets a respite from most human activity at this point. The operation of the lodge would lead to trail use by hikers and bicyclists with accompanying noise, lighting, flashlights, bike lights, headlamps, and the physical presence of people on the trails. There is evidence that these effects can result in animals changing their behavior, being displaced, competing for nest sites, interrupting their eating and sleep, changing their breeding behavior, and making them more susceptible to being killed by predators. And there are other effects as well, like the circadian rhythm things that were mentioned before. 2 references, one regarding the effect of night lighting on plants, fish, and wildlife, and another reference regarding night trail use effects on wildlife are in the pre-hearing brief. Great blue herons are reported to be highly vulnerable to human activity, as in an article about them by a senior environmental planner for the Washington Department of State and Wildlife. I have a copy of this article today. If it's okay if I offer it to you, I will. If it's not, that's okay too, whatever you decide. I didn't see any assessment of the great blue heron in the FEIS. I have photos of them on trees that are attached to the beach down at the shoreline of this park. Pileated woodpeckers are a priority species for the state, potentially a keystone species. A keystone species is a species that is uncommon and plays a critical role in functioning of the ecosystem. They benefit other species like insects, amphibians, birds, and mammals. Because of this, their habitat deserves special attention. I realize that the Watershed Company, in their June 2016 report, found no active bald eagle nests in the park, and one nest mapped there in the past outside of the construction zone. Bald eagles are protected under the Migratory Bird Treaty Act and the Bald and Golden Eagle Act still to this day. While swimming in Lake Washington along the park's shoreline, I have seen bald eagles on multiple occasions picking up fish and landing on the trees in the park. With disappearing habitat, I think it's good to keep in mind that the bald eagle could potentially nest in St. Edward State Park again in the future. A concern I also mentioned in my comments in the pre-hearing brief is that we currently have part-time park ranger coverage at St. Edward State Park and no on-site nighttime ranger coverage, as far as I know. I feel that if this continues and Daniels Lodge is built, there will be less enforcement of illegal trail use and activities that may harm wildlife. I don't have any power to change this, but I feel like the EIS should lead to protection of these animals, including their offspring, their homes, their environment. I feel they should not have to adapt to the unnecessary invasion of their home at night. I don't think any of us would want increased visitation, lights, and noise to invade our neighborhoods consistently at night. I also feel that frequent trail walkers like myself have the visual, auditory, and physical presence to get good information on the existence of wildlife in the park. And I feel it is my duty to speak for the wildlife who cannot make comments and attend meetings. I feel like we know there will be effects on wildlife from human activity. No one knows all the effects, not even the experts, but we can be assured that there will be a change in their world from our noise, lighting, pollution, and physical presence. There's already human activity during the day affecting wildlife. This park is not the place to add effects at night, too. I hope there will be additional EIS coverage of these issues to do justice to the welfare of all wildlife in the park. Based on the issues in my comments and the pre-hearing brief, I personally feel development does not belong in this unique park, which has I think it's the only undeveloped shoreline in Lake Washington, maybe in addition to the McDonald property next door. And that's my comment, and I don't know if I could add anything or not regarding information I heard today on the parking lot. That this is not part of my witness statement. So,
I think probably leave that to you. Have someone who's going to be addressing parking, right?
it's regarding wildlife connection.
Go ahead.
Yeah, I commented on this in my comments to the DIS that I was against the cutting of the Doug firs and the cedars for the alternate one parking option. And I'm just hearing today, because I had heard that alternate 2 was passed, and now I'm hearing maybe alternate 1 was passed. And they are wildlife homes, and they are significant, and some heritage trees. A lot of them are in good shape, and I just wanted to have an objection to those trees being cut. I live in Kirkland. We have a tree ordinance, and I know a lot about the tree ordinance. And I'd like to see the same happen in the state park. And to remind the Daniels Real Estate that if the trees are cut, there is still the Migratory Bird Act, and they really are not to be cut during nesting season if there's an active nest in the tree. So anyway, that's my comments at this time.
Thank you. Go ahead. You had questions, Ms. Hurt? Okay.
Well, because I stated things in very general ways, there were so many answers to things that were vague, like not significantly affecting things and that kind of thing, that I didn't respond in particular in detail to these things. But I do object to that kind of language because I don't think anyone can know that kind of thing. Yeah, not significant. There were several. Maybe there's a definition of these things somewhere that I haven't seen, but I just couldn't get. I couldn't understand what that meant. Yeah. Yeah, I know.
That would be kind of a leading.
So I wish I had my comments with me that I made, but they are on record.
They're on record.
Yeah.
Yeah.
So if anyone wants to view them.
All right. So,
well, I wasn't prepared because I thought I was going to have to stick literally to my brief. So that's all I have right now. I'm very connected to the park. You probably can tell that I feel like I'm there so much of the time, 2 to 3 times a week for many, many years. I see the animals. I know that I don't have pictures of the bald eagles. I was swimming at the time several times. I've been swimming in the lake on the shoreline. I've seen them there, and there's no camera in your hand when you're swimming. So, no, I don't. It is hearsay, but all I can say is I'm being truthful about that. So. Mm-hmm. Yes.
And in one of the documents, it talks about that the hotel operator will give the people staying at the hotel the rules of park usage.
Right.
Do you think that will solve the drug confident?
Well, it would be interesting to know about enforcement of that kind of thing. Would be interesting to know what I don't know if that would be a state park question or what kind of question, because now that it's getting all mixed together.
What do you mean it's getting all mixed?
Oh, well, Daniels will be in the middle of a state park owned by the state. So I don't know if the ranger is going to be on site and enforcing this kind of thing or not.
Yeah.
Right now, technically the gates are supposed to close at dusk and no cars get in, but the cars are going to get in after that for sure.
So your concern is how would this be enforced if they do have the park rules?
Right.
How would you know that people aren't deciding?
Right. I think it's going to be a high temptation, especially the. Oh, I'm sorry.
I'm sorry.
Yeah.
Get some water. Go ahead.
I think it's going to be a temptation, as we all know. It's especially the Seminary Trail, which is wide and open.
Okay. Thank you.
Thanks.
okay. Oh, you have cross-examination. So the order of cross I think I'm going to use, unless you have another preference, because it doesn't matter to me which order I go, is applicant first, then state parks, then city. Does that make sense to everybody for cross? Okay, then applicants, any cross? Okay.
All right. I'm Andy Murphy, an attorney for the applicant. Good afternoon, Ms. Hendershot. Do you consider yourself an expert of trees?
No.
Do you consider yourself an expert in wildlife?
No.
And you don't have any specialized education in trees?
Oh, I have. I don't remember my curriculum from when I was a general science major, but it's mostly biological, and there was some plant and tree education in that.
So does that mean you had
and then I
a
had
class
some
or two
education.
about? Oh,
I'm sorry.
we don't want to cause problems for our court reporter.
Yeah.
You mentioned you had some education. Would that be a class or two?
No, I have a general science degree, and most of it is biology classes. It was very close to a biology degree, but it's general science. Mm-hmm.
And does that address wildlife as well?
Yes.
So the limit of your formal specialized education is a general science degree that includes some courses on plants and wildlife.
Yeah, concerning wildlife, yes. Yes.
But you don't consider yourself an expert in those areas?
Well, you'd have to define expert for me, really, for me to be able to answer that, because. No. No.
You ever contributed to a formal report?
No.
And do you have a copy of the brief you submitted?
I do, but it has writing on it. So I'd rather not leave my personal Pardon?
I just want to ask you a few questions.
Oh, okay, yeah, sure.
So this is, for the benefit of the record.
Mr. Murphy, your microphone is off.
Is it?
Yeah.
Bless my soul. Is this better? All
Now
right.
you got it, yeah.
Glad to join the party on microphone problems. I'm referring to the brief that was submitted as part of the pre-hearing briefs. It's titled Lodge of St. Edward, and then your name is on the front cover.
Yes, yeah.
And the first page of this addresses what you have characterized as inadequate responses to comments you submitted. Is that correct?
Yes.
And the first comment that you have taken issue with is one that says, it's under 3.3 on the bottom
Yes, I
third
have
of
it in
that
front of me,
page.
yes. Mm-hmm.
And it says, currently there is no trail use at night, if I read that correctly.
Mm-hmm.
Can I direct your attention to the response to this, which is in the FEIS, it's in the binder in front of you, titled Core Documents. It will be tab 11. And can I direct your attention to page 3-45? I'm referring to the response that starts on page 3-44. This is the response to your comments. This is what you took issue with. And the comment that you submitted was comment 10. So the response is on 3-45, and it directs you to section 3.7 of the EIS. Is that correct? Yes. All right, let's go to that section. If you have a pen or something to leave there, we're going to come back to that, so it might help you. Okay. The DEIS is core document 19 in that same binder. It's the tab 19. And can I direct your attention to page 3.7-3? And can I draw your attention to what looks to be the third paragraph on that page? It's the second full paragraph. And it starts, the use of the lodge as an operating hotel would increase the number of recreational visitors in the surrounding area, than the surrounding park. When the 100-room hotel is at capacity, it is likely that approximately 200 or more additional visitors would be at the site, which could increase use of recreational amenities in the area. Would you describe the trails as the recreational amenities in the area? No, this is the... If the trails were included in the recreational amenities in the area, would this respond to your comment about trail use? Okay. Can I draw your attention to page 3.3-10 of the same document? And you've expressed concern in your brief and in your testimony about impacts at night. And this, under the heading of animals, under the second full paragraph of that heading, says operational noise and light from the proposed project could also affect wildlife in the site vicinity. Since use of the park is not currently permitted after dusk, the greatest long-term effect from the project would occur in the form of increased noise from dusk to dawn. Did I read that correctly?
I believe so. I didn't follow you word for word, but I didn't follow you word for word, but I'll just, I see that you're reading it.
Thank you. Your second comment in your brief that you submitted addressed concerns about how noise and light from hotel operations would affect wildlife. Is that correct?
That's true.
And so this section I just read refers to how noise and light from the project would affect wildlife. Is that correct?
I'm not following you, because I'm also seeing that on my 3.3 comment that I said currently there's no trail use at night, which shows that I'm considering night use in that comment.
So your concern is about trail use specifically at night?
Well, that's assuming people will stay on the trails. But really, it's trails and any, let's say, social trail activity, which is illegal trail use when you go off the trail.
So
that would be part of that.
Can I refer you to back to your brief? Under the comment that you submitted, the last sentence of that first comment says, currently there is no trail use at night. Is that accurate?
Yes, that is what I wrote.
And there are homes surrounding St. Edward State Park.
Yes,
is that correct?
Yes.
And it is currently against the rules to use the park in the evening. Is that correct?
That's right.
So your concern is that, no, let me rephrase. So if people are, is it your position that people are currently following the rules?
I can't comment on that since I'm not there at night.
But it's your understanding that there is no trail use at night?
Well, I just know it's against the rules.
Okay.
I could never be there every day, 24 hours checking on that. Yeah. Yeah. And I might add, any use by people from those houses is also considered social trail use and against park rules. That land goes up to almost to the plateau there. So all those social trails you see from there, if you've ever been there, are illegal trail use. So, to my understanding.
Do you have any reason to doubt that Parks will change its enforcement of its rules?
I have no information about that.
Is that a no?
No, it's just that I have no information about that. I don't have enough information to answer that.
All right. Can I direct you to the last section of your brief, which includes an article from the Audubon Society?
Yes. Are you referring to the Portland Audubon Society?
That's correct, the one that's in your brief.
Yes.
Doesn't have a page number, but the headline is Light Pollution, the Reversible Scourge on Our Night Sky.
I do have the document with me, just so you know. Right here.
Okay. I'm referring specifically to your brief.
Okay.
On the right-hand side, that first column, in the first full paragraph, it says, here in Portland, we are poised to take the necessary steps to integrate thoughtful lighting practices into our city codes.
Okay, I see where you are now.
Is that correct?
Mm-hmm.
And so is it fair to say that this article identifies thoughtful city code compliance as a way to address light pollution?
I can't speak to that.
Okay.
Yeah.
Can I draw your attention to page 3.8-4 of the EIS, the DEIS?
Am I in the DEIS?
That would be tab 19.
Tab 19? So I can forget the other tabs now.
For now.
Okay. And what page, please?
3.8-4.
I think I'm on the wrong thing. I picked 20, sorry. Did you say 3.8-4?
I did.
Okay. Okay.
Under mitigation measures on that page, the second bullet says lighting design for the project site would be consistent with the City of Kenmore requirements, and it cites a code provision, KMC 18.30.070, to minimize light spillage from the site, particularly in areas adjacent to existing forested areas of the park. Did I read that correctly?
I see that, yes.
And do you have any evidence about how the proposed project will affect night lighting outside of the lease area?
I've seen what was written, but there didn't seem to be any details about how they were going to do that.
But you don't have any evidence to offer about how light pollution will exist outside the lease area?
No, and how could somebody? You'd have to know the foot candles, and it would have to be post-construction, really, or knowledge about what bulbs were going to be used and what wattage and where and how they were aimed. Seems like an impossible thing for me to answer. Sorry.
Thank you, Ms. Hendershot. I have no more questions at this time.
All right, Ms. Mulligan.
Yes.
I have just a couple questions for you about your appeal statement, if you don't mind keeping that open.
Sure.
And I just have a couple clarifying questions about the last few pages that have your list of animals you've personally witnessed, and then followed by what's identified as Exhibit C,
yes.
the photos of animals you've identified. In your frequent visits to St. Edward's State Park, those animals that are pictured, were any of those photographs taken inside the seminary building?
Of course not. No.
Do any of the animals that you have identified as witnessing on the property have habitat inside the seminary building?
Of course not.
Thank you.
Although, I can't vouch for the butterflies and the bugs. I really can't. I don't know where they go after I take pictures of them.
Did you have any other questions? Oh, you didn't. Okay. Mr. Casaguman, do you have any questions?
I understood you to say that you live in the city of Kirkland. Is that correct?
That's right, yes.
In what neighborhood, by name, do you live in Kirkland?
Norkirk.
Norkirk.
Norkirk, Norkirk.
And approximately how many blocks or miles is that from the entrance to the state park?
I think I mentioned about 7, but I couldn't tell you exactly.
7 blocks or miles?
Miles, I'm
Miles?
sorry. Miles, yes.
So when you said in your testimony that the light and noise from this project will invade your neighborhood, that was incorrect.
No. I was saying, you mean just now? I was just giving an example of what we as people might not want in our neighborhoods. I wasn't saying that I personally have any effects in my neighborhood.
Oh, this would have been about 15 minutes ago.
Yes, I can read what I've said.
So your testimony then is that the light and noise from this project will not invade your neighborhood because you...
Not mine. I said, I don't think any of us would want increased visitation, lights, and noise to invade our neighborhoods consistently at night. An analogy.
All right, thanks.
Yeah.
And my understanding of your testimony, in part, was that you saw a bald eagle flying above you when you were swimming in Lake Washington.
That's right.
Is that an accurate?
A number of occasions, yes. Mm-hmm.
When was that?
I don't have the dates. I didn't document it. I didn't know I'd be in a hearing someday.
Oh, can you give us an approximate
it's
time?
hearsay. I couldn't say. It's probably within the last 5 years that I've seen 2 or 3.
And in both cases when you were swimming in Lake Washington?
That's right. I go down to the beach and I swim in the shallow water there in the summertime.
Okay.
Mm-hmm.
And isn't it true that if you are swimming in Lake Washington and you see the bald eagles flying around, that you cannot tell whether they land on the seminary building or in the area surrounding it?
When you say the area surrounding it, what do you mean?
I'll draw your attention to the diagram On your far right, the second from the end?
Yes.
The area I'm talking about is the area that surrounds those buildings and the cleared out area around the buildings.
So are you saying that it's before you access the Seminary Road, that the trail that goes down to the water?
No, I'm talking about the area, cleared area that surrounds the buildings in the diagram that is second from the end. The next picture. To your right. So my question is, when you were swimming in Lake Washington and saw these bald eagles, isn't it true that you could not tell whether they landed on those buildings in that aerial photograph or on the cleared areas surrounding those buildings?
So are you talking about only what I can see in that picture?
What you could see when you were swimming.
So, I mean, right now, what I can see on that picture, on that photo?
My question is...
When you say areas surrounding the building, do you mean only what I can see on that photo?
Okay, my question is, when you were swimming in Lake Washington and you saw a bald eagle flying over your head...
Right, sure.
Isn't it true that when you are watching the bald eagle flying, you cannot tell if it lands, whether it's landing on the seminary buildings in that aerial photo or on the land surrounding those buildings, which is the cleared areas surrounding the buildings in the aerial photo?
There's no way I could see the seminary or the construction zone. So it's not landing in the construction zone, if that's what you mean. I absolutely saw them land on trees in the park at the water's edge.
At the water's edge, thank you.
That's right.
I have nothing further.
Okay, thank you, Mr. Kaskuba. Any redirect from the appellant?
This is something I'm not used to, so I'm sorry. I was thinking that was much later. I think you've been asked some questions that really do not pertain to the project. I don't think you ever said that there were eagles on the, I did not hear you say there were eagles on the building or any animals living in the building. You are talking about animals in the forest. Would you please explain what animals you're talking about and clarify where you see them living? Because I know
do you mean
see
go
them.
through my list or
No, just the general idea of where, just give us an idea of your concerns and where these animals are living. Are they living in the property that is being leased, or are they off that property? And what do you see? You've already explained some of the danger you see for them, or the changes in their rhythms and their living situation. But just clarify where the animals are concerned. Do you see animals being in the leased area and animals both out of the leased area, or is it okay? Because there seems to be some confusion that maybe you think you're saying that the eagles are landing on the roof, or there's animals in the building.
I don't generally walk around the seminary building right next to it when I'm taking walks. So these animals and insects and birds that I've seen are on trails. You know, I'm seeing them from the trail, or I'm seeing them down by the water, always in the state park, but not in the construction zone necessarily. I can't speak for where they go after I see them, though. So.
And but your real concern is the people not necessarily staying in the hotel when they're in the hotel. Your concern is when they're on the trails at night and at other times.
Yeah, so, again, I have a reference in my brief about the impact. I mean, it's a really good reference, I think, on the impact of light and noise and people and bicyclists coming into a park and affecting wildlife in a negative way. So that's what I brought up, because that's what really was not addressed specifically in the FEIS. I didn't know I could bring up anything that I thought was weakly addressed, or I would have been much better prepared. But I did definitely pick one that I didn't think was addressed at all because it really bothered me that it wasn't addressed.
Okay.
So it's absolutely, so you have a building and you have the activity around it and you have the activity coming in from the road, and then you have branches of that activity escalating all the way down to the water now. And so the wildlife that gets to sleep at night, and of course animals that are nocturnal are disturbed during the day. But we already have that going on. Let's not add some more is what I say. Let's not bother them all day long. All night long, all day long, 24/7.
Okay, and there was another, while you were speaking about wildlife, there was another thing in the draft EIS about a concern. And the being fair, the EIS does say that this change will impact animals and can, I'm quoting from memory, but can disrupt their reproductive lives,
right,
et cetera.
Yeah.
But my question is the concern because there will be increased traffic, the concern of wildlife with the roads, et cetera. Do you have a concern about that?
Yes. Yeah. I've made comments about a great number of things in the to the DIS, and like I said, I wasn't satisfied with most of the answers, and I can't be specific right now because I wasn't prepared to speak about that, but you certainly can access the record from what I wrote before.
Yeah. Thank you.
Yeah.
Okay. Is that it for Ms. Hendershot then?
I think so.
Okay, great. Next witness then. Thank you, Ms. Hendershot.
Thank you.
Okay. And I'd like to call Dr. David Bain as a speaker.
All right. And Dr. Bain, have you been sworn in?
I have.
Oh, you have? Okay, great.
Oh, that's right. I start, don't I?
Okay, I'm Dr. David Bain, and I'll be talking about marbled murrelet, which is a seabird that nests in forests, and it's on the endangered species list, and it was not considered in the environmental impact statement.
Dr. Bain, if
Yes.
I could interrupt you for just a moment. Mr. Hearing Examiner, and I know you issued a ruling on this, but I'd just like to state State Park's continuing objection to any testimony regarding the marbled murrelet.
Okay, noted. Thank you. All right, go ahead, Dr.
Okay. All right, I'll start by giving my background, and hopefully by the time I'm done, you'll understand why marbled murrelet's are relevant. I have a PhD in biology from the University of California at Santa Cruz, which I received in 1989. I've done over 10,000 hours of field work in marbled murrelet habitat. While I've not published any of my own work on marbled murrelets, I did assist Ed Melvin with a publication on the use of pingers to reduce marbled murrelet entanglement in gill nets. I'm one of about 70 certified marbled murrelet observers. To get that certification, you need to have field experience. You have to attend an annual training that includes information on the effects of disturbance on marbled murrelets. And you also have to show that you're competent to identify marbled murrelets and a number of other seabirds in the field. And I've also attended a number of forest management plan meetings that have addressed marbled murrelet concerns. I've qualified as an expert witness in federal court to deal with issues of disturbance on harbor porpoises and gray whales. I've been an expert witness in Canadian court on effects of disturbance on killer whales. I was selected to do the peer review on National Marine Fisheries ESA recovery plan for southern resident killer whales, and also for the ESA listing for Lolita, who's a southern resident killer whale in captivity. And I'm a co-author of Canada's resident killer whale recovery strategy prepared under the Species at Risk Act. So I've spent 34 years studying disturbance on marine life. I did work on the Maury Island gravel mine expansion proposal and submitted legal declarations on that. And let's see. Also, one of my positions is I'm a board member of Friends of North Creek Forest, and I'm involved in their grant writing, and did a literature review of marbled murrelet nesting habitat for inclusion in our grant proposals, which were funded by the state of Washington to help protect or to facilitate the recovery of the marbled murrelet. I believe the St. Edwards draft environmental impact statement has the same flaw as the early work on Maury Island, failure to consider disturbance on an ESA-listed species. The marbled murrelet is threatened under the Endangered Species Act, and it's a priority species in the state of Washington. Let's see if I can read my writing here. The greatest threat to the marbled murrelet is nesting habitat loss, and the marbled murrelet breeds in stands of trees that are greater than 60 acres in size, trees that are greater than 100 years old, and less than 50 miles from marine water. I think in general the trees at St. Edwards Park are too young for marbled murrelets at this stage, but they will be old enough to constitute marbled murrelet breeding habitat before the expiration of the lease with Daniels. Because marbled murrelets feed at sea, but they nest inland, they gain energetic benefits by nesting near shore rather than farther inland. One of those benefits is the energy involved in flight. It's only about a 5-mile flight from St. Edward State Park to Puget Sound, whereas many of the closest known nesting sites on the east side of Puget Sound are 25 to 35 miles inland. So they get to save a lot of energy going back and forth. Also, they get benefits in feeding. When they're rearing chicks, they may need to fly back and forth as many as 8 times a day to give their chicks an optimal amount of food. However, in practice, reproductive success is an order of magnitude lower now than it was historically, and that's probably due to the elimination of coastal breeding habitat and the move to more distant habitat where they can find suitable forest cover. Recovery plans for marbled murrelets have a very long time frame, and that's because they depend on old-growth forest. And when you're dealing with, trying to increase breeding habitat and you have to wait for trees to grow up, you can be looking at plans that say in 2067, this is the amount of recovery we expect to see. There are a number of agencies involved in updating their recovery plans for marbled murrelets. U.S. Fish and Wildlife Service is due to complete its 5-year update of the recovery plan. DNR currently has a proposal for forest use open for public comment, and that public comment period closes next week, I believe. And another agency that has significant land that could become murrelet breeding habitat in the foreseeable future is state parks, with St. Edwards being one example of having enough trees that are reasonably old that they could become breeding habitat. So therefore, I think it's important that these agencies consult with each other, and given the federal nexus with the Land and Water Conservation Fund, U.S. Fish and Wildlife Service probably should have engaged in a Section 7 consultation before completion of the environmental impact statement. Concern over the lodge visitor use of the forest is of special concern at dawn and dusk, and also at night, because there are a number of threats to marbled murrelets. One, food scraps attract predators, and crows are known predators on marbled murrelets. So increasing use of the park poses a threat, even used during the day. Murrelets seem to rely on low light levels for arrival and departure from their nesting site. It seems very important to them that they're not observed because they're spending their day primarily out at sea, so they're not on the nest to protect their chicks, and that makes the chicks especially vulnerable to predation. So increased light levels in the park might allow owls that are known predator on murrelets to observe them flying in and out of their nesting sites, and that could lead to increased chick mortality. Another concern is that marbled murrelets are killed in collisions with vehicles. I think the data are primarily for logging vehicles, but if they were to resume nesting in places like St. Edwards Park or North Creek Forest, regular cars would be a concern. Let's see. I think the reason it's important to have a consultation is DNR has a wide range of alternatives they're considering, and they've not picked a preferred solution. For the nesting area that includes St. Edwards Park, their plan ranges anywhere from a further reduction of 1,000 acres in breeding habitat to a potential increase of 21,000 acres. And with less than 300 forested acres in St. Edwards Park, adding that to a loss of 1,000 would be a big deal, but it probably would not be a huge deal in the context of a 21,000 acre increase. So I think it's important that state parks and DNR talk to each other and decide whether DNR is going to take responsibility for recovering the species, or if they want to share that responsibility with state parks. In the recovery strategies, some of the main things they're talking about are increasing the amount and quality of suitable nesting habitat, increasing size of suitable stands.
Dr. Vane, I'm
Yes.
sorry to interrupt again, but Mr. Olbergs, I need to object. That recovery plan is a Department of Natural Resources proposal or a U.S. Fish and Wildlife Service document. I'm not sure which you're referring to, but neither of those apply to St. Edwards State Park. They're not relevant.
Well, I think that when you're doing an environmental impact statement, you're supposed to consider all reasonably foreseeable cumulative impacts. And you're correct that these are not state parks policies, but state parks actions do have a reasonably predictable effect on what will happen with marbled murrelets in this area, and therefore they should have been considered. And since they were not considered, the environmental impact statement is not complete. And the end of the line would be I'd ask the hearing examiner to not approve the project at this time and ask that the environmental impact statement be completed and brought back to him, and then make a decision at a
That's the
future
extent of your comments on those plans, then?
What was that?
Is that the extent of your comments?
No, I've got some more.
About those plans that Parks
Yeah.
is saying are irrelevant.
Yeah.
All right. Well, I'll allow it, but it looks fairly tenuous connection. But I'll assess it in terms of weight and compelling evidence. But go ahead.
Okay. So protecting forest buffer, speeding up the creation of new habitat, and improving the distribution of nesting habitat. And that last one is particularly relevant to St. Edward's Park because, we have lost essentially all the coastal breeding habitat. And we do have patches of forest that were logged early in the 20th century that are getting close to becoming habitat again. And these would be fundamentally new locations. So, for example, if you had a large wildfire in the foothills where they're currently breeding, you could lose a lot of breeding habitat, but you might have a population in St. Edward's Park that would survive. And because they're close to water, they would be expected to be the source of a growing population, and then their offspring could recolonize the forest farther inland. Some shorter-term objectives are maintain potential and suitable habitat in large contiguous blocks, maintain and enhance buffer habitat, and again, of particular relevance to St. Edward's Park, minimize nest disturbance to increase reproductive success. Some of the other concerns are limiting noise, and people yelling are loud enough to be of concern. I think in practice, people having normal conversations would not be an issue. There's concern that if people are close enough to the murrelets for the murrelets to see them, that visual disturbance would be enough. A 300-foot buffer is currently recommended, though the science is not necessarily adequate to support that conclusion. So those are the points I wanted to make about marbled murrelets, and then I'd also like to follow up on the bald eagles and the great blue heron briefly. With the eagle nesting, there's a requirement for 660-foot buffer, and I think the seminary is greater than that distance away, so there's no need for consultation about the construction phase. But if it will result in hikers passing within 660 feet of a nest, WDFW should be consulted about the project. And then on great blue herons, there are priority species for the state that was also admitted from consideration in the EIS. And the recommendations for great blue heron recovery include protecting foraging sites, and the shoreline along St. Edward's Park is a foraging site that needs to be protected, and the possibility of hikers leaving the seminary and going down to the beach and disturbing herons is something that should have been considered in the EIS that wasn't. So let's see. So I think that's all I wanted to say.
Okay, great. All right. Any more questions from Ms. Hurt?
I forgot to turn it back on. Sorry. Do you have any other concerns that were in the in the EIS about wildlife other than the blue heron and these things about in the marble mar, which I did not know much about that bird. I have to go home and look it up. So.
I think when you're dealing with wildlife, there are some species that are more protected than others, and the ESA-listed species kind of get the highest level of protection. Right. And then you've got priority species like great blue herons that are not in danger of extinction, but we realize that if we keep doing what we're doing, they will eventually end up listed. And then there are common species like deer that, we kind of say at this stage, if we harm them, it's not that big a deal because there are more deer other places that'll keep the population surviving. So, it's a moral concern, but it's not a legal concern. And, I think the salmon are potentially another concern, and that's one where I don't think the science is quite far enough along. There's a strong suspicion that excess lighting contributes to predation on juvenile salmon. It's an area of active research now, but that research has not been completed yet. And then the other issue with salmon that maybe should have been looked at more carefully is whether, light coming across the lake would exceed the light levels coming from the seminary. And if the seminary is not adding to light levels, then, it really should not be a concern. But you also have the possibility of people taking their flashlights and walking down to the beach, and, if they start lighting up the fish and then the predators see the juvenile salmon lit up, then they have the opportunity to feed on them, and that would result in an increase in salmon mortality. And, the killer whales I focused my research on, depend on those salmon for food, and it's a food-limited species. So, the loss of salmon here would result in, loss of salmon for killer whales to eat, and perhaps a further decline of their population. And I guess one other thing that I should have mentioned is that in the Maury Island case, when the judge reviewed that, one of the arguments against protecting the whales was, well, Maury Island is just a very small part of their range, and it would only have a small impact. And we question whether that's a valid argument. That I kind of analogized it to a flood control policy of attempting to identify which raindrop caused the flood, and then running around in a paper cup and catching that raindrop and think you've prevented the flood. Because a lot of these endangered species things are saying, well, the first batch of raindrops doesn't matter because there's not a flood, so we don't have to worry about it. And then after there's a flood, it doesn't matter because, the species lost and we can't do anything about it. So the only one we care about is that one that causes the flood. And kind of the point was that's an absurd way to go about it, that, species can be dying a death of 1,000 cuts. And rather than look at each individual one, you look at all the things going on that have that magnitude or greater, and say, if you deal with those, is that sufficient to recover the species? And if it is, then you can ignore less significant things. But if it's, this and all the other things that size are causing you to lose the population, then you need to deal with all those things that size, even if each one on its own would not result in the extinction of the species.
Is that it, Ms. Hurt?
Yeah,
Question?
I'll wait for the...
Okay. Now, after cross, then we'll take a break, and then when we come back, we'll figure out whether we're going to finish today or tomorrow, and schedule tomorrow if we need to. Then still have to deal with the SEPA exhibits. Probably should have done that before, but it's not a big deal to do it then. And then we'll finish off the SEPA appellants, witnesses, and then move on to the rest. So, applicants, any cross?
Yes. Good afternoon, Dr. Bain. My name is Amit Ranade. I represent the applicant here. Just an initial question. Your last name is spelled D-A-I-N. Is that correct?
That's correct.
Okay. I saw your name on the email notification list for the draft EIS. Is that correct?
Probably.
Okay. I did not see any written comments from you in response to the draft EIS, and I did not see your name appear as a speaker at the public hearing on the draft EIS. Am I correct in understanding you did not submit public comments
I
during
did
the
not
draft
submit,
EIS period? Please let me finish my question before you answer, because we've got somebody transcribing. Am I correct in understanding that you did not submit written comments and did not submit public comments during the public hearing?
That's partly correct. I did not submit written comments, but I did speak at the public hearing in January.
Did you speak at the draft EIS hearing?
Oh, not at the draft EIS.
Okay. You testified in trying to establish your credentials that you've done 10,000 hours of field work on marbled murrelet habitat. Did I hear that correctly?
In marbled murrelet habitat. I'm primarily a killer whale biologist, but marbled murrelets and killer whales share the same habitat. So, I've watched, killer whales, swimming along that I'm taking data on, and you'll have a flock of marbled murrelets here, and then the whale that should have come up in the flock of marbled murrelets skipped a breath, so the other whales, came up here next to it. That the one that would have disturbed the murrelets decided to skip that breath and, come up on the other side. So
that's pretty remarkable. That's very cool to hear,
yeah,
actually.
So resident killer whales are nice like that.
They're good neighbors.
Transient killer whales, on the other hand, are known to swat the murrelets with their tails and kill them.
Fair enough. So while you're sitting there taking data and probably sitting in a much nicer office than I usually do, were you taking any data on the marbled murrelets?
Yeah, we took data on their locations. Generally we just noted their presence rather than the number. I did some field work in Prince William Sound where we took more detailed data on their presence. And then the last couple of years I've done some marbled murrelet monitoring where we take detailed notes on marbled murrelets as far as what their behavior is, their exact location, things like whether pile driving is going on at that particular moment and so on.
Okay,
so U.S. Fish and Wildlife has a data protocol that we followed.
And is that, I'm looking at the CV you submitted as Exhibit 4 of the appellant's materials. I see one of your job experiences, at least 2015, 2016, is marine mammal seabird monitor. Is that what you're talking about? Okay, so you've been doing that for a year and a half, maybe? Since 2015?
Yeah, so getting paid to do seabirds in particular. I've done more bird monitoring that's been incidental to killer whale projects. But
I see you've done, you've got a lot of publications.
Mm-hmm.
I didn't see any dealing with the marbled murrelet, but I might have missed it. So I'll ask you.
No, that's correct. I mentioned in my testimony that I assisted Ed Melvin with one of his marbled murrelet publications.
Okay. And I don't see on your academic background, and so I'm asking, I don't see, you're not a botanist, correct?
I'm not a botanist, that's correct.
Do you have a forest practices management degree?
I do not.
Can you tell me where on the taxonomic hierarchy orcas and marbled murrelets diverge?
They diverged a very long time ago. So you'd go back to,
they're the same. They're not the same species, certainly.
Oh, no, they're not even the same class.
They're not the same genus.
No, you would have had reptiles diverging into birds and mammals. So you're probably talking, hundreds of millions of years of divergence.
I think I would agree with you on that.
Yeah.
Have you ever studied specifically the effects of noise on birds, seabirds, and let's be even more specific, the marbled murrelet?
Yeah, those, the work in the last year and a half was specifically on disturbance of marbled murrelets, and then also that work I did with Melvin was looking at using pingers to cause marbled murrelets to avoid gill nets. So there are these little orange things that make noises that murrelets can hear. And the idea is that, when they're in the water, you don't want them chasing fish into a net and getting tangled up, because that was one of the main sources of mortality. So we were looking at, would the noise produce adequate disturbance to protect them from getting entangled in gill nets?
And yet this study doesn't appear on your list of published or unpublished work?
Yeah, as I said, Ed Melvin was the author of that.
Okay.
And I played a fairly small role in it.
And have you done any studies on the effect of development on the marbled murrelet? By that I mean construction of buildings or the operation of buildings?
Not personally. I've reviewed studies that other people have done.
Okay. Same question with respect to lighting. Have you done any study of the effects of development lighting, so construction lighting, building lighting in operation on the marbled murrelet?
No, I have not. But again, I've reviewed the work of other people.
In your testimony, you referred several times to Maury Island. Can you tell us what project you're talking about?
There used to be a gravel mine on Maury Island, and there was a proposal to expand the gravel mine and install a dock that would have allowed them to barge gravel from Maury Island to Seattle about every half hour. And I think the idea was that that gravel could be used to build the third runway at SeaTac. And, the concern was that, where they wanted to put that dock was, kind of the best habitat in Puget Sound for Chinook salmon. And it was also, critical habitat for killer whales. So, what we tried to do was make the case that the impact of this planned project on killer whales posed jeopardy to the survival of the species. And after about 10 years of fighting it, Judge Martinez ruled that, in fact, it did pose jeopardy to the species. I'm going to try to guide you to a document here. I want you to take a look at the draft environmental impact statement that's in the record. It's a core document, Exhibit 19, so hopefully it'll be behind a tab that says number 19. When you get there, you there? Yep.
Okay, would you flip to, there's a couple of figures I want you to look at. They're called Figure 2-2 and 2-3. They're colored aerial maps of this project. They'll be in Section 2 of the document. So, and let's start for a second with the figure 2-3.
Okay.
What is your understanding of the project that we're talking about here today?
Okay. I don't think that anything within that project area would have any direct effect on murrelets. It would be people going to and from that project site that would be the concern.
So you understand that what's being proposed here is to renovate an existing building. Is that?
That's correct. Okay. And it will be.
And you understand
it will be done before marbled murrelets would be considering St. Edward's Park as a place to nest.
Okay.
Assuming things don't get dragged out forever, it would get done, long before the murrelets would be there.
Okay. And you understand that none of the project is going to be, trying to think of the right way to describe the shape. I'm going to say it's the shape of a house here, these boundaries in Figure 2-3.
Yeah.
You understand that the project doesn't go outside of that boundary?
Correct.
Okay.
Yeah.
And so
I'm saying that the reasonably foreseeable
I understand what you're trying to say.
Extend beyond that area.
But your references to Maury Island, where you're trying to compare the Maury Island project, where they're expanding a gravel mine to the shore, adding a dock, and shipping gravel to go build a runway, to be the same thing as renovating an old seminary building, where I see 1, 2, 3 large trees, maybe? You think those two are comparable projects?
Well, killer whales, the population we're talking about range from Central California to Southeast Alaska. And we're talking about a very small project site. And, it's kind of the things that spread from that project site that are concerned. So in the case of the gravel mine, it's the noise from the tugs. And it's the gravel, hitting the barge and the noise that made that raised concern for the killer whales.
Are there any tugs or barges that will be involved with this project?
No, but there are people with flashlights and kids that run around screaming and things like that.
Okay. And when you say there will be people with flashlights, are you assuming that guests of the lodge will be violating park rules and walking around on the trails at night? Is that your assumption?
Yeah, my assumption is they will not be held prisoner in the lodge at night. Okay. They'll be free to go outside.
And are you assuming then that all the people that live along the edge of the park are held prisoner in their homes and don't walk into the park as we speak today? Is that your assumption?
I think they can leave their homes without going into the park.
And are you assuming they don't go into the park?
Well, I know there are night events in the park. For example, the hearing we had in January was inside the park at night.
I think you testified already that your basic opinion of the marbled murrelet question is that this park could someday be a nesting site. Is that a fair general characterization?
Yeah, that's correct.
Okay. Have you seen any marbled murrelets in the park today?
No.
And I use the term today sort of generally, in present day.
Yeah, I understand that. No, and you would not expect to see them in there. You might catch them, flying over the park on the way to somewhere else, but marbled murrelets have fairly specific nesting requirements, and St. Edward's Park does not currently meet those requirements and is not likely to for a couple decades. But you're talking about a 60-year lease, and within 60 years, it is likely to meet nesting criteria. And marbled murrelets are likely to still be on the endangered species list in 60 years. So using the park as one of the steps we take to recover that species is something we should be looking into. And as I said, if DNR goes all out for protecting murrelets, then we won't need to worry about St. Edward's Park, and I'll be thanking you for saving the building. But on the other hand, if DNR says, well, we don't have to go all out because we've got all these state parks that murrelets will be able to nest in eventually, then it will be important. So again, my point is that discussion needs to happen and should have happened as part of the environmental impact statement process. And since it was omitted, the consultants should have to go back and, see, what the state park's going to do, what's the federal government going to do, what's DNR going to do. Are cities like Bothell going to step up? And
do you have any data to support your assumption that this park will ever support marbled murrelet habitat? Or is it based entirely on the proximity of the park to Lake Washington and Puget Sound and the fact that there's trees there right now?
Well, as I mentioned in the testimony, when people have found marbled murrelet nests, it's been in stands of forest that are greater than 60 acres in size.
Have you conducted that kind of a study, you yourself? Have you?
No.
No. Okay. Have you tagged any birds and tracked where they go?
No.
Okay. So you're assuming that over the next 20 years or maybe longer that DNR will not have any kind of policy change. You're assuming that there will be no other changes to the park. Excuse me, I'm talking now. Okay. You're assuming that the users of this park are going to violate park rules and perhaps the park isn't going to enforce those rules. You're making all those assumptions in concluding that renovating an existing building is going to somehow affect a bird that wouldn't even be interested in this place for at least 20 years. Is that what I'm hearing?
No, I'm expecting DNR to change policy. As I said, they've got draft environmental impact statement out for comment now.
Okay. Would you please flip to page, it's the map, the aerial map immediately before the one that you probably have open. It's figure 2-2.
Okay.
This is a, let's call it a zoom out view of the park, right? It's a higher altitude shot. And in the upper left-hand corner along the waterfront, there's a piece of land that's marked out, and it's called the McDonald property. You see that?
Yes.
Are you familiar with what's going on with that property?
Yes, I am.
Okay. Is the McDonald property wooded, or is it clear, bare land?
It's wooded.
Okay. And is there anything in your estimation, and I understand you're not, you have no educational background in forest practices, and you're not a botanist, but you're out there. Is there anything to your eye that's discernible between the trees that are in the McDonald property and the trees that are in the rest of St. Edward's Park?
No, I think the McDonald property would be a valuable addition to the park. And when Ken Moore applied for a state grant to purchase that property, that grant was very highly rated.
Okay. Let's flip back to figure 2.3. It's the next page. I touched on this for a minute. Again, looking at the boundaries of the project, in your opinion, how many trees inside the boundary of the project could one day support a marbled murrelet nest?
I don't think any of them would.
Okay. Do you know where the nearest old-growth tree to this seminary building is in the park?
Not exactly.
Do you know how long it takes for a tree to be classified as an old-growth tree?
Well, from the marbled murrelet's perspective, it needs to be over 100 years old.
Okay. So you don't know if there's a tree, where there are trees in this park that are over 100 years old, if any?
Well, the park was logged in the 1920s, so as I said, you know, the trees that have grown in since then will be less than 100 years old now. But in 30 years, they'll be well over 100 years old.
Okay. Would you please flip to section 3.3 of the draft EIS? It's the same document you're in, it's just further down. Section 3.3, and specifically to page 3.3-10.
Okay.
I myself have to get there.
Okay.
Okay. You see there's a heading there. It says animals.
Yes.
Okay. I'm going to read you the first sentence under that heading. It says, development of the Lodge Hotel under Alternative 1 would increase habitat fragmentation or reduce habitat connectivity as the proposed site development is concentrated in areas of existing disturbance. Do you agree or disagree with that statement?
Okay. I think you misspoke. You said it would increase, and
you omitted the not.
text here says would not. And
sorry, you're right. Would not increase habitat fragmentation.
Do you agree that it would not?
You agree that it would not. Okay.
Because it's taking an area that's already been built on.
Okay. Now I'm going to read you the last sentence of that very same paragraph. And I'll read it more slowly so I don't skip words. Construction activities would be limited to daylight hours, and temporary increases in noise could temporarily disturb wildlife occurring adjacent to the project area. And then in parentheses it says, within approximately 750 feet. Do you agree or disagree with that sentence?
I'm not sure that the 750-foot limit applies, but you know, as far as exceeding, you know, legal noise effects, it will not do that with any listed species, to the best of my knowledge.
Okay, so what do you mean by you? How are you interpreting the within approximately?
I could not make a legal argument that the noise from the construction is a problem.
Okay. So let's look at the very first sentence of the next paragraph. Operational noise and light from the proposed project could also affect wildlife in the site vicinity. Do you agree? Isn't that what you've been talking about?
Yeah, the effects of noise and light, especially at night, is a concern.
Okay, and then I'm going to read you the last two sentences of this paragraph. In addition, increased traffic at night may create a movement hazard for reptiles and amphibians in the area. As a result, the project could reduce the abundance and diversity of wildlife within and immediately adjacent to the project site, particularly at night. Now, I know you haven't been testifying about reptiles and amphibians, but you have been talking about wildlife, and I've got the same question. Do you agree with those sentences, or do you disagree with those?
I agree with those.
Okay.
I do a lot of bicycle riding at night, so I'd see, the frogs and the snakes out on the bike trail, and presume they're also out on the roads.
So this is what you've been talking about, correct?
Well, again, the amphibians and reptiles do not have the legal protection that the marbled murrelets do.
Right. You made some comments about salmon and fish sort of more generally. And if you need to look at the project map again, you're welcome to that. That's figures 2.2 and 2.3. But where in the project area would you expect to see fish?
Okay, let's see. I guess I told Elizabeth I wouldn't need the map, but actually I do, so if you can find that. I'd expect to see fish along the shoreline, and then...
Is there any shoreline on figure 2.3, which is the map of the project area?
I'm looking at 2.2.
Okay, well, let's look at 2.3. That's the project area.
Yeah, I would not expect to see fish in the project area.
So are we literally talking about fish out of water?
No, we're talking about reasonably foreseeable effects of people going from the
So are you
project
assuming
area.
that the landscape is going to change and a creek is going to emerge, or where are you getting water on this map?
I'm not getting water on this map. I'm getting people on the map and people leaving this area to go to the water. Because that's one of the really nice things about St. Edward's Park is it's on the water, and you can hike through the woods, and you can find a creek, and you can...
And is it your contention that the EIS does not note the fact that people visiting the lodge will use the trails? Are you saying that's not in here?
I'm not saying that that's not in there.
So you're agreeing it's in here?
I'm agreeing it's in there, yes.
Just to avoid the double negative?
Right.
Okay. In your testimony, you talked about the effects of light across the lake on fish.
Yeah.
Is it your contention that however they end up lighting this lodge, that light is going to spill onto Lake Washington?
I believe it will.
And what is your basis for that testimony? I think you testified earlier, you haven't done any kind of light studies on birds, or have you done any kind of light studies at all?
I have a lot of personal experience with light at night. As I mentioned,
how tall are the trees around this park?
A lot of them are well over 100 feet.
Okay. Are they at least as tall as the building?
Yeah.
Okay. And so
we have clouds the light bounces off of.
Okay,
and,
so
when we have snow on the ground, it bounces up to the clouds and down to the snow and back up.
Sure.
And
so
things get very bright around here at night.
So is it your testimony that the lighting on this lodge on a cloudy night, or maybe a cloudy and snowy night, is going to be materially different than the light that will be emitted by all of the houses and the rest of the development all around the park?
I suspect not, but somebody should measure that to confirm it.
Okay. You testified that, or not testified, I'm sorry, in your brief you alleged that there was no noise impact study done. Is that still your position?
Not as far as it relates to marbled murrelets. So marbled murrelets were not considered at all. So that indicates that they did not consider the effects of noise on marbled murrelets. Marbled murrelets are species that are more easily disturbed by noise than a lot of other marine birds.
So it's your position that there should have been a study done about an animal that you admit is not out on the park or in the park at all?
Yes, because it's a reasonably foreseeable cumulative effect of the project.
And so is it your position then, just following your logic, that any other animal that could conceivably in the next 20 years or longer step foot in the park should be considered if they're threatened or endangered?
Yeah.
Is that your view?
Mm-hmm.
Okay. I have no other questions.
Okay. Ms. Melling, did you have questions?
I do, Mr.
Do you have a lot of them, or we could take our break now if that's...
I actually probably only have about 3.
Oh, okay,
So
go ahead
okay. Dr. Bain, I'd like to just stick with figure 2-3, if that is still open
Okay.
in front of you, and ask kind of a follow-up question about your testimony regarding the great blue heron. My understanding from your testimony was that modifications to the existing shoreline have the potential to impact the great blue heron. Does this project modify the existing shoreline?
It would affect the presence of humans on the shoreline.
Is there a new trail proposed as part of this project?
Not that I'm aware of.
And so I have a very similar question for your testimony regarding the eagles. You expressed concern about use of trails within 660 feet of eagles. Are you basing that concern based on existing trails or the construction of new trails?
I think based on existing trails.
So this would be an existing impact that already is on the property for the eagle that you are expressing concern about?
Yeah, and I think that eagles are fairly tolerant of people, so it's more a process thing where you have to tell WDFW this is happening, and they have to say it's okay. And it's just a little paperwork that should have been done that isn't. So I have experience with eagles in parks in this area where they seem not to be concerned at all with what people are doing.
So is it your contention that the discussion about the presence of trails and eagles is inadequate in the EIS, where it is raised and identified as a potential impact?
No, it's state law requires that if there's a project that takes place within 660 feet of an eagle's nest, WDFW is supposed to be consulted by it. And because this project would affect people using the trails close to the eagle's nest, WDFW should have been consulted.
I think perhaps you and I are maybe talking about two slightly different things. I believe you just answered my question that there are no proposed new trails as a result of this project. So is there use of eagles within 660 feet of the project boundary?
It depends on whether you count the people walking away from the project as part of the project.
How many users do you anticipate will walk away from part of the project compared to the current use of the park?
Well, I guess the projections are it's on the order of 200 people would be staying at the lodge in addition to the local residents that would be using it anyway.
Do you know the average daily number of users for the park?
Not offhand, no.
So my last question for you, you mentioned collisions with vehicles as a potential impact by the marble murrelet that isn't present on the site. I did not see in your appeal brief any references. Did you provide a list of scientific literature that you relied on to formulate your opinions?
I did not provide a list, no. There wasn't time to put that together.
I have no further questions.
Okay, Mr. Casaguma.
Thank you. Mr. Bain, would you agree that St. Edward State Park is heavily used?
Yeah.
And do you agree that it has approximately 865,000 visitors a year?
I don't know the number, but I would not disagree with that.
I understand you have the draft environmental impact statement in front of you.
Yeah.
Could you turn to the diagram that everyone else has been having you look at, which is figure 2-3?
Okay.
And am I correct in stating that this diagram shows the seminary building in the lower left-hand area? Above that, in the middle, a gymnasium. Just to the right of the seminary building, a swimming pool building. And then north of the gymnasium, between the pool and the gymnasium, and to the right of the pool and gymnasium, there is surface parking.
Correct.
Would you agree that many of the park visitors park their vehicles in the parking areas?
Yes.
In fact, would you agree that most of them park in those parking areas?
I don't know how much are parking there and how many are parking at Bastyr and how many are walking in or bicycling in.
But you agree that there are likely many, many visitors who park on those parking areas?
Yes.
I understood you to testify that the marbled murrelet does not like to establish nesting areas in areas that have noise. Is that true?
Yes.
And they also don't like to establish nesting areas in areas where they can hear humans yelling and talking loudly?
I think I said that in reference to the eagles, but I think it would apply to murrelets as well.
Okay. And I think I also heard you say that marbled murrelets also do not like to nest in areas where they can see visual disturbance from human beings and other activities. Is that correct?
That's correct.
So would you agree with me that currently today, the area that I described to you on figure 2-3 could not be, and even if there were the 100-year-old trees that you talk about, this would not be a bird nesting area?
Right. The area in 2-3 is not the bird nesting area. Again, it's the extra people attracted to 2-3 that move out into the forest that would be the concern. And
Okay,
that's
but again, you don't know how many people that would be. Is that correct?
Not exactly, but I think the projections are hundreds a day would be staying at the lodge.
Whose projections are those?
I think that would be based on the number of beds they're planning to put in there.
Okay, so you've speculated on that?
Yeah, I guess that's speculation.
Okay. So are you familiar with, having heard testimony before, what the project being proposed actually is?
Yeah.
And so my question to you is, so what aspect of the project is going to have a significant adverse environmental impact on the marble murrelets, possibly establishing a nesting area in the area figure 3 in the future?
If there were only like a 10-year lease on the project, I'd say none. But since there's a 60-year lease, I think, within the next 60 years, assuming the park doesn't decide to tear down trees and turn it into ball fields or something like that, those trees would be old enough and abundant enough and contiguous enough that you would have suitable nesting habitat for murrelets.
So you've talked about trees. So are you testifying that there's some trees in this area that would be removed and therefore the entire state park is not going to be a good nesting area?
Not in the project area. Again, I've been saying that we have people that will be coming into this area and leaving it, and it's the people leaving the area that are going to be the problem, not what's going on within that area. Right. And when you're doing an environmental assessment, you need to look at the reasonably foreseeable cumulative effects, and it's reasonably foreseeable that you will have more people going into the building, and it is reasonably foreseeable that they will not remain within that building the whole time they're in the park.
Okay.
And, you know, when they leave, you've got the problem of, you know, if they drop a sandwich scrap that attracts crows to the area, then when the crows can't find that sandwich scrap, they'll look for murrelets, and they'll kill murrelet chicks, which will contribute to
thanks.
preventing their recovery.
So other than additional users of the trails surrounding this project area, there are no other adverse impacts that you're talking about from this project itself. Is that correct?
Assuming it's done right. So, you know, you've got stormwater mitigation that has to get done, and assuming it's done in compliance with the regulations, you know, you won't be affecting water in the streams. You know, people do get it wrong. For example, the airport in Everett just screwed up and, you know, had to pay a big settlement to take care of fixing it. And, you know, I hope Daniels will be better than that, and that won't be an issue. You know, if the lighting's done properly, you know, the city lights from over here will probably light up the beach more than the light from the seminary, but if it's done wrong, you know, things may end up different.
Okay, thanks. You just testified that you anticipate that there could be an additional 100 trail users throughout the state park as a result of this project. And if my math is correct, that would be about 36,500 users a year. And based upon 850,000 visitors per year, would you agree with me that that's a change of 4.2% over the current trail use?
You know, something like that. But again, the timing would be important. If you have
you can just
people,
answer my question. Yes,
if you have people leaving the seminary at night, or, you know, within 2 hours of dawn and within 2 hours of dusk, those trail users will be more important than people using the trail at lunchtime.
I have nothing further, Mr. Examiner.
Okay, Ms. Hurd, any final redirect?
I have a question or a comment. You were asked your expertise on this bird, and did you ever do studies on it? Did you study it in school? As someone with who does have a high degree and has done a lot of research, what is your opinion of continuous education that gives you the same qualifications that you would get if you had had a degree in marblets?
Well, let's see. You know, I don't, well.
In other words, can you get the same education from reading the articles you read that you would get in a classroom? That's what I'm really asking, I think.
Yeah, well, you know, classroom, you know, a lot of college classes are, you know, 10-week courses, and I would say that I've done more reading about marbled murrelets than, you know, students would normally be assigned in a course. You know, if I were trying to do like a graduate degree in marbled murrelets, I'd probably be in that all but thesis level for a master's, where I've gone out and I've done my research, but I have not, you know, actually written the thesis yet.
Okay, so you really have studied this. It's not just an occasional article in an occasional magazine, Nature magazine.
Yeah, and you know, talk with professional colleagues that do marbled murrelet work full time, and you know, we've discussed things like, you know, they've got noise standards that are based on injury, that are based on studies that the Navy has done, but you know, our Pinger studies suggested that very much lower levels of noise affect murrelet behavior, and you know, talking about things like, well, you know, maybe we should go out and do a study of how sensitive murrelet hearing is, and see if they're more sensitive than other seabirds, or if it's just a behavioral thing that as deep divers, they're more vulnerable to predation. So they need to be more aware of the predators around them, whereas a gull that's, barely diving underwater at all, is more visual in determining whether predators are out to get it.
So it sounds like you really have studied this, even though you don't have the formal degree, or your degree didn't cover it. That hasn't been your research. You still are very familiar with it. So I was just curious, because there's been a lot of questions today about experts, and I think expertise can be gotten other than with your degree. And there's a lot of people who do continuous education are always educating themselves or through classes. So that's why I asked.
Yeah. So, and thinking about it, I think myself is one of the best in the world when it comes to killer whales, and I'm definitely not there for marbled murrelets. But as I mentioned, I have testified in federal court in the U.S. and Canadian government courts as an expert witness.
So you have the
and I think that my knowledge of murrelets does meet the threshold for an expert witness.
For an expert. Thank you.
Yeah.
Is that it, Ms. Hurt?
I think he's
Okay.
answered enough questions and gone
Dr.
through
Bain,
enough.
you went through the gauntlet there. That's all
my
these attorneys.
summary is, no, right now, they're not. This project is not a danger, but he's looking out in the future, which is something we all need to do as we look for how these projects are done and the impact they have on our future generations. And I guess instead of our children, it's the marble marmalade. So thank you.
Yeah, they're not quick fixes for the species, and you have to be thinking 50 or 100 years ahead if you're going to recover them. So I agree that they're not going to be on the site where the construction is taking place, and they're not going to be there while the construction is taking place. But because of the scenario for planned use, there will be an impact on them, and that impact needs to be weighed, and that was not done in the process. That's kind of my bottom line.
Okay, thank you, sir. Appreciate it. All right, so like I said, we'll take a 10-minute break and kind of consider how much time you need. I'm anticipating we're probably not going to finish by 5 today, and that you'll want to leave at 5. So the big issue is, do we absolutely have to start at 9 tomorrow as opposed to 10 and give the commuters, a chance to avoid some rush hour traffic and that kind of thing. So anyway, we'll take a break until about 3:54, and then address that and some other issues. Ready to go? All right. Now, the court reporter asked she needs to schedule another court reporter for tomorrow. So once we figure out a starting time, we need to stop just for a minute so she can notify the court reporter what time to be here tomorrow. So first of all, does anyone think we're going to be done by 5 today? No? Okay. Does anyone want to stay here longer than 5 today? All right. So we are doing this tomorrow. How much time do you think the applicants, do you have any idea at this point how long it's going to take you to present your case?
So our expectation, or our hope, I guess, is that we'll be able to begin our presentation with a motion that might narrow the issues. And if it does, then there's a number of witnesses we can release and, maybe even be done in a half day tomorrow. If we can't narrow issues, then we're going to have a long list of witnesses to address all the issues that are still on the table, and I would expect it to be a full day tomorrow as well.
Oh, okay. All right. So I guess, we better start at 9 then.
Right. Well, I will say, to the extent I have a vote, I too, especially my wife with the kids, would appreciate it if we started at 10.
Yeah.
I think 10 to 5 would be the outside if we can't narrow issues.
Okay.
That's my estimate.
Of course, it
I don't
sounds like
know.
if you're saying
Rod doesn't
Can we
like that,
compromise
so-
at 9:30?
Yeah, sure.
Oh, okay. Thank you.
Sure.
All right, Mr.
Even
Casco,
a half
what
hour
about
is gold
the
in the
city?
morning.
We all were hoping it would be 9 o'clock, but out of respect for me, 9:30 is fine with us.
Okay. All right. And what about the time it's going to take you then to do it tomorrow? Do you have any idea? Or
Our rebuttal probably will only be about 15 minutes at the most.
Okay, all right. And Ms. Welling, did you have a lot to ground to cover?
I anticipate that State Parks testimony will probably take about an hour.
Oh, okay. Okay, all right. And then, Ms. Hurt, how much more time do you need? Oh, okay, all right, okay. So we should be able to get this done tomorrow, starting at 9:30. So, well, let's let the court reporter, Miss, you can go ahead and notify the reporter we're starting at 9:30 tomorrow. We'll take a very short break for that. Okay, ready to go? All right, now, and then another disclosure. Mr. Renati came and asked me about a procedural issue during the break. Ms. Mooney, I believe it was, had made some testimony during the site plan hearing. She was listed as a witness for the SEPA appeal, so the appellants didn't cross her during the site plan in anticipation that she would be up on the stand for the SEPA appeal. Now, Ms. Mooney's not going to talk as part of the SEPA appeal, is that correct? Okay, all right. Okay, yeah, Mr. Renati's asked for a chance to cross, so we'll, Ms. Mooney, you going to be here tomorrow? Okay, all right. Good, so that's, I think we have that. Pardon? Okay, we'll make sure to get you then before 12:30 tomorrow then. All right, so we have that handled. Now the exhibits before we move on, and then we'll get back to the testimony. Now, everybody get a list of the master exhibit list sheet that I emailed to everybody last night? Trying to pull that up here.
No, sir.
Okay. I have copies. Here we go.
Mr. Hearing Examiner, I have a copy. If
okay, yeah, I just found mine too. So go ahead and give that to Ms. Welling. I basically I sent an email last night to the SEPA appellants. The appeal parties. If your document's not on the list, it's not going to be the administrative record. So you want to make sure that it's complete. And as I was explaining at the beginning of the hearing, I put in my pre-hearing order and so forth in the core document list because those are documents common to everybody in the SEPA appeal. Everything else I've separated out according to the parties so that I could use their exhibit list that they already submitted. So I've already identified and admitted exhibits 1 through 20. Well, actually, I think we're at 46, 47 now of the core documents. City documents, the only documents I found beyond the exhibit list was their witness and exhibit list and then their hearing brief. Are there any objections to entry of the city's SEPA documents as identified in their exhibit list and those 2 additional documents? Okay, hearing none, then exhibits C1 through C16 are admitted. The appellant's documents are a little more extensive, and of course, taking to the objections that were raised by the parties in their briefings and that I already addressed still stand. Beyond the objections that were already made over the appellant's documents, are there any other objections to what's listed as exhibits A1 through 15? And these are all documents you've all received before in our emails back and forth.
Mr. Examiner, we have some objections. These are the appellant's exhibits?
Yes. Yeah.
Okay.
Yeah.
We object to the admission of Exhibit 5 for lack of foundation, if nothing else. We have no idea who put this together. It's just a table. It appears to be meeting room capacity at Cedarbrook Lodge. So there's no foundation for that. We object to Exhibit 6. This is the email that was discussed during the public hearing on the site plan. This is hearsay, at least on behalf of our client. It's hearsay. It's trying to put words in our client's mouth, and he's, we'll have testimony on that. But it's hearsay, and it should be excluded. It's also not relevant, so it should be excluded.
Was that the email that Ms. Mooney presented, or?
I believe so.
Oh, okay, so it's already in through her testimony.
And we don't know. There's a bunch of handwriting on it and highlighting and arrows all over the place, and no idea who did that. So there's a foundational problem with it as well.
Okay, all right. Well, as to Exhibit 6, I've already admitted it elsewhere on the additional basis of the handwriting and things. I'll just say it's admitted, but all handwritten notations are stricken, since we really don't know what that means, unless I'm certain you don't have a problem with that, do you? Pardon? Okay, all right, so we don't consider that to be part of the record. Could you, Ms. Hurd, explain the 5, the calculation of Cedarbrook Lodge, and were you going to have a witness explain what that was about? Oh, sorry, are you going to be talking about that? Oh, okay, so
we're happy to wait until he talks about it.
Yeah, until he talks about it. We'll delay that on that one. All right, any other objections? Well, there's still the Susan brief. Is Susan Carlson here to? Okay, she's not an expert witness. Yeah.
Mr. Examiner, if you're...
She was not an expert witness as...
Yeah.
Defined by expert witness.
Okay, Mr. Renati.
We were going to... this was going to be one of my motions at the start of our case, but I'm happy to raise it now. We moved to strike that and have it dismissed for lack of jurisdiction. That is an appeal. It's an attempt to present another appeal in the context of this appeal. The file itself is called Susan's Appeal. We have and can present to you, we went through the document, and a number of the issues are literally verbatim what's in the appellant statement, and obviously those can stay because those are already in. But there are a number of issues that are raised in what we're calling Susan's Appeal that are untimely. She should have filed her own appeal on time. She got all the notices. We can, if you look in the appendices to the final EIS, the notice list, her name appears there. So our position is that the hearing examiner does not have jurisdiction over the new issues that are raised in Susan's appeal because that's an untimely appeal. And we move to dismiss it.
Well, as I said wrote in my ruling, essentially she either had to be an expert witness, in which case objections would be waived because no request for her presence was provided, and Ms. Hurd has essentially admitted she's not an expert witness, so that wouldn't apply. So the other basis is she needs to be here for cross-examination, and she's not either. Is she going to be here tomorrow, Ms. Hurd, for cross-examination?
I have not been able to contact her since getting your email. I doubt she'll be here. I did send her the email, but we missed communication last night because I was not at my computer. I was working on other things. And when I emailed her, it was probably too late for her.
Well, that's in an appeal hearing where you have where it's such an adversarial proceeding. The courts have said in Crowbuck versus Snohomish County that all witness testimony has to be subject to cross-examination. So I'm going to strike A14 then. And it really did duplicate, I think, everything else that was already there anyway. Oh, I'm sorry. Is this? I'm going to get this closer then. I am striking A14 then from the record because she's not present for cross-examination on that basis. All right. So, beyond A14 then, any other objections? I think we covered everything else. Hearing none, then exhibits A1 through 14, through 15 with the exclusion of A14 are admitted. And again, it's recognizing there have been objections, and those objections were overruled to some of those documents. All right, finally, or well, not finally, but moving on to the applicant documents. Any objections to any of those that are in there? That's the A1 through 41 and the supplemental one, AS1 through AS41, and then A42 through 50. Okay, hearing no objections, those are admitted.
Mr. Hearing,
oh, sure.
I have no objection, but I just, for clarification in the record as this moves forward, the documents are identified with an A both for appellant and for applicant. Would it be possible for us
did I do that?
to identify the documents with a different letter?
No, good point. I didn't even notice. Yeah, that's what happens when you do this late at night.
We'd
so
be willing
we'll
to
say
go with a D.
the appellants are the, I'll call them the S documents just because of the SEPA appellant. Oh. So that'll be S1 through S15 will be the appellants then. We'll stick with the A. So any objections over A1 through A50 and AS1 through AS41? Okay, hearing none, those are admitted. And finally, state parks documents, which I have as P1 through P7. Any problems with those? Okay, hearing no objections, those are all admitted as well, P1 through P7. All right, now, Ms. Hurt, on to the next witness then.
My next witness is Peter Lance.
Hello, my name is Peter Lance. I live at 6501 Northeast 151st Street in Kenmore. I've been a resident of the Bothell, Kenmore area for 64 years.
And have you been sworn in, Mr. Lance?
Yes, I have.
Okay, great, thanks.
I'm sworn in and done. My brief is in the file, so for expediency, I'm not going to read it all to you again. You've all read it, or if not, you can read it tonight. It's a great non-narcotic sleeping aid. I'm going to help you. I'm going to go to some of the issues that have reared their head. Is this a hotel, a lodge, a conference center? And that seems to be a source of contention here. Great argument about this not being a conference center, but a hotel with meeting rooms. Kenmore KMC Code 18.0.40030 addresses this issue, which is the SEPA official has decided this was a hotel and not a conference center. The Kenmore Code, the logic has preempted that this is used by the SEPA official is that the transportation plan provided by Heffron creates a low usage of or demonstrates a low usage for the parking for the conference center, and that a reasonable solution for, at least to the SEPA official, has been satisfied that we don't have to apply the Kenmore Code. And the Kenmore Code is fairly clear about this issue and kind of anticipates it. In the code 18.040.3.030, I'm not just going to call it the Kenmore Code from now on. Pardon you all have it. It's in my table on the second page. When it comes to the conference center discussion, they have hotel discussed earlier, but then when the question of conference center comes up in the Kenmore Code, the verbiage is 1 per 3 fixed. This is a number of parking stalls, which is a key critical issue in this. 1 per 3 fixed seats plus 1 per 50 square feet used for assembly. And whether it's a meeting room, a conference center, however you want to mark it and label this, this is under the conference center. The implication is that if it's used for assembly, you have a parking stall required for every 50 square feet, and their word is for assembly purposes, right here out of the Kenmore Code. I would point out that Daniels has marketed this property as a conference center. It's on his web page. It's our Exhibit 1. It's probably I'm not sure which, now that all my numbers are fouled up, but it's on his webpage, and it's the 9th line, but I'm going to read the paragraph to you from his webpage. And he's talking about this project. At St. Edward Park, we will repurpose the badly deteriorated interior of the seminary building into a park lodge with 80 to 100 guest rooms, a conference center, meeting rooms, a wellness spa, and it goes on. The discussion seems to be that there is a conference center flavor to this project. It's got meeting rooms for assembly purposes, and the Kenmore Code 18.040, the Kenmore Code would be the applicable code that should be the measure of the day in this situation. The Heffron report indicates that there's 16,600 square feet of conference space at the time they did the study. That comes up to about 333 or 332 parking spaces required to satisfy Kenmore's code. That would be required for this hotel. There's no other exceptions or exemptions of this that I'm aware of. I believe the SEPA official exceeded his authority when he chose to define this property or this project as a hotel, not a conference center. This code seems to anticipate if it's a small meeting room, small conference center, big hotel, you count the bedrooms. If it's a big conference center, a lot of meeting areas, you count the square feet and you take the higher of the two. It seems pretty darn clear to me how this comes together. The citizens' concern really with the parking and traffic is the fear that the park user is going to be pushed out, the traditional park user is going to be pushed out of this park when the lodge and conference center are running at full bore. The Heffron study, I've already written this in the study, so I'm going to be very quick, takes a snapshot in time, appears to project it, and the snapshot in time was January 2013. I'm going to presume that that is a slow season for conferences. I'm not an expert on conferences, but most things have a seasonal function to them. The conference center appeared to be running at about 18% of its full capacity. If you look at the exhibit that I presented here, which is the Cedarbrook Lodge floor plan, which is about the same size as the one proposed for Cedarbrook. They could have over 1,000 visitors in the park. Heffron suggests in their Table 5, in their report, that for every conference visitor, you have 0.9 cars that need parking. This is a proxy, which is the same proxy that Heffron used for another parking analysis, and this is the flat-out, full-bore, everything's running at full speed, but you're looking at 800, 900 cars to be parked if Daniels gets things going using this proxy, which would be expanding Cedarbrook. The other thing, we can throw that away because I'm not an expert on lodges and so on, but we can take Daniel's own numbers and what is in the EIS, part of your Exhibit 5, on pages 42 and 43 of the EIS, the seminary building, the proponent proposes to rehabilitate the seminary building for use as a lodge. It goes on to say that he would anticipate 550 people visiting the conference on a busy day and have 240 people in the restaurant at full capacity. That's 790 people using that Table 5 multiplier of 0.9, which is probably not quite accurate for the restaurant part, but probably very acceptable for the conference attendees. You still have many hundreds of cars to park.
Could you just restate for the record what page you were citing of which document?
Oh, it's my brief.
Thank you.
And it quotes the EIS. I'm sorry. Pages 42 and 43 on the FEI FEIS. So I pulled it right into the brief for you.
I see. So that's the, let's see, 1, 2, 3. That's the 5th page of your Exhibit 5.
Of mine, yes, my Exhibit 5. So what we have, and I'm guessing for restaurant use, you probably have people coming in pairs to restaurants. So, and I'm not a traffic expert, but I can certainly add numbers together, do basic math. My background in college, 1974 graduate economics degree with an emphasis on statistics, and a graduate degree from the University of Denver, market research, real estate and construction management. So absorption studies and so on are not foreign to me. And I still have a rough outline of the loose figures here. We have a lot of cars that can be showing up here in the park that Daniels is going to need to park. There's not likely to be enough room at Bastyr. There's no evidence that Bastyr can accommodate these cars, and Daniels is not told us where off-site he is, or the applicant, where these cars would be parked. And worse is the problem of hotel users using the public parking, which has been a sacred trust of the whole process. There'll be no loss of public parking. The SEPA official acknowledged in his response to his letter to Phyllis Finley that, and it's in my report here, and I apologize. You guys can read it at your leisure, and I'll let you get going here. He acknowledges that they cannot stop or prevent people who are visiting the hotel from using the public parking. And he puts forth a number of things to discourage that behavior, but yet it can happen, it will happen, it's just going to happen. People are going to find it inconvenient to use the shuttle, people are going to have a Discover Pass, and in the instance when they want to use the hotel, sometimes they're just going to use their Discover Pass and not go through the inconvenience of using the alternatives offered by Daniels. This was not studied. It was acknowledged but not studied in this body of work. And so I think these are the critical issues. There'll be too many cars. We don't have a parking plan for them, a shuttle to a non-existent parking lot. The Cedar Brook, which was used as the template, as the report acknowledges, it's down by the airport. Our exhibit shows a Google shot of the area. There's a parking lot within 2,000 feet that people could walk to or could be valeted from. Cedar Brook doesn't have the concerns of trying to compete with the public parking lot. But I'm very concerned that the public user is going to be displaced on busy days. This will not be a 100% all the time situation, not by a long shot, but it is going to happen. And the continuum from the very low threshold used in the Heffron report, where the conference center is running at 18%, to my admittedly full usage scenarios, neither one are probably very likely, and the truth is somewhere most of the time in the middle. I don't see how from the Heffron report we have, looking at this information, a good idea of how many people are going to use this park or the lodge and the conference center every day. It seems to be very poorly measured. The snapshot that was used to compress, again, goes back to January of 2013. When the representative from Heffron comes up, I would like to ask a question, and the question will be, if the Cedar Brook Park had been very busy at the time you took that snapshot, for whatever reason, would the numbers be different for your projections? Instead of operating at 18%, had the Cedar Brook Lodge been running at 85%, which I'm guessing is probably a more normal usage or 75%, how would the projections look if you use the exact same math and metrics? I'm very bothered by that snapshot being used to project forward. And we could talk about the problems of this study also. I've touched on it. Seasonality, at least the snapshot was taken in January. It wasn't retrospective throughout the year, and it was not brought current with what were the conference center attendance issues, or what was the activity at Cedar Brook in all of these years from 2013 to the time this was published. We just had this one 9-day period in January to reference and go forward. And that essentially sums up my 3 points. The SEPA official acknowledged that we can't keep lodge users from using the public parking. The metric used for setting the parking standard is spelled out in 18.40.030, and it does address the problems between square footage and beds, and I don't believe the SEPA official has that authority to redefine the Kenmore Code. That may be something that City Council can do, but I don't believe that is, I think that exceeds the SEPA official. Let's see. The market study. Oh, parking. Where are you going to put the cars? Where up there on that hill? I don't know. Mr. Hearing Examiner, you've had a chance to visit the park, but there is not an abundance of parking near that area from which Daniels has been able to demonstrate he can actually run the shuttles to and from and have people happily using those instead of paying to use the public parking.
Okay. Thank you, sir. All right. Ms. Hurt, did you have any questions?
Peter, when you were looking at all this, did you look at how many cars might be coming into the park? Like, what are the, we have park users coming every day. We know there's low times, there's high times. Obviously, December and January are going to be the lower times of the year. I don't know whether you saw calculations that I did from information I have. And so is one of your concerns also the seasonality of the park users who come to the park?
Of course. The park is very quiet in the winter, December, January, especially on rainy, cloudy days, and quite busy in the late spring and early summer and fall.
Yeah. So I can share this with you. We can submit it as an exhibit if you want. Those are the number of visits. These are the number of cars at various days, and this is the average per day, per year.
Okay. Oh, this is an attendance by month, and it varies from a low of about 28,000 cars per day in month 1 to 73,000. Not unsurprising, a seasonal difference, 73,000 in July.
Yeah, of people, because of the July is a high season.
I apologize again for objecting and interrupting, but could you please identify the document that you are looking at and referring to?
It's an email from Ms. Hurst that I don't know where you got this.
It's information I received from State Parks on how many people attend the park.
Evidently, it's a state park 2016 attendance by month. It's not surprising information.
Could you identify which exhibit that is?
We haven't presented it as an exhibit. I just had it laying here and thought he didn't address anything in it, so I gave it to him. We can make it an exhibit. That is not a problem.
Well, it is because it's supposed to be in the exhibit list.
Okay.
So
it's not something that was submitted as an exhibit.
All right.
It was my calculations, and I did send it, but it does give information about how many people visit the park and the number of cars. But at the time that we had to have exhibits in, I didn't have the information.
Okay. I hope we don't have to argue the concept that things have seasons and there's an ebb and a flow throughout the year.
Yeah, makes sense.
That should be something. Can't tell you the exact ebbs and flows, but there are ebbs and flows, and they're not accounted for in the Heffron report that I could see.
Okay, all right. Any other questions, Ms. Hurt?
I just, in studying, and you say you're not an expert, but you can look at the math. And, but in studying this and studying the Heffron, and you've done a lot of work on looking at this, and the differences between Cedar Brook and St. Edwards, could you elaborate on that a little?
Well, one of the reasons Cedar Brook was chosen was because it was just about the same size as the proposed Daniels proposal. Daniels proposal is 97% by my calculation of the size of the Cedar Brook at the time that they did their analysis, and what I analyzed was the conference space or meeting room space as you would have it.
So, okay. And do you think they're comparable, or could you take
No, I don't think they're very comparable properties, but the capacities of the meeting room spaces are probably fairly similar. There are market differences between what goes on down by SeaTac and the kind of visitor you get that may even fly in and fly out for a conference in one day versus a conference or meeting center up here at St. Edward, where you're probably going, and I'm speculating, there's no market research accompanying this, which is just a deficiency. Who's going to come and attend the conferences here? Are there going to be high-tech people from the east side having a visit, coming in, some division of some tech company having a group, or vendors coming in and having a conference? And are they going to start at 8 in the morning, have a breakfast, tie up all the public parking for the day, and leave at 5 o'clock after they've had their conference? This is just not addressed for this property, and it's quite different than SeaTac. Geographically, the clientele should be examined. I'm going to suggest they're going to be different. That you're not going to have the same people, and the SEPA official should have anticipated or asked this question. Not that he's going to get a different answer, but I think he would, and he should have investigated and analyzed the differences in the two markets. They're not the same, or not likely the same. They just don't look the same. The access to public parking is abundant down by SeaTac. People could walk from the SeaTac lots. They have a shuttle that could be coming and going full both ways, totally fouling the numbers and the counts up for an application here. Certainly there's some information, some seeds that can be gleaned from the Cedar Brook model. I mean, it's a conference space. You can tell how many people could be seated in those spaces as a proxy for what the potentials, high and low, are for the St. Edward property. But it requires more depth, more thinking, more analysis. And where are the people going to go? Where are you going to park their cars if Daniels even meets his goals, which aren't as big as extrapolating the Cedar Brook? But there's a lot of people that could be coming to use that property if you just take Daniels, or the numbers presented in the FEIS. And they're not addressed anywhere.
Okay. Ms. Hurt, you're done?
I think so.
Okay. All right. The applicants.
Good afternoon, Mr. Lance. Again, my name is Amit Ranade. I represent Daniels Real Estate. I thought I heard you say in your testimony that you're not a traffic expert.
True.
Okay, so then I'll dispense with that line of questioning, and we'll accept that you were not offering expert testimony. Have you done any independent study with respect to traffic flows around the park?
No.
Okay. I'm going to walk through your brief, and I've got some questions. I think I've organized, I followed along with what you were saying, and I think I've got the sort of high-level topics, and I want to talk about a few of them. You start with what I think is a disagreement with the land use code designation. I understand your testimony to be that you think this is a conference center, or should be treated as a conference center under the Kenmore Municipal Code, and you object that it's being treated as a hotel. Am I understanding you correctly?
I think the code should be looked at, and there's a section under there that says conference center, which also anticipates a conference center with lodging.
You're talking about the code?
Yes.
Okay. And you're referring to this is Kenmore Municipal Code section 18.2560?
No, 18.40.030.
Okay. Well, before we get into the code, I've got a preliminary sort of factual question for you. Or a couple of questions. In your testimony, you read off a sentence, maybe it was two, out of the Daniels website talking about this project.
Correct.
Other than that, do you have any other information regarding the nature of or the planned way in which this facility will be used?
I have offered no exhibits, though I suspect...
Well, it's a yes or no question. Do you have any other information besides what you read on the website? Have you talked to anybody at Daniels about how they plan to actually use the facility?
I've never spoken to anybody from Daniels.
Do you have any knowledge that people staying in the hotel will not be allowed to stay there unless they are a conference goer? In other words, the rooms that are being created are only available if you're renting the conference facility.
I have no understanding of that at all.
Okay. Now I'll take your attention to, and I'm going to read it to you because I don't think you have the code in front of you. Section 18.2560 of the Kenmore Municipal Code is the definition of conference center. And it reads, in quotes, it says, conference center, end quote, means an establishment developed primarily as a meeting facility, including only facilities for recreation, overnight lodging, and related activities provided for conference participants. So is it your testimony then that you don't have any knowledge that the meeting space here is provided only, or the rooms are provided only to people who are using the meeting space? You don't know one way or the other, do you?
I do not.
Okay. Is it your view that a development that might have several components to it, like this one, it's got a restaurant, it's got some meeting rooms, it's got lodging rooms, that those components need to be analyzed for parking on a piecemeal basis so that you look at the restaurant independent of the conference facilities, independent of the rooms?
No.
Okay, so you agree that the entire project should be viewed as a single project?
There's going to be overlap, yes.
Okay. Do you have any knowledge as to how many square feet are allocated to conference and meeting rooms?
I do. It's on the Heffron report, 16,600 square feet.
Okay, and do you know how many square feet are allocated to hotel rooms?
I don't.
Okay. I want to make sure I understand. What I understood the next two topics in your brief to be, they're sort of related, and they deal with the parking mitigation that's suggested in the EIS. And I want to make sure I understand what you're saying. Bottom of page 2, you write, the responsible SEPA official erred in not analyzing and collecting additional information for parking solutions than just that offered by Heffron. So are you suggesting that the SEPA official should have gone to somebody else to get more ideas on parking mitigation?
I'm suggesting he should have thought about it, used his head. He's an intelligent man. He is employed to analyze and investigate. And in this, I think he needed to analyze and investigate in more depth and detail, as I've outlined earlier.
Are you familiar with the mitigation that's being proposed for, or recommended for parking?
I'm very much aware.
Okay. And I don't necessarily, if you need to flip to it, it's page 3.12-14 of the draft EIS, and that's Exhibit 19 of the core documents.
I probably have it memorized.
Well, my question is this: if you can answer it without looking, that's fine. Do you have other ideas for mitigation that you feel were excluded from the discussion?
I didn't come here today with solutions. I'll be perfectly honest with you. This is a hard, to my mind, a very hard problem to figure out.
Okay.
If the lodge.
Okay, well, that's all I needed to know. The next sort of parking mitigation topic, as I understand it, is that you say, and I'm quoting now, this is, it looks like the first full sentence on page 3 of your brief, the SEPA responsible official failed to require more data or analyze and investigate the applicant's proposal to successfully use nearby parking lots. I want to make sure I understand what you're saying. Are you saying that the SEPA responsible official should have analyzed the technical feasibility or the economic practicability of off-site parking?
I think he needed to see if Daniels could do it.
Okay.
I could tell you I'm going to park cars on the moon, and it shouldn't fly.
Okay, so let me ask the question again. Are you saying that the SEPA responsible official should have studied the technical feasibility and the economic practicability of this recommended mitigation?
I think you should have sent it back to the applicant and asked for more information.
Okay, on those subjects or?
On those subjects.
Okay. The next thing I think you talk about, you have some complaints about Heffron's use of data from the Cedar Brook Lodge. If Heffron, well, are you familiar, first of all, with the Institute for Transportation Engineers? Have you heard of them?
Well, from the study, from reading this report.
Okay. Do you have any reason to believe that the data and the tables that have been prepared by, I'm going to call it the ITE, do you have any reason to believe that that information is not the industry standard in terms of analyzing traffic and parking?
I believe the ITE is an industry standard, yes.
Okay. If Heffron had not used the Cedar Brook data at all, they just hadn't mentioned Cedar Brook in this analysis at all, would you still have a problem with the data that was used to analyze this parking and traffic?
Well, absolutely. As I indicated, there are too many arrows pointing towards a problem. And when I looked at the information provided by Daniels and how many people he thinks he will have in the building.
I'm not talking about building capacity yet. We'll get to that. I'm talking about traffic and parking. You spent quite a bit of time saying that complaining about the Cedar Brook data and the reliability of that data. And so my question is, if Heffron hadn't used that data at all, they had just relied on the ITE data, would it still be your position that the ITE data is unreliable and should not be used?
I'd have to see how the responsible SEPA official interpreted just that data if it had been presented. That's an abstraction that's not here, and I don't have a context to work with that. I don't know how the SEPA official would have worked the ITE data and the conclusions he would have drawn from just that table.
But you agree that the ITE standards are the industry standard. You said that earlier. Or are you going to change your testimony now?
No, I'm not changing my testimony. As so many things are, they're subject to interpretation, and the interpretations used by the SEPA official are, I find, bothersome.
So let's talk about this full capacity scenario that you started talking about it at the bottom of page 4 of your brief. I have a few questions about that. First, I think you testified earlier and admitted that this is an unlikely scenario. I thought you said this is not likely to happen.
Well, I don't know. There's no retrospective study anywhere offered going back and asking at Cedar Brook, how often are you running at full capacity? That question, for the last 3.5 years or 4 years, wherever we're at now, does anybody know? How often they run at full capacity? I can't tell you.
So you have no knowledge one way or the other as to how often or
Absolutely
how rare it is to have the kind of full capacity scenario you're talking about?
No, I don't know.
Okay. The tables and the information that you've presented in your brief, and I'm looking at the top of page 5, number 8 in particular, where you say it, the Cedar Brook floor plan capacity suggests over 1,000 visitors. Where did that 1,000 come from?
It is our exhibit.
Is that this exhibit 5, this table?
No, you can get there two or three different ways. It is exhibit 5. It summarizes it for you. Okay. And exhibit 2 is their floor plan. So
Okay.
This is basic math again. I went through their floor plan, and it told you how big the rooms are, and I just used it as a proxy, and how many people could be in these rooms.
And that's how you got the 1,000?
Pardon me?
That's how you added up all the room capacities and...
Right here in the table,
Right.
exhibit 5. Yeah.
Right. Okay. So for purposes of telling us that there could be 1,000 people at the lodge, it's your position that Cedar Brook is comparable to the lodge. But for purposes of talking about traffic and parking impacts, it's your position that Cedar Brook is not reliable data and it's not comparable. Is that what we're to understand?
I'm saying physically they're very much the same. Physically, the two buildings are similar. Their locations are different.
So Cedar Brook's comparable when it helps you, but Cedar Brook isn't comparable when it doesn't help you. Got it. Okay. Let's talk about, let's keep talking about this full capacity scenario for a second. I'm going to ask you to take a look at page 3.12-11 of the draft EIS. That's exhibit 9. It's tab 19 of the core documents, exhibit 19. It's probably the document that's open. Your right hand's probably in the middle of it. Yeah. So page 3.12-11. Now, you've expressed quite a bit of concern about the number of people that might attend a conference or the number of people that might be staying overnight and at a conference. And it could be a very busy place, the lodge. I think that's been, generally speaking, your testimony. Okay. I'd like to read you a passage out of the page that I asked you to flip to. And it's at the very bottom of this page 3.12-11. If occasional events are expected to exceed parking demand, this could be accommodated through, it says though use, I think they meant to say through use, of valet parking to stack vehicles more tightly into the existing spaces. Alternatively, the lodge could develop an agreement with Bastyr University to lease its excess parking supply during evenings and or weekends when the university's parking demand is lower. Since parking at Bastyr is located more than a half mile from the project site, a shuttle between auxiliary parking and the lodge may need to be utilized for more formal events. Is it your position that that sentence or those sentences don't acknowledge that it's possible that there's going to be an event that fills up all the parking spots and the lodge is going to have to do something to deal with the overflow? Are you saying it's not addressed by those sentences?
Bastyr University's parking is often constrained and filled to capacity. They're not always going to be a 100% go-to opportunity for the lodge operator. I think they're going to come up woefully short far too often.
But do you agree or disagree that the lodge needs to do something to take care of parking off-site if there's an overcapacity event?
They have to solve the problem, yes.
Okay. And would parking at Bastyr, for example, getting into an agreement with Bastyr and having a shuttle service, would that be a solution, or is that not a solution?
It's not a practical solution because I don't think Bastyr can provide the service
Okay, so again, your quibble isn't with the solution itself, it's with the practicability of the solution. I want to understand what your concern is.
I'm going to go back to my example. If I said I'm going to park cars on the moon,
right,
and I can't argue about the quibble about the practicality of parking cars on the moon. And if Bastier's parking lot is full,
right,
which it is most of the time, it's not a solution. It's a dream. And that's my concern. It should have been investigated.
So you think this is not a realistic solution? You don't think it's practical?
I do not think it's a realistic solution.
Okay. You mentioned the. I want to turn to your discussion about no net loss of parking spaces. You have that in your brief as well.
Yes.
And you referenced a comment letter by Phyllis Finley and the SEPA responsible officials' response to that comment letter. Do you remember that testimony?
Yes, I do.
Okay. Do you, and the official said, I don't want to speak out of turn here, so let me see if I can. I'm going to take your brief at its word. I think you quoted it correctly. So I'm reading out of your brief. The response to Ms. Finley was, "It is acknowledged that the proposed lodge would not be able to prohibit guests from parking in the St. Edward's State Park public parking spaces if they should choose to pay." Did I read that correctly?
Well, yeah, and that's quoted from the SEPA official.
Okay. Did you read the rest of the response to Ms. Finley, the sentences that immediately followed that?
I have it right here. What in particular?
Well, why don't we start with the very next sentence?
No, I don't have it right here in front of me. I'm sorry. I've got it over here.
I can tell you it's page 335.
I've got it.
Oh, you've got it. Okay. So why don't I it sort of starts right in the middle of the paragraph to after number 14. The quote that you put in your brief appears, except that it doesn't end with a period, it ends with a comma, right? Do you see that? And it goes on to say, but the following elements would provide a cost and convenience incentive for guests to use parking provided by the lodge and a disincentive for guests to use parking provided for the park. And then there's a number of bullet points that follow that lay out all the incentives that will be in place to encourage lodge guests to use lodge parking. Did you read that when you wrote this?
Read it many times.
Okay.
Yes.
And generally speaking, do you agree with what the SEPA responsible official wrote here? That yeah, it's true. Daniels can't stop members of the public, even if they're coming to the lodge, from using public parking. Do you agree with what was written here, even the portion that you quoted?
Well, I agree with these comments.
Okay, thank you. Do you know how many parking spots are available in the park right now?
Yes.
How many?
220.
Okay. And do you know how many parking spots will be available to the public after this project is completed?
220.
Okay. Thank you. The last comment that you raise in your brief is a general comment, and I think this is maybe not verbatim, but very close to issue number 12 in the appellant's issue statement. A comment about not placing findings in context. This is page 7 of your brief. You say the SEPA responsible official did not place the findings in context, and then you go on to list a number of categories.
Mm-hmm.
Would you please flip in the draft EIS, this is tab 19, to page 3.12.1. 3.5 or -5. So 3.12-5. You there? Okay, so at the very bottom section there, do you see where it says year 2020, no action traffic volumes? Do you see that? I'm going to read the second sentence in that section. The 2020 background traffic conditions reflect cumulative increases in traffic volume resulting from growth in regional development, growth of the Bastyr University campus population, and additional traffic that would be generated by a ball field improvement project at St. Edward State Park that the city has proposed.
I'm going to concede this paragraph to you.
Thank you. I have nothing further.
Okay. Ms. Welling?
Mr. Hearing Examiner, I just have two questions which I hope are a relatively minor point of clarification for Mr. Lance. Given the time, I'd like to state State Parks has no objection to staying a few minutes after 5 if that makes sure that Mr. Lance doesn't need to return tomorrow.
Okay. Anyone have a problem with that? All right, let's get it done.
So, Mr. Lance, in your appeals statement, page 5, I asked you about this, and so I'm asking the same clarifying question as I asked in the midst of your testimony, and I will apologize on behalf of all lawyers everywhere. We are a little bit precise and meticulous about citations to the record, particularly because as cases proceed, it can be very difficult to find those again later because we no longer have access to the live witness. And so on page 5 of your appeals statement, both in paragraph 10 and then in the large quote at the bottom that has the italicized language, you point to pages 42 and 43 of the FEIS, and I am unable to find those pages or the citations, and so I will help you. The core document number 11 is the FEIS, and it begins, so the pages are numbered with an introductory number. So, for example, section 3 has a 3 point something to make a page number. I can't find a 3-42, 43 or a 2-42, 43 in either the DEIS or the FEIS that contains this quote.
And I understand your problem because I was using the PDF file, the Adobe, and I was using those pages when I referenced numbers to look at it online. I'm not sure I can do it without a computer.
And Ms. Welling, you're talking about paragraphs 5 and 10 of the appeal statement?
On page 5 of Mr. Lance's appeal statement, paragraph 10, he cites pages 42 and 43 of the FEIS.
Does anybody have a laptop?
Oh, I see. Okay.
Could you open up the City of Kenmore's webpage with the full EIS?
Would it help to look at the hard copy at all, or?
Page 42, 43.
It's the PDF page.
Yeah.
I know what he's done. Let me see if I can find the answer to this question.
I hope it's not the DEIS, but it's...
Yeah, I've got it right here, I think. Let's see. Yeah, it's...
Mr. Lance, we believe it's a page of a witness list. Is that correct?
I think I have found the language. And you're welcome to come look over my shoulder. I think it's pages 2.8 and 2.9 of the FEIS, starting there and there.
Okay.
Is that what you're talking about?
Okay.
You found it. It sure looks like it.
2.8.
Yeah.
So the witness is saying it's 2.8 and 2.9.
Okay.
That's all I wanted to know. Thank you very much.
Oh, you're welcome.
Nothing else, Ms. Welling?
No, sir.
Okay. All right. Mr. Casagula?
Mr. Lance, I'm going to start with the definition of conference center, which you were asked to read, but to summarize again, the main part of that definition in Code 1820-560 is that a conference center means an establishment designed primarily as a meeting facility. Do you agree with that definition?
I can accept that.
Did I say that correctly from the code?
Well, primarily.
Would you agree with me the key word is primarily?
The biggest function, biggest draw to this facility up there is going to be the conference center.
Okay, so you have to help me understand why you say that this project is primarily a meeting facility. So I would ask you to look with me at a portion of the DEIS, Draft Environmental Impact Statement, which is, I think, right in front of you. And I'm looking at figures 2.5 through 2.9, which would be approximately at page 215 of the EIS, so it would be right in the beginning. And these are diagrams of each floor. Tab 2.1. Well, a lot of the witnesses have been looking at the EIS. I'm assuming that it's right there. What core document?
Yeah, core document.
Core document. Oh, gosh.
Yeah, the DEIS is 19.
DEIS is that 19?
Yeah.
Approximately page 214. It'd be in section 2.1, which is a series of figures. And I'm referring to, again, figures 2.5 through 2.9. Do you see those? They are diagrams of each floor. So if you start at figure 2-9, would you agree that that shows on the fourth floor only lodging or hotel rooms? 2-9. So we're starting at the top of the building and working down. And would you agree that figure 2-9 is a depiction of the fourth floor, and it contains only lodging rooms? Yes. And then turning to figure 2-8, which is the third floor, would you agree with me that that also shows only lodging or hotel rooms? And then on figure 2-7, the second floor, would you agree with me that almost the entire second floor is hotel rooms?
Oh, there's 6,000 square feet, it looks like, of meeting rooms.
Okay, so you have the gray area, which is meeting rooms.
Looking at this, we got 2,800. We have more conference space than we have hotel room on this floor.
Okay.
By doing the quick math, I don't know what the calculator is. Adding it up real quick and looking at 3,200, 1,800 is that's 5,000 square feet, and we have 1,300 and 2,800 for hotel rooms, like 790 plus 737.
Okay.
They're about the same.
So, and then you're looking at the first and second floors, we see meeting rooms. Is that correct? Okay, so given those diagrams, would you please explain to us the reasoning why you're calling this primarily a meeting facility and not something else, like a hotel? What is the basis for that?
Mr. Lance, when you answer, can you please direct to the microphone?
I mean, I haven't done this sort of square footage breakdown, but looking at these charts, they looks like you might have a few more square feet of hotel room, but intensity of usage is going to be a real concern and going to be in the meeting rooms.
Okay, so the basis of your contention then is the intensity of use?
I think that's a strong consideration in your loose definition, yes.
Okay. I just wanted to
Primarily.
understand the basis for your contention that this is primarily a meeting facility, and your answer is it's the intensity of the use. Is that correct? So will you please describe to us what you mean by intensity of use?
Number of visitors, people that can come and go at any given time. When everything's going full bore, all flat out, you can get far more people in the meeting rooms than you can in the hotel rooms. You get 200 people in the hotel rooms, and you can have 800 people using the FEIS numbers in the meeting rooms and restaurants.
So your contention then is that you're assuming that we have to do the impact analysis, assuming that every room is occupied, and that the maximum number of people that are mentioned in the various documents are all going to be there. The conference attendees, the employees, and the guests are all going to be there at any one time. Is that your contention?
My contention is that the ITE probably has a standard for operational use of these facilities on a daily basis, and I would refer to that for your basic percentage usage of these. But what is the question? The question is this a lodge or a conference center?
I'd like to understand what your reasoning or premise is as to why you say this is a conference center and not a hotel.
Well, I'm just looking at 18.4030, where the metric is square feet or hotel rooms. It's a real simple metric. And so when I look at and I'm not, you can call it anything you want to. My concern is applying the code correctly, and the code spells out real clearly what is a square footage when you use the square footage metric, and it spells out very clearly when you use the room metric. And but if you're trying to argue that a meeting room is not a meeting space, and if you can pull that magic off, then it becomes a moot point. But these appear to be meeting spaces, or 18.40
right,
is
but I'm just trying to understand, what your argument is, what your reasonings are. And so I heard you say that it's a conference center because you can apply the calculations in the table that you just referred to under the category of conference center.
That's where this project seems to fall.
Okay. But you also admit that the term conference center is defined, correct?
Of which this seems to fall into that category.
It has to be primarily for meeting facilities. I'm just trying to understand exactly where you stand, because then our people can go from that.
Well, and I would hope, in all honesty, that this doesn't come out to be a legal scrap, but trying to do the right thing for the state park and have a solid parking and traffic solution. And I think I brought up issues here that should make you wonder, what are you going to do with all these cars? And if we you can wordsmith this thing, and you can probably beat me wordsmithing somehow. You can change the language around, and a dog is a cat now, and doggone it, I won't be able to beat that. But this appears to fall in that category, and it appears to be a conference center or a meeting space. Okay. And the hearing, you folks should be concerned what you're going to do with all these cars, and did you count them correctly? Because I just don't see that. Yeah.
And so is it your position that, I thought I heard you say, however, you do admit that the ITE standards are reasonable standards to apply to situations like this?
Well, the way, if they're applied ethically, honestly, and without an agenda. And that's what I would look for is, if you're going to use those standards, use them and use your head. As you apply those standards, think about what's going on here in this park and with the parking problem you're trying to solve. I'm really not afraid of having the hotel up there if you can solve the parking and traffic issues. I don't think you've thought this one through, folks.
Okay. I've just been handed something that is a calculation, and I'm going to ask you if you agree with this. Would you agree that the square footage of the lodging rooms is approximately 150% bigger than the square footage of the meeting room spaces in the lodge as depicted in the figures that you and I were just reviewing?
I haven't done the math. If you tell me it is, I'll take your word for it. I trust you.
Okay. The other thing I wanted to ask was, do you have a suggestion to the city, the SEPA official, as you said, as to what standards, what methodologies, what formulae should have been used here or should be used in this additional study that you talk about?
Would you repeat the question?
What methodology do you suggest should have been used instead of the ICE or the Cedar Brook Lodge comparison?
I'm not in a position to tell you how to run the tests. I'm here to point out serious deficiencies and things that were not investigated and should have been looked at and should have been investigated. These aren't things I made up. I used your numbers, and I noticed a lack of numbers. And that's what really concerns me, is the lack of numbers about the day-to-day, season-to-season, year-over-year usage that you would expect from this lodge up here. And I'm interested to hear how Cedar Brook massages the number from January. I don't quite understand that January snapshot, and the question still will stand. If the conference center was running at 85%, would the projections have looked different?
Following up on what you just said, would you please turn to Appendix H of the EIS that you are looking at? Appendix H is the transportation analysis prepared by Heffron.
Which page?
Appendix H.
Oh, appendix. After 3-3, I guess it's tables.
I know.
The appendices aren't there?
Yeah.
Then I go into the Fair and Piers document immediately thereafter.
Okay. Let's see.
Attachment D, Cedar Brook Lodge, trip generation, service, Heffron.
I am referring to the Heffron analysis. I just want to run through some of the parts of that with you. I guess I'm at a loss as to where all these documents are now that we've changed the numberings, and we call some things core documents and other things.
Appendix H, I'm sorry. I was looking for Appendix H of the Heffron report. Okay.
Oh, I'm sorry. It's Appendix H of the DEIS.
Okay, I'm here.
Okay, so you now have that in your hands, the technical memo? Okay. Could you please turn to page 2?
2?
The first paragraph underneath the figure 1.
Oh, okay. Project description under project.
And so there's a paragraph just before section 2.2 of that report.
You're in the attachment to that report.
I am in the attachment.
Yeah.
Okay. Thank you. I have the consultant helping me. Someone just handed me this and said it was a report. I'm sorry.
2 by 2, traffic volumes.
I apologize. There's so much paper in front of me. This is attachment B to the report. I apologize. I feel like stopping and going home, but
okay.
I'm sorry. It's getting late. We're trying to hurry through this, but okay, we now found it. Thank you. So we're now in, I guess, attachment B, page 2 of the attachment B, right before the section entitled Cedar Brook Lodge Trip Generation Rates. And I'll read these 3 sentences to you and ask you if you agree with them. In terms of what you've been talking to about, the consultant used the wrong time of the year to analyze the Cedar Brook Lodge's occupancy rate and number of visitors. It says Cedar Brook Lodge provided information about these operating parameters for the period when trip data was collected. During the weekday counts, occupancy ranged from 69% to 94% and averaged 79%. Okay. Cedar Brook Lodge provided information about these operating parameters for the period when trip data were collected. During the weekday counts, occupancy ranged from 69% to 94% and averaged 79%. The hotel had active conference and banquet activities with between 100 and 200 guests each day and an average of about 155 guests per day. So does that satisfy your concern about that this may have been a slow time of the year where it's averaging 79%?
That is the hotel occupancy. That is not the conference occupancy.
Okay, so
Conference occupancy is very important. The 79% is, they're referring to hotel rooms.
but then the next sentence says the hotel had active conference and banquet activities with between 100 and 200 guests each day.
Yes, and if you refer to this chart, it shows their capacity of up to 1,000 people could possibly be in their facility. Looking at when they're running full out, they were averaging about 15% conference capacity in that time period.
Oh, thank you. That helps me understand your position.
Yeah, and Mr. Lance, you were pointing to the capacity of the conference facility. What document was that? Where was that from?
It is our Exhibit 2, and that is taken directly from the Cedar Brook website.
Okay,
And
great.
I just
Got it.
went in to look at how they, what their capacities were for their various conference rooms.
Okay, thank you.
Okay, I'll next refer you to, and I hope I have this right, page 14 of the report. Okay. Page 14 of the report, first full paragraph.
Heffron's report?
Of the Heffron report. Hopefully that paragraph says similar to vehicle trip rates.
Yes.
Okay. And in the middle of that paragraph, and I'll quote this and ask you a question about it. The Cedar Brook Lodge data indicated a peak parking rate of 0.74 vehicles per occupied room, which was lower than the ITE rate for a hotel in a suburban location. As described previously, the lower observed rate could be due to the lodge's proximity to SeaTac Airport, which is well served by taxi and shuttle service. Therefore, the higher IT rate was applied to estimate the parking demand generated by overnight guests, reflecting a more suburban parking condition. Do you understand that quote I just read to you to mean that the consultants used the higher IT rate and took into account the factors and elements of the Cedar Brook Lodge situation?
Mr. Lance, just a reminder to speak into the microphone.
I understand that sentence.
So what's your answer to that question, please?
What was the question? I read it. It's a snapshot on a
The fact that
20-page traffic report.
the question is, does the fact that the consultant, Heffron, used the higher IT rate answer your objections to using the Cedar Brook Lodge figures and information.
It doesn't satisfy my objection to the projections of
Thank you. I want a clarification of something I believe you said. I believe you said that the participants in the Cedarbrook Lodge conferences would be walking from SeaTac Airport. Is that a correct statement that you made?
No, they could walk from the public lots nearby. If Cedar Brook was filled up, it's only 2,000 feet from a public lot. You could just see, and there's probably other street parking, but there's a big parking lot 2,000 feet away.
I see. Are you talking about parking right lot? What kind of lot are you talking about?
At Cedar Brook?
No, you're talking about the lot that they walk from and go 2,000 feet to the lodge itself.
To Cedar, it's a more realistic scenario than I've been able to figure for Daniel's proposal to shuttle people. I found a parking lot, you could walk to it. I can't find a parking lot where Daniels is going to put his cars when he's got a big to-do. It's there on the, but your question is, where's the parking lot? Was that your?
No, I was just asking what type of lot are you talking about? You said they walk 2,000 feet to the
Well,
lot
they
itself.
could. I don't know how they get around at Cedar Brook, but people could. It's walking distance if there's no parking at Cedar Brook itself.
Now, the scenario that you are painting for us that the transportation analysis and parking analysis did not take into account was special events, big events where the park is very crowded and there are a lot of attendees to the park events. So my question is, have you actually attended any of these events so that you could personally observe the parking situation and what was being done with the overflow cars?
Not at Cedar Brook. I have been to conferences before, but
I'm sorry, saying over to park.
Well, I've been there many times, and I've been there when they're parking on all over the place. They're parking on the lawn. When they did the summer concerts, you've probably been there. They're parking on the ball fields, or the ball field, the grass ball field.
Have you observed any solutions to that overflow parking, personally?
Well, that is a solution.
What is the solution?
Well, they park on the ball field, and the park ranger puts people, sets the park users, opens additional grass field parking lots.
Okay, thanks.
But that is public parking.
Thank you very much.
Okay. Ms. Hurt, any final redirect?
Yes, I have I don't know. I'm sorry. I don't have the final EIS in front of me. I do not know the page numbers of the floor plans you were looking at. I would like for Mr. Lance to look at the first floor of the seminary building's floor plan.
Ms. Hurt, just for your reference, I believe that binder on the corner of your table contains the documents, and I believe Exhibit 11 is the final EIS.
Although I think the floor plans that Mr. Getzoum was looking at was in the DEIS, figures 2.5 through 2.10.
I have the DEIS here, but I don't think it's in there.
Yeah, those figures 2.5 through 2.9 are the figures that...
I should have written down...
In the very thick DEIS, that's where they're located.
Is it in the DEIS?
Yes, it is.
Okay, let me try to find it here.
Okay.
I haven't found it yet. I find the DEIS floor plan or the numbering here to be quite hard to find, so it's up front. Thank you. Two 6 and 2 7. Thank you. I've got 2 3. Okay, I got it. Peter, it's in the... Okay, so we got the first floor. basement. Did you find it, Peter?
Yes, they did.
Okay. So, similar exercise. Look at the first floor of the seminary building, and how much do you see any hotel rooms?
I do not see any hotel rooms.
And what do you see?
I see a kitchen and conference centers and meeting rooms, or kitchen, dining room, and meeting rooms on the first floor.
Looking at the first floor, just a quick math thing there, how it looks like how many square foot of meeting rooms?
About 5,000 or 6,000 square feet of meeting rooms and about 6,000 feet of meeting rooms and 3,200 square feet of dining room.
Okay, and then look at the other one, which is figure 2.5, and that's the basement.
That appears to be all meeting rooms except for some small 2,000 feet of offices and the mechanical rooms.
And there are no hotel rooms.
No hotel rooms.
And the square footage there?
About 7,400 square feet, 7,500 square feet of meeting rooms, 2,000 feet of offices, which are probably facility support, I'm guessing, and mechanical room.
Okay. So that adds up to a lot more meeting room space than hotel room when you consider the first floor and the basement. Do you agree?
For the first two floors, there are no hotel rooms.
That's what I'm saying. So overall, there is a lot of meeting space here.
Oh, yes, there is.
Okay. So are you, let's see, are you aware, have you looked at the Daniels feasibility study? I do not know what the exhibit number is.
I'm not sure what you're referring to.
Okay. All right. Well, I have. I'm not the one testifying. Okay. The other thing I wanted to ask you, so this indicates there is a lot more meeting space than on the first, the second, the third, and the fourth floor. Most of the meeting space in this building is a proposal is on the first floor and the basement. Do you agree with that?
Yes.
Okay. So do you think that qualifies more as a conference center based on the Kenmore Code you've been looking at?
Well, the dominant, most important rooms of this building are conference center or meeting rooms and restaurant, but mostly meeting rooms in the dominant floors. You enter and you see meeting rooms straight away.
Okay. And in everything you've read, and I know you've done a lot of work on this, and everything you've read, you have never heard that only hotel guests would be attending conferences.
I'm not even sure that's true.
Okay. But that's...
I've never heard that before.
You've never heard that or seen that in anything, in any of the documents that are in our
I have
material.
no understanding that you have to stay there to rent a conference room.
Or to be in a... You have to rent a room. You have to be going to a conference to use a hotel room.
Right. I'm unaware of that requirement.
Okay. And then you have quoted from the Heffron that there's 16,600 square foot of conference room.
It's right in the report.
And do you know how much conference room a 100-room hotel, what is the usual allowance for the conference? Do you have any idea?
I have no idea.
Okay. So, all right. And let's see. When you have gone to the park in the summer, which is, of course, the higher, or even in the spring, the higher uses, what is your observation of the amount of parking that's available?
Sometimes there isn't any. It's the park, people are hovering, waiting for somebody to leave. On some occasions, the park is full now. It's at capacity.
With the 200 spaces are full, and that's what you see.
And people are hovering, looking for a place to park,
Okay,
waiting for somebody to leave.
okay. And you live, you go to the park often?
I do.
Okay, so this is not something that you just saw one time, a snapshot?
I started paying attention last spring as this was going on, and I was concerned that this parking issue is not being well attended, and on most Saturdays and Sundays, nice days, not most, you would often find the parking lot at capacity.
Okay, and was the playground at capacity?
I
you look?
really wasn't looking for the playground. I'm sure there were sometimes I was up there, the park was just full, just
Okay.
flat full of people.
So based on the questions you've been asked and the material you've looked at, do you still believe that this parking study should be based on conference use and not just a 100-room hotel configuration?
Well, I think it should be based on what the true anticipated needs for the hotel and lodge and conference center are going to be. It should be an honest look at these disparate and sometimes overlapping activities, and they should have been measured correctly and throughout the seasons. It probably doesn't matter much if the parking lot is full of hotel users in January, on a rainy January day, though there'd be room to work with Daniels, I think, in the public parking on some situations, but not on the most of the time. When the park is busy, the mantra is there's no loss of public parking.
Okay.
That's been a promise throughout this EIS process.
So you have found that throughout reading in all of the EIS throughout the draft EIS and the final EIS, that it's no loss of existing public parking.
It was the park planner's promise to the park commissioners at the closing hearing right up the hill here at Bastyr. There will be no loss of public parking when the park commission agreed to go forward with the lease.
And
that was the park planner's promise.
so in your calculations, and I know you're not a parking expert, you don't have the expertise that someone that does this all the time, but in your calculations, you certainly have the ability to calculate as a contractor, as an economics major, so your math is there. Do you think the 153 parking places for this lodge is going to meet the need of the lodge? And even if they, I just, because with 16,000 square foot of conference space and only 100 rooms, the feasibility of having only having a conference there if you have a hotel room seems vague to me. I don't know how that feels to you, but do you see that eventually but I guess what I'm asking is, would you think that they will have more conference than 100 people?
That would be my yes, he expects to have 550 people show up for some of the conferences. Those are EIS numbers. Those aren't mine. So that's 550 visitors to the conference in the meeting rooms and 240 to the restaurant. Those are the published numbers. So yes.
Okay. Well.
And that doesn't make sense for a hotel requirement that you have to spend the night and rent the rooms to have a conference. That doesn't add up.
And then you have the square footage that you were asked about on the rooms, on the floors with the guest rooms. And you have, you were I think you were asked to compare square footage of the guest rooms to the meeting room.
Well,
were they comparable? But do you see that as being comparable in the number of people in those rooms, in the number of cars?
I see the conference rooms as being potentially far more significant, especially during the day when parking is at a premium, far more impactful than the hotel.
Okay. So
in the evening, it won't matter. It'll rarely matter if the parking lot is
But what
full
do you consider evening? I'm thinking about summer.
Well, it's going to change throughout the seasons.
Okay. I think that's probably what I have. I think the summary is this has 16,000 square foot of conference space. It's 100 bed, 80 to 100 bed hotel, a room hotel. I didn't mean bed. Sorry, it's getting late in the day. And that the parking is inadequate for the size of the building, and for keeping a promise to the public that there's no net loss of public parking. And that's the summary I did.
Okay, great. One quick item to address. That's the Exhibit 5 issue. Since Mr. Lancey is here, let's deal with that. The applicant had an objection over foundation.
We'll withdraw the objection.
Okay.
It can
all
be
right.
admitted.
But I could not figure out what Exhibit 5 was from the emails I received. And then the Exhibit 5 in the notebook I got from the city on the SEPA appellant exhibits was the appellant's traffic study, or traffic brief, I should say, which is not what I don't think that's what you intended Exhibit 5 to be, right? Is that the Cedar Brook?
Exhibit.
Pardon?
It is part of the traffic. It's just a summary of the space, the rooms for your.
I just want to make sure I have the right exhibit. So that's you've got. Okay, I'll just take that and put it in the official file then. So, all right. With that, we're adjourned until 9:30 a.m. tomorrow morning. We'll see you then.